Legal. I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for Additional Estimates 2025-26. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors, elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. The Senate has referred to the committee the particulars of proposed expenditure for 2025-26 for the portfolios of Home Affairs and the Attorney-General and other related documents. These are additional estimates proceedings, and the outcomes to be heard during today's estimates are from the Attorney-General's portfolio. The committee has set Friday the 20th of February 2026 as the date by which written questions or notice should be received to the Secretariat. The committee has also decided that answers to questions on notice should be returned to the Secretariat by 5 p.m. on Friday the 10th of April 2026. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate has endorsed the following tests of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate on the 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirement of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to public interest that could result from the disclosure of the information or document. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I'll be particularly vigilant in ensuring cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. Officers called upon for the first time to answer a question should state their full name and the position for the Hansard record, and witnesses should speak clearly into the microphones. I remind committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. The committee's proceedings today will begin with the Attorney-General's Department. I now welcome Senator the Honourable Don Farrell, representing the Attorney-General. I also call officers from the Attorney-General's Department in relation to cross-portfolio, corporate and general matters. Minister, would you like to make an opening statement?
Thank you, Chair, for that opportunity, but at this stage I won't have an opening statement.
I think it's a one-off. It's a one-off offer. It's not at this stage.
I'm in control of the show. Thank you, Senator Shoebridge.
I am doing other committee hearings, and there are some of those where I will be making an opening statement. So
we don't get the privilege today. That's what you're saying. Secretary, would you like to make an opening statement?
Good morning. Thank you, Chair. I do have a brief opening statement.
Absolutely.
Thank you. Since the last estimates hearing, the department has played a central role supporting the government's response to the terrorist attack in Bondi on the 14th of December 2025. At the outset, I want to express my deep sympathies to all those impacted by this attack, particularly members of the Jewish Australian community, and to acknowledge the distress and trauma this event continues to cause for families, communities and colleagues. We stand together in rejecting anti-Semitism, hate and violence. These have no place in our society. I also acknowledge last Thursday's announcement by the Western Australian Joint Counter-Terrorism Team that a person has been charged with engaging in a terrorist act on 26 January in Western Australia targeting First Nations people. This act of violence is confronting and upsetting, particularly for First Nations colleagues, communities and those with family, cultural or professional connections to the region, including in our Perth office. Events such as these reinforce the important role of the Attorney General's Department in upholding community safety and national security. I'd like to briefly outline the work we progressed in the immediate aftermath of the Bondi terrorism attack and to acknowledge the contribution of many staff who worked tirelessly to deliver this work. The department led urgent work on a package of legislative reforms which culminated in the passage of the Combating Anti-Semitism, Hate and Extremism Criminal and Migration Laws Act 2026. I would also like to acknowledge that this work was undertaken in close cooperation with our colleagues in the Department of Home Affairs and with the Office of Parliamentary Counsel, which drafted this legislation. We have moved quickly to stand up the Royal Commission on Anti-Semitism and Social Cohesion, announced by the Prime Minister and led by the Honourable Virginia Bell AC, and are fully committed to supporting this work. In parallel, the department has supported the Attorney General in her engagement through the Standing Council of Attorneys General on national efforts to combat hate speech and online harms. This work continues with the E-Safety Commissioner and the Special Envoy to combat anti-Semitism invited to attend the next meeting of Attorneys Generals. I want to acknowledge the professionalism, expertise and commitment of staff who progressed this complex and sensitive work over the summer period under intense time pressure. This reflects the very best of our portfolio and the Australian Public Service. I welcome the committee's questions today and look forward to assisting the committee.
Thank you very much. We'll proceed to questions. Senator Bligh.
Thank you very much, Chair. As part of what the Prime Minister said on the 30th of December last year, in that he has accepted the recommendations of the first ever Special Envoy to combat anti-Semitism here, and that he's implementing her recommendations. As part of that, the Special Envoy, Julian Siegel, recommended in her report in July 2025 that departments complete anti-Semitism training. Can I ask whether your department has started implementing a training program?
Thank you very much for the question, Senator. I will ask my colleague, Ms Dawson, to come to the table to note broadly the work that we do around diversity and inclusion training in the department. I would note that I have had conversation directly with the Special Envoy about anti-Semitism training, and I'm meeting this week with her office to discuss how we can access training that the anti-Semitism envoy herself has recommended. I think I can say that she has collaborated with the Sydney Jewish Museum in relation to some of this training, I intend to talk with her office about how best to engage and use that training.
Senator Bridie Dawson, Chief People and Strategy Officer. Thank you for the question. The department does maintain a zero tolerance approach to racism and discrimination and any form of anti-Semitism. A range of mechanisms supporting safe reporting, cultural inclusion and respectful behaviour is enacted across the department. We have a number of report and support mechanisms which I can go into. We also have a cold action plan that I can go into, but I think your question goes to specific training. The department already has a robust anti-racism training, a module that staff can access. We also have a cultural e-learning course which covers cross-cultural communication and cultural diversity, cultural differences and similarities and cultural adaptation. As of the end of December, we also have Indigenous cultural awareness training to complement that. As of December 2025, we had 46 staff have completed the anti-racism training, and we'll complement that, as the Secretary mentioned, with further resources available to our staff.
Can I ask if those modules have anti-Semitism in them as something standalone?
No, it does not specifically go into anti-Semitism.
Okay.
However, we will look at the future anti-Semitism training and our own and keep modifying and reforming it.
How long do you think it will take to get an anti-Semitism module up and running? What's your time frame that you're looking at to do that?
As soon as possible will be our goal.
I think that the first key step is to meet with the Special Envoy's office this week and discuss the training that they want to raise with us and then consider how it can be made available to staff in the department.
Can I ask, given the recommendations were made in July 2025, why has it taken so long to get a module up and running if it's something that you want to put in as soon as possible?
I think what I would say, Senator, is there is, in terms of anti-Semitism training, I think it's really important to ensure that the training is developed and provided by an appropriate organisation and working with the anti-Semitism envoy to not working with, but the anti-Semitism envoy herself has been doing work in that space to ensure that appropriate training has been provided. So I think it's fair to say that at the beginning of last year there was no off-the-shelf product, so to speak, that we could draw upon, but I think the work that she has been leading has ensured that there's some training that is available that is potentially applicable to use in our department, and that's the conversation we're going to be having this week.
So you've mentioned that you liaise with the Special Envoy and her office. Are you also working with the Race Discrimination Commissioner?
We work closely with the Race Discrimination Commissioner, as we do with all the commissioners in the Australian Human Rights Commission on a range of matters. And as Ms Dawson has already referred, we do have anti-racism training already in place in the department.
Does the Race Discrimination Commissioner engage or teach any of the modules that you already deliver?
Not that I'm aware of.
Are there any plans?
No specific plans yet, Senator, but I might just add to my statement that the department will also work closely with the APS Commission. They are looking at some specific anti-Semitism modules, and I've been advised that they are hoping to roll them out in March, so that will be further resources that will be available to the department through their APS Learn platform.
Excellent. And who in the department will be responsible for coordinating and delivering the new anti-Semitism program?
That would be myself.
That's
and
you?
Ms Henson, who also
Okay.
looks after human resources.
Fantastic. Thank you. Did you have any questions? You're good.
No, not in If I could just, with indulgence, Chair, if I can just thank members of your department, Secretary, for the fantastic effort they put in following the Bondi massacre in terms of preparing that legislation. I was incredibly impressed by Ms Chichi, who's there, I think.
She is.
And there she is. Yeah, Ms Chichi, hello. And her team. It was just a really, it was an enormous effort. So I just wanted to put that on the record.
Very grateful. Thank you,
Thank
Senator.
you, Senator Scarr. Senator Shoebridge.
Thanks, Chair. I'm assuming questions about much of that package will be later on in integrity and security.
That's correct, Senator.
Yep. I just wanted to check questions about the implementation of the National Firearms Registry. Is that cross-portfolio?
Well, that's largely, well, in fact, entirely the Department of Home Affairs now.
Yeah, well, it largely, wholly, it was under the AGs.
Yes, yeah, it transferred back to the Department of Home Affairs.
When did it transfer?
When the machinery of government changes happened in June. Sorry, I'm just seeking guidance from my colleagues who will give me a definitive answer any moment, but in 2025.
All right. With following the election?
Correct.
All right. Advice on the ICJ climate advisory opinion?
So that will be in International and Security Group.
International and Security. Communications from the Attorney General to the NAC Commissioner?
That will be, again, in the International and Security Group.
In the International?
And Security Group.
Oh, okay. You probably wish it was international, but he's onshore, unfortunately. Questions about your FOI performance?
That is appropriate in this section in cross-portfolio.
All right, lovely. What's the average turnaround time for an FOI application?
I'll ask relevant officers to come to the table to assist with those questions.
Mr. Eagle, almost is Dawson, is it? I can't read from here. I can read Eagle, I just can't read the other one.
Oh, sorry, Senator.
Yep, Ms. Dawson. I could ask you a series of questions about metrics, or you could just volunteer the information about what the performance of the department is and the most current figures.
Thank you, Senator. So Kenneth Eagle, Corporate Counsel, Attorney General's Department. So your question was just general stats about performance?
Well, what's the average time for determining FOIs and how does it compare to last time we asked that question? How many FOIs are on foot? What's the longest, stalest FOI? And what the trend is?
Sure. So in 25-26, average processing time for decisions to be finalised is just over 45 days. That's against an average statutory time frame of 47.5 days. So average processing time for finalising is just under the statutory time frame average. In 24-25...
When you say statutory time frame average, are you saying that's including your extensions?
That's correct.
All right.
Yep, 24-25. By comparison, average processing time for finalising decisions was just over 62 days. With an average statutory time frame of 50.5 days. So in 25-26, we're seeing a reduction in average processing time for finalised decisions compared to 24-25.
Okay. It's not sounding like a crisis in need of urgent statutory reform, but we can probably go there later. How many applications have we been dealing with? And what's the trend line? Increasing, decreasing?
25-26, we've had 219 decisions in the first 6 months.
Decisions?
AGD requests finalised 207.
Sorry, you've had 219 applications or 219 decisions?
No, we've had 219 applications.
Okay, and 207 decisions.
Finalised. And I just clarify that decisions finalised is by date finalised. So it's
they could have been for the previous year.
You're ahead of
and that's as of when?
31 December. That's the most recent stats that we provide to the Office of the Information Commissioner.
All right, and 24-25?
24-25 for the total year was 333 applications with 339 finalised. So we are seeing an increased trend.
All right. but a reduced time in which you're processing them.
That's correct, Senator.
Can you explain what you've done to have that improvement?
Okay, I might jump in and just say one thing. We did make some changes into how we managed, and in particular asked Mr Eagle to oversight our work around FOI. I think I have acknowledged that it wasn't where it should be for the department, and Mr Eagle has, with his team and working across the department, I think put in place some improved processes that have enabled us to be able to progress decisions more promptly.
All right. And Mr Eagle, can you, without spending over long on it, give an indication of, having cast your eye over it, what changes you made?
I think, Senator, one of the main things we've been looking at doing is focusing on the process and ensuring that people are engaging with the Act, with the guidelines, with applicants to, as quickly and efficiently and compliantly as possible, progress FOIs through to finalisation. I think, without taking up too much of your time, that would be how I'd summarise the steps we've taken.
And can you now let me know about OAIC reviews? How many were lodged last year? How many have been lodged this year? What the outcomes are?
Sorry, OAC reviews, I may have to take that on notice. I'll just quickly, sorry. At the moment, we have, that's as at 6 February, we have 25 IC reviews on hand.
Yep.
But as far as...
in terms of the number lodged and...
Yeah, sorry, I don't have that data in
win
front
or
of me.
loss rate. Do you have a win or loss rate at the OAIC?
I'm not sure win or loss rate is able to be provided in a basis where a decision from OAIC could be remitted back for decision, for a further decision. It could be that an applicant withdraws. It could be that part of the decision is upheld, other parts are not. So I guess it's difficult to definitively say win or loss.
Well, then maybe I will ask you if you could provide on notice for the 24-25 financial year, data about OAIC reviews dealing with that granularity.
Yep.
And then if you can, data up to date on OAIC reviews, again, dealing with that granularity for this financial year.
I'll do the best we can, Senator.
Yeah. And I'm not going to impose some framework on you, but the way that provides the best insight into what actually happened.
Yes, Senator, we'll take that on notice.
All right. Given everything else is in other matters, they're my questions, yeah.
Thank you, Senator Shoebridge. Hopefully we can keep moving through the program as swiftly as this throughout the day. We'll be in a good position by the time we get to the end of the day. Thank you very much. Before we move on to the next group, I would like to let the Australian Law Reform Commission and the Office of the Commonwealth Ombudsman, the National Student Ombudsman, know that the committee is in a position to release you for today. So thank you very much. All right, we now call officers in relation to the Justice and Communities Group and Closing the Gap outcomes 10, 11 and 15. Senator Scarr.
Thank you. I've got some questions in relation to government-funded legal advice for permanent protection visa applications, appeals, administrative appeals and judicial appeals. So, relevant officers, they will come to the table.
Senator, can I clarify, does it relate to assistance for people appearing before the ART or federal court or both?
Both, and in particular assistance provided to specialist NGOs, etc., that provide that sort of community legal assistance. Okay. Do you have your name thing? Yeah. Thank you. Thanks very much. So just to provide some context in relation to these questions, we have an ever-increasing cohort onshore of people who've exercised their right to apply for a protection visa and are in the process, and they've been refused a protection visa in the first instance by the Department of Home Affairs. They've exercised their rights of appeal, merits review and judicial review, and the number of people onshore having been initially refused a protection visa but still onshore, either going through the appeal process or having exhausted all their rights of appeal and still onshore, which is a matter for Department of Home Affairs. The numbers are increasing every day. So I want to first just ask a general question with respect to what federal government resources are provided in order to assist people who are making merits review applications, the ART, and are also progressing through judicial review to assist them to have legal assistance which may, hopefully, more efficiently deal with their claims.
Thank you, Senator. Esther Bogart, Acting Deputy Secretary's Justice and Communities Group. So, Senator, as I'm sure you're aware, the National Access to Justice Partnership Agreement came into effect on the 1st of July last year. That provided $3.9 billion to a range of legal assistance providers to provide services to people in various forums, including they do provide services to people in the ART and the courts, as well as a range of other advice outside of those systems. There was some initial funding to legal assistance providers in the 2023-24 MAEFO.
Just before we get to that, and we'll get to that. Just in relation to the latest package, can you provide any granularity as to how much of the $3.9 billion will actually be directed towards, or is intended to be directed towards, people who are going through merits review and judicial review in relation to onshore protection claims?
So, Senator, there isn't a specific amount. That $3.9 billion is provided to the 5 different subsectors of the legal assistance sector, including largely legal aid commissions and CLCs are the ones who do provide those services. The funding is provided quite flexibly. It's provided via states and territories through a national partnership. It is a matter for those organisations to determine how they provide services to members of the community. There are a range within the NAJP, National Access to Justice Partnership, of priority client groups, and I can confirm that following consultation in the lead up to the negotiation of that agreement, vulnerable migrants, including asylum seekers and refugees, were added as a priority client group under the NAJP to really emphasise, even though culturally and linguistically diverse people had always been a priority client group, to really specifically indicate that they are a group that legal assistance providers should be prioritising in delivery of services. But in that package, no particular amount is directed to a particular area of law. It is a matter for each of those providers to determine that depending on demand based on the priority client groups and the priority law types in the NAJP.
So, Ms Bogart, how's the federal government then ensure that an appropriate tranche of that funding is going towards those particular cases? Because after all, the ART is a federal government agency, and it has, as Secretary, you're well aware, it has a caseload that has exploded. You're looking to hire additional members, etc. Our federal court system also has an increasing number of immigration matters coming before it. We've received evidence during the last estimates in relation to that issue. People who aren't legally represented perhaps anecdotally, it will take longer to deal with their claims because their cases aren't presented in an orderly way. It takes more time for the judicial officer or the member of the ART to deal with their cases. So how are we meant to measure through this process and other processes that an appropriate tranche of that funding is going towards this cohort?
Senator, there is reporting that providers do provide on the different priority clients. So we do receive some reporting on that basis. We haven't received that reporting yet. It's due shortly.
So just on that point, when is it due, Ms Bogart?
I will have to take that on notice.
Before the next estimates? In May?
Yes.
Before the next budget?
Yes, I believe it's the 31st of March. Yes, 31st of March. There we go. I have a thumbs up from the back.
Oh, that's excellent. Thumbs up. Thank you, thumbs up. Is that going to be made public? Is that going to be made public?
Senator, that reporting isn't made public. It is reporting that's provided by the states and the territories from the legal assistance providers to the Commonwealth as part of their standard reporting under a national agreement. Senator, I'll also add that in the 23-24 MAEFO, the legal assistance sector did receive an additional $48.9 million over 2 years, specifically for the permanent protection visa workload before the ART. So there was some additional funding from this department and a further $12.4 million administered by the Department of Home Affairs to deliver pre-application assistance and community engagement. So there has been additional funding put into the sector in recognition of some of these workloads.
And as I understand it, that funding was due to expire on 30 September last year, is that correct?
Yes, Senator, it has now expired and services are now provided as part of the NAJP.
Okay, and when is the department proposing to report on the outcomes of that funding? So as I understand it, when you provide these tranches of funding, there are reporting, as you referred to in relation to the program, the NAJP program, there are reporting obligations. So have you received reports with respect to the outcomes of that funding? How many people were assisted? What difference did it make in terms of the progression of their cases? Because these are really important issues in terms of the government balancing the cost of providing legal assistance on the one hand, but against that, the efficiency in terms of expeditiously dealing with cases. So what can you tell us? Has any reporting been made public?
Yes, Senator, we have received reporting. It isn't ordinarily made public, the reporting that we receive under agreements like that, but I can take on notice and see what we can provide.
Okay, if you could take that on notice, are there any observations you can give us at this stage? Presumably you've got some insight with respect to the success of the program, what you learned from the program, how those learnings are reflected, hopefully they're reflected in the NAJP?
Well, I think the fact that broadly speaking, that cohort was identified as a priority cohort for the NAJP is a reflection of the demand and the need for those clients. And we're happy to take on notice anything further we can provide you in terms of which providers perhaps were able to provide the highest levels of assistance and a little bit more detail on the nature of that assistance.
But just at a high level, can you tell us how many people were helped?
No, Senator, I don't have that in front of me.
Can you give us a ballpark figure?
I honestly don't. I don't have even a guess. I would.
So you can't tell me if it was 1,000 or 5,000 or 10,000?
Senator, we've agreed to take it on notice and we will.
Okay.
Paul, is this a good time to rotate the call?
Yeah, well, I'll just finish this with points to take on notice.
Yeah, sure.
So look, I must say I'm a little bit surprised that you can't give at least some high level indication with respect to how many people were assisted, at least in ballpark figures. But if you can take on notice and provide as much granularity as you can in relation to the number of people helped, where the funds, who actually got the benefit of the funds in terms of across different state jurisdictions, across what community legal centres or legal aid, etc. That would also be helpful. Any objective data you've got with respect to the positive impact it had with respect to case management, the time to resolve issues, the use of perhaps, because one of the issues that's raised, if someone has the benefit of legal advice, then hopefully they can advise them that if they don't have a substantial case, maybe they can discontinue the proceedings. So I'm very interested in that sort of granularity. So if you could take that on notice, please.
We'll take what we can in the parameters of the reporting requirements and what we received, certainly, Senator.
Okay, thank you.
Thank you, Senator Scarr. Senator Polley.
Thank you, Chair. Questions in relation to the reforms around checks for working with children, checks if I could.
Thank you, Senator. I'll get the relevant officers to come to the table.
Thank you. At the last estimates, you were able to provide us with an update on the work that's been undertaken to reform working with children tax following the commitment to action through the Standing Council of Attorney Generals at their meeting on the 14th of November 25. I understand there was a significant amount of money invested. Can you give us an update as to where that is at, please?
Certainly. Thank you, Senator, for the question. Chris Collett, First Assistant Secretary, Children and Families. Senator, as you may be aware, the Standing Council of Attorneys General at their meeting on the 14th of November last year approved a national reform agreement for working with children checks. It is obviously a complex piece of work across all jurisdictions that involves reforms to policy, to legislation, to IT frameworks and so on, cutting across multiple different departments and portfolios in every state and territory. The agreement sets out the bodies of work that are required and clear timeframes. That agreement is part of the Standing Council's communique and is publicly available. Going to your specific question, I can take you to some of the key developments since this committee last met. Priority one under the agreement goes to national recognition of negative notices, and you may have heard the Attorney General talk publicly about banned in one, banned in all. All jurisdictions now have legislation either in place or in their parliaments. One jurisdiction has introduced but is yet to pass that legislation that will allow for national recognition. There is still some technical work to be done with one of the states and territories, but that is moving very productively and very well. And a credit to your state and territory colleagues, ministers and governments to progress that legislative reform so quickly. Priority two goes to negotiating meaningful consistency in exclusion criteria. It's quite a complex policy piece, and we're working very closely with states and territories to look at the differences across their criminal codes and the particular offences relevant. Priority three goes to risk assessments, and we need to see increased consistency across jurisdictions to allow them to recognise each other's checks going forward. We have a body of work. I should note that the first body of work with exclusion criteria is led by South Australia, and we're very grateful for their efforts. The second one with risk assessments co-led by Queensland, and again we very much appreciate the technical expertise and knowledge of that agency. Priority four goes to developing information sharing arrangements between the screening units, again a body of work that we're co-leading with New South Wales. And priority five goes to the complex IT infrastructure that will be needed to support this, the national continuous checking capability. You referred to the funding, that's the $37 million of funding that the Attorney General announced late last year to allow the Australian Criminal Intelligence Commission to build that capability. As of late last year, that is now adoption ready. There will be a complex body of work for the state and territory screening units to onboard to that will happen over the course of the coming year, and an ongoing body of work between the Commission and state and territory police around data exchange and so on. They'd be the key points, but I might just check with my colleague, Ms McMichael, for anything further.
Yes, I think that's right. And did you mention the legislation for Priority Action 1? So all jurisdictions have now legislated other than WA, which has introduced legislation that we expect that to pass very shortly.
That's very good news, but could you just step us through the developments around the IT solutions? Because I think that's going to be crucial in making sure that checking capabilities are there.
Yeah, look, thank you, Senator. You're right. It is a critical capability to allow for national recognition of working with children checks. Although I would note that all of the priorities I touched on are critical. Every single one of those has to be landed. The Australian Criminal Intelligence Commission is leading that work, and certainly, in my view, is uniquely placed to be able to provide that service, both for the Australian government but for the states and territories. Their capabilities and the particular functions that the Commission provides to law enforcement nationally means they have both the IT capacity as well as the operational and technical ability, the pre-existing relationships with state and territory police and so on. There are approximately 6 million Australians that hold a working with children check. So once the capability is up and running, it needs to continuously monitor those 6 million people, as well as people that are excluded from working with children checks. And of course, going into the future, as new Australians come on and come off those state and territory registers, that capability has to continue working. The technical specificity I'd need to leave to the Australian Criminal Intelligence Commission to speak to, but the way I would explain it from a policy perspective, it's a network of networks in being able to, on a rolling basis, monitor 6 million and more Australians across each and every police force when it comes to criminal histories that are relevant to working with children checks. I think it's also important to note, Senator, that as that capability comes online, while it's critical for working with children checks, it will be available to governments to support a range of other screening services that we need in our country, particularly as it applies to people working with or engaged with vulnerable Australians, whether that's people in aged care, people with disabilities and so on. So it will have broader applications as the capability comes online.
There's been an issue that, will this actually change mandatory reporting? So if you're a teacher, which has happened recently, a teacher in a private school, allegations of grooming, they weren't reported, and so they left the private school, they were asked to leave, but then went straight into the public system. Is this going to capture those individuals?
Senator, I don't want to speak to specific cases, but if I go to your question more broadly, working with children checks and reforms to those checks need to sit in a broader framework in how Australia provides a safe environment for children. When it comes to particular reporting around the education profession, that's a highly regulated profession. There are all sorts of parameters and oversights that apply to teachers, predominantly at the state and territory level, that are quite specific and appropriate to a workforce that is paid, professional, tertiary educated and heavily regulated. Those same applications don't necessarily apply in full to that much broader community of working with children check holders, the 6 million I mentioned. Your question also goes to mandatory reporting, which again, while not the responsibility of this department, goes to the child protection frameworks that states and territories have and the obligations that are on both professions where they're specified. I think in many, if not all jurisdictions, teachers would be mandated reporters under child protection frameworks, but there are also avenues available to all citizens to report conduct to the appropriate authorities and under certain circumstances a legal obligation, particularly with regards to child sexual abuse. But I think at the core of your question, that mandated reporting issue goes to child protection frameworks not working with children checks. Of course, these systems have to be interconnected, and the information sharing frameworks that we need to develop that I spoke to before under priority 4 of the Standing Council's agreement would need to be able to bring in that sort of information so that a screening unit in a jurisdiction can see that there has been some sort of reporting about an individual with a working with children check.
And there's been agreement with consistency in the risk assessment and eligibility criteria for screening across all jurisdictions, is that correct?
That's what we're working on now. There's been agreement from ministers to do that work. We have the mandate from ministers across all states and territories and the Commonwealth. The doing of that work is underway now, and I don't want to minimise it, and I'm also very grateful to our New South Wales colleagues. It's a complex negotiation, the sorts of issues that have to be weighed up around the multitude of aspects that are relevant to a working with children check and then brought to a level of consistency. We don't need absolute harmonisation. We don't need them to be exactly the same. We need to have meaningful consistency to allow for national recognition
and what's the time frame for the implementation so that this is? Understanding WA haven't passed their legislation, but is there a time frame that is being put in place that you can update us on?
Yeah, absolutely, Senator. So there are multiple timeframes, and as I said before, the Standing Council's reform agreement is publicly available. Those timeframes are all articulated. They do vary. So for your particular question around information sharing, I think, Ms McMichael, it's middle of this year for agreement on the policy settings and the end of this year on the frameworks for doing that. Importantly, every jurisdiction will need to change their legislation, and there are timeframes on legislation being moved into next year, noting that we want to make sure we've negotiated outcomes on eligibility exclusion criteria, risk assessments and information sharing, so that states and territories can then move a single suite of legislative reforms to progress those work going forward. So all those timeframes are articulated publicly in the Standing Council's agreement.
Thank you very much. Congratulations on that work. It's really important, so thank you.
Thank you, Senator.
Thank you, Senator Polley. Senator Shoebridge.
Thanks, Chair, and good to see you all. I had some questions, first of all, about legal assistance funding.
Just bring the other people back to the table.
Yep. What's the preferred way of pronouncing the acronym for National Access to Justice Partnership?
We have debated this at length, and we use NAJP.
NAJP?
We're very standard on that one.
Okay. Maybe I might just say the Justice Partnership, but all of them are bad, whoever came up with that acronym. All right, the NAJP. The Community Legal Centres Australia, I know I have put in a pre-budget submission for increased funding for community legal centres under the NAJP. Secretary, they've asked for, because of the urgent need that they see, an extra $95 million for dealing with the sheer number of people impacted by domestic and family violence and who have been turned away by community legal centres. Previously, when we've asked about the NAJP, we've been told it's a 5-year funding and it's locked in, and regardless of the desperate need, and in this case, the need for people to get that advice about domestic and family violence, what's the position about increased funding for the community legal centres?
So, Senator, obviously that's a priority area under the NAJP in terms of funding for people experiencing family, domestic or sexual violence, building from the National Cabinet agreement from 6 September 2024, which put together the overarching package of support around women's safety. There's a range of initiatives under that, and I'll just ask Ms Bogart or Ms Mackesy to talk to the detail of that. I mean, obviously each year around the budget cycle we engage with key stakeholders, including the Community Legal Services stakeholder group, and look to understand the particular issues that they're raising. And I would say it's just...
But Secretary, I know it was a long question and it was probably a bit untidy, but I suppose my preliminary inquiry is this. Is there scope for increased funding for domestic and family violence support services, notwithstanding the NAJP is locked in for over the 5-year period?
So again, I'll ask colleagues to assist.
Senator, what I would say is, while we recognise there's always really high demand for legal assistance services, and particularly in the family, domestic and sexual violence space, there was a significant increase to CLCs, women's legal services and family violence and prevention legal services under the NAJP. So there was a 74% increase of funding, or for CLCs that's $275.7 million, or $833.3 million for women's legal services specifically as a standalone subsector created for the first time. They're recognised as a really important subsector. and also an increase of $193.4 million, or 112% more for the Family Violence and Prevention Legal Services. I would say that the increase in funding under the NAJP was really specifically directed towards family and domestic violence services, but notwithstanding that, I know that demand is always there.
Well, much of that funding was simply just picking up indexing that had been lost over more than a decade of real erosion in Commonwealth funding. I'm not saying it wasn't.
Some was.
I'm not saying
it
wasn't a material increase, but a big chunk of that was just simply picking up lost indexing going back over a decade. And I'm not going to hold your government entirely responsible for this, Minister, but big chunk of that was just restoring back to where we were a decade ago. Community legal centres are telling us that there's about 7,500 people every week who they're having to turn away with desperate need for help on domestic and family violence, on other critical issues. 7,500 people every week being turned away from the community legal centres. I suppose I'll go to you, Minister. Does your government have any intention or approach to actually fund the community legal centre to deal with that level of need? You know, women who can't get advice in domestic violence.
Are you saying we should fund every person who goes into one of these centres? Is that your proposition?
I'm saying you should fund every occasion that a woman goes to a community legal centre because of domestic and family violence and desperately needs help. I'm saying that. I'm saying you should fund
presumably
every
the
time
7,000
kids issues about kids' safety are going to community legal centre. Yes, I am saying that, Minister. I am saying that.
All right. Look, we take all of those issues seriously, and this government, I think, has got a record in terms of domestic violence of doing more than any other previous government has done. Obviously, to provide legal assistance for every single case that comes into a community legal centre would be a very, very expensive proposition. But it is a matter I'm very happy to raise with the Attorney General and come back to you with her formal response.
Yeah. Well, community legal centres, just to be clear, of that 7,500, community legal centres say their data says that 40 to 50% of that unmet need, the people they're turning away nationally, is frontline domestic and family violence prevention, and that jumps up to 75% in remote and rural areas. So when I put the 7,500 people a week, a huge proportion of that is family and domestic violence centres, and particularly in regional and remote Australia. Minister, do you accept that that's not right? That if you did have a magic wand, I'm not saying you did, you would fix that.
Yeah. Well, if we did have a magic wand, we would fix it. I go back to the original response I gave you, Senator Shoebridge, that I think you'll find that this government has done more to end the scourge of gender-based violence, which we, of course, understand is devastating many individuals, families and communities around the country. We accept the proposition that more needs to be done, and that's the ambition of this government. Can I perhaps just go through some of the things that we have done in this space? In September 2024, National Cabinet announced a $4.7 billion for measures to prevent violence and homicide against women and children. This included $28.6 million for two new pilot policing models to target high-risk and serial family violence offenders, which are partnering with the states and territories to implement. It includes $50.6 million over 4 years for the National Information Sharing Framework and its co-location program. And that's designed to improve information sharing on perpetrators across family law, family violence and child protection systems. We also provided $6.8 million for supporting children after separation program to expand access to therapeutic supports for children affected by family violence. These commitments build on the government's $3.4 billion investment into women's safety since October 2022. The government also passed landmark reforms in 2023 and 2024 to make the family law system simpler and safer for children and caregivers. So, you know, we have committed to doing things in this space. I personally accept the proposition that more needs to be done, but in terms of the specific question that you've asked, I shall get a formal response from the Attorney-General.
Thank you, Minister. Just to finish this in the time available, what the Minister says may be all well and true, but it doesn't respond.
It is true, not maybe true. It is true.
What the Minister says may be all well and true, but it doesn't respond to a mum with her kids who turns up to the Community Legal Centre in Dubbo desperately needing legal assistance about family and domestic violence and is turned away because they don't have the resources. Community legal centres have said they need an extra $95 million a year to deal with that. What is the process? What's the budgetary process? Is it NAJP? What's the process where they can engage on that?
So I don't have the answer to that question.
No, but they're going to them.
Ms Bogart does.
Senator, any decisions about increasing funding or budgetary process is obviously a matter for government. But what I'm
asking is, does that require revisiting NAJP, or is there, what's the process that would see that?
Senator, over the years there have been increases of funding over multiple occasions to legal assistance and in different ways. Sometimes it's through reopening a national agreement under the NLAP. There was an additional I think $400 million put into that over its life. But there's also other avenues that funding is provided. Senator, I will add, I know the statistics you're providing are about turnaround rates for CLCs, but the legal assistance sector is made up of 5 different subsectors. There's CLCs, there's women's legal services, there's legal aid commissions, family violence and prevention legal services, which are particularly in regional and remote areas to support First Nations women, and Aboriginal and Torres Strait Islander legal services. So those statistics may be for the CLCs, but there may be other parts of the sector as well as the pro bono sector that could be capturing those people once they are turned away. And I don't know that for sure, but I'm just
Ms Bogart, I'm pretty sure I could put the same call for increased support. In fact, I know it's probably in my questions later. For each of those other elements, they're all facing a similar crisis of turning away people that they would desperately want to help. So you raising that, I think, just raises the extent of the problem rather than identify an alternate solution.
Senator, I think I would go back to Ms Bogart's original point. Of the additional $800 million that came in under the new National Access to Justice Partnership, it was brought in very much with a focus on protecting women and children, particularly victims of domestic violence. So it has been identified as the critical area for enhanced focus under that partnership agreement, and we will continue to work with all the subsectors to seek to support them to address that need.
Thank you, Senator Shoebridge. Senator Blythe.
Thank you very much, Chair. This is looking at a different issue, going into artificial intelligence.
In which context, Senator?
In the context of, I guess, frameworks that have been set up for safety and governance within the department.
Right. We'll attempt to help. That would have been in cross-portfolio. And I think some of the people that I would have had to assist me have left. But perhaps if you ask your questions, and I'll do what I can to answer.
We can see how we go.
Yeah.
So I guess it's just what the department's doing to ensure that AI systems are used fairly, safely and accountably in all of the various areas of responsibility.
Thanks. I think that we can speak to some of the issues associated with organisations that we fund. I would say in the courts, in the legal assistance sector and elsewhere, there are early processes to look at utilising AI to achieve scale and efficiencies. I think there are some services operating in the legal assistance sector that are looking at addressing unmet need by being able to provide AI-enabled platforms and technology that can be utilised. So Ms Bogart or Mr Daniel might be able to expand on that a little bit further for me. Actually, if I can take a step back, Senator, we have established a portfolio AI committee. That's a consequence of the fact that the Attorney-General has asked us to look at opportunities for AI to be utilised to achieve scale and efficiencies in the delivery of our services. So we established a committee that has all the agencies in our portfolio. Yep. And we're looking at where we can share some experience about perhaps AI-enabled bots that might be able to give fast and accurate advice to people that are approaching agencies, whether it's the Office of the Australian Information Commissioner or the Australian Human Rights Commission or the courts. So we're looking at exploring how we can share development experience in those spaces for it to be used across multiple agencies. And I think we're actively engaged with in conversations with the courts. Obviously, all those agencies are subject to the whole of government AI frameworks that apply around responsible use of AI. And I think I'll just see if Mr D'Emanuel wants to add anything to that.
Senator Liam D'Emanuel, Acting First Assistant Secretary, Courts, Tribunals and Commercial Division. I'm currently acting as the Chief AI Officer within the department, and then the department also has appointed a AI accountable official, who is our Chief Information Officer, Mr Harrison, able to assist you with an overview of AI in the context of the department and what we're doing, if that would be of assistance.
That would be very helpful, thank you.
Thank you. So in terms of the Attorney General's department, we're really focused on ensuring that we're harnessing the benefits of AI to support productivity and innovation, but also ensuring that we're managing and mitigating risks that may be associated with AI. The Secretary spoke about the governance frameworks that we have set up within the department. Staff have access to broadly two sets of tools, so access to public tools that no doubt you would be familiar with, like ChatGPT, and then also to enterprise tools which have been deployed across the department, so Microsoft 365 Copilot, for example. As part of that, we've really focused on ensuring that there's clear guidance for our staff in place as they use these tools and navigate the information in their day-to-day work with those tools. So we've got a range of policies in place. We have a responsible use of generative AI policy and also to an AI acceptable use policy. We also too have training for our staff in place and ensure there's ongoing education and engagement across the department, both as new tools are deployed, but also to ensure that staff are aware of their AI obligations, but also to their broader public service obligations around privacy, security, freedom of information, for example. And that's underpinned by the governance frameworks that we have set up in the department as well.
Okay, and I guess in terms of sensitive information with some of those publicly sort of more mainstream, how are you monitoring whether sensitive information is potentially being put into those by employees?
I might ask...
I think we'll ask
Mr Harrison's over.
Yeah.
Sorry. He's very efficient.
I'll ask Mr Harrison to talk to that issue.
Thank you.
Before I do throw to him, I would say I've just recently completed the AI training myself.
Yeah.
And it's particularly useful, accessible, but delivers all the key messages around privacy and security, but also seeks to encourage and make people open to thinking about more use cases for AI. So we want to drive its use, but in a responsible way.
Fantastic.
Mr Harrison.
Yeah, thank you. Michael Harrison, Chief Information Officer, Attorney General's Department. We relied pretty heavily from the beginning on really strong education of staff. We made available public tools well over 12 months ago, I think. So we're very keen to have our staff engage with the technology. It's such an important opportunity for the department and the public sector. But we issued very clear responsible use guidelines that really stipulated not to put private information, not to put secure information into the public tools. It was a simple test. If you wouldn't put it into Google, don't put it into the public AI tools. And we've been working quite hard since then to deploy secure tools.
Okay.
Because I think making secure technologies available is the strongest way that we can protect private or sensitive information in the use of the artificial technology.
Yes, certainly.
Chair, if I could just ask a follow-up question as
Absolutely.
part of this block. So that deals with privacy security issue, but the other issue with AI in a legal context is practitioners using AI for the purposes of making submissions to court in terms of case preparation, and there have been quite a number of reported cases of, I think they refer to them hallucinations of case authority, where cases are just come out of thin air to support propositions, submissions which haven't been checked in terms of attribution of precedents, etc. Is that part of the guidelines you're referring to in a particular legal context?
I might first go at that and then I'll hand over. One thing I should note is the Attorney General did put the use of AI in the legal profession on the agenda for the Standing Committees of Attorneys General at the last meeting, and there was a preliminary discussion about opportunities and challenges about use of AI by the legal profession, and I think there will be subsequent conversations there. Obviously, it is a matter for each court to determine rules as to the use of AI, and I think it would be fair to say, Senator, that there's different approaches in different courts around the country, even as between a Supreme Court in one jurisdiction and a Supreme Court in another. I know it was the subject of quite a lot of discussion at the Australian Legal Conference that was convened by the High Court at the end of 2025, and I think there is further work to consider consistent approaches to challenging that, and I think further conversations, but it is a matter for each court as to the rules that they apply in their courts, and I think there's also obviously the conversation both with the professional bodies, the bar associations, the Law Council, and the Australian Australian College of Judicial Administration and the Judicial College around training in the court space as well.
But, Secretary, you know, I mean, the Attorney General's Department is in a very privileged position insofar as you have oversight of a number of, or responsibility for a number of courts and tribunals. Is there any proposal for the Attorney General's Department to lead some sort of national approach across different state and territory jurisdictions, so we have some sort of consistent approach to AI that's informed by the input from the professions, from the tribunals, from the courts, so that we can deal with this issue as opposed to each court and tribunal embarking on their own ad hoc arrangements?
Senator, that will ultimately be an issue for each jurisdiction in terms of their preparedness to engage in that way. As I said, the Attorney-General did put it on the agenda for SCAG. I see that as the initial discussion about that issue, and I think there will be further opportunities through SCAG to consider whether or not there's interest in that more coordinated national effort.
Okay, thank you. Thanks.
Sorry.
Can I share the call and come back to you?
Yeah, certainly. I've got two more, but in your hands.
Yeah, no. Thank you. Senator Cox.
Thank you very much, Chair. Can I ask some questions in relation to NAJP? I think same officials? We could, yes? No? Different ones? Good, I'll wait till they're in place. Hi there. I'm interested to know how the Commonwealth is engaging with states and territories to ensure that the long-term workforce planning supports the legal assistance sector to continue meeting the needs of the community into the future.
Thank you, Senator. Bridie McCasey, Acting First Assistant Secretary for the First Nations and Justice Policy Division. So, as Ms Bogart noted, the NAJP commenced on July 2025, and it's $3.9 billion in funding over 5 years. Funding for the legal assistance sector is a shared responsibility between the Commonwealth and the states and territories, and the NAJP is a partnership between the Commonwealth and the states and territories. There are a range of mechanisms that are built into the NAJP to support that engagement, and as you've noted or flagged, that includes working together on the long-term reforms that were agreed as a priority under the NAJP. Specifically, that is the National Legal Assistance Data Strategy that will strengthen the sector's data capability and maturity. There's also the National Legal Assistance Workforce Strategy, and that will consider practical actions to improve attraction, retention in the legal assistance sector workforce, particularly in remote and very remote areas. And there's also an outcome-based framework to be delivered within the first 2 years of the NAJP, which will shift the legal assistance data landscape.
Great, thank you. Can you explain to us how the National Access to Justice Partnership, or the NAJP, supports the delivery of closing the gap outcomes, particularly our justice targets?
Certainly, Senator. Under the NAJP, governments are working in partnership with the Aboriginal and Torres Strait Islander community-controlled legal assistance sector to develop a Closing the Gap schedule. That's due to be completed by the 30th of June 2027. And that's provided for under Clause 77 of the NAJP. That schedule will include actions to support progress towards the priority reforms under the National Agreement on Closing the Gap, in particular targets 10, 11, 12 and 13, as well as the priority reforms, as I've noted. I would also note that significant components of the NAJP funding contribute towards closing the gap. Ms Bogart has spoken earlier about the uplift to the different sectors, and that includes a 64% uplift in quarantine funding for ATSLs, which are the Aboriginal and Torres Strait Islander legal services. They provide services to Aboriginal and Torres Strait Islander people to improve self-determined access to justice, reducing incarceration rates and reducing family violence. This also includes funding for the custody notification services, which are crucial for preventing Aboriginal and Torres Strait Islander deaths in custody. They respond to recommendations of the Royal Commission into Aboriginal death of custody as well. And I should note that this is the first time under the NAJP that the custody notification services have been funded in all jurisdictions. Previously, Queensland and Tasmania didn't have funding for the CNS. There's also a quarantine funding stream under NAJP, which represents a 112% uplift in relation to family violence prevention legal services, and they provide services to Aboriginal and Torres Strait Islander women and children who are experiencing at risk of or recovering from family, domestic and sexual violence. And I'll just finally note that alongside the NAJP contributions to closing the gap sits funding from the Community Legal Services Program. This is a nationally focused grant program that complements the NAJP, and under the CLSP, as we refer to it, there was $12.26 million in funding to the 2 Aboriginal community-controlled peaks, which is the National Aboriginal and Torres Strait Islander Legal Services and the First Nations Advocates Against Family Violence.
Great, thank you. Recently there's been some media reporting from the Northern Territory regarding the adequacy of funding, particularly for legal services. Can you tell us what the total funding allocated for the NT legal services are under the 5-year NAJP?
Yes, Senator, certainly. I'll just turn up the relevant section of my brief. Oh, sorry. So under the NAJP, the Northern Territory will receive a funding increase of $167.2 million. That's an increase of 108% in Commonwealth funding over 5 years. And I can provide further breakdown if you wish, but that's the overall figure.
Great, thank you. So sorry, just noting that was an increase in funding. Is that correct?
Senator, yes.
Great, thank you. How much is being invested in family violence prevention legal services, specifically family violence prevention legal services in the NT? And on a per capita basis, how does that compare to investments in other jurisdictions?
Thank you, Senator. So the FVPLS in the Northern Territory received a 112% increase in funding. So previously the funding under the previous arrangements was $34.322 million, and it's now $72.8 million. We don't have a per capita breakdown, Senator, to hand, and I think it's worth noting that that would not necessarily reflect the way that the services are accessed in any event, because it's not the whole First Nations population that accesses those services, because they target a specific need. However, what I can say is that the number of existing family violence prevention legal services in the Northern Territory which are funded that's 3, compared to some of the other jurisdictions, reflects the number of First Nations people in the Northern Territory.
Yeah, great. As someone that's previously on this committee had some conversations around missing and murdered First Nations women and children, particularly in the Northern Territory, I'm sure that the increase is well sufficient, not just per capita. So I just want to quickly move to justice reinvestment, if I can, and the justice reinvestment program. How is the department reviewing the progress of the justice reinvestment projects funded to date?
Thanks, Senator. I'll just ask Ms Woods to come to the table, who is our expert on justice reinvestment.
And I'll just note, whilst Ms Woods is getting settled, Senator, that justice reinvestment is by its nature a long-term investment, but as I'm sure Ms Woods will take us through, we have seen some very positive early successes in the program.
Do you, Kath? I might ask Ms Woods to start, and then Ms Turk, who's leading the work on establishing the Justice Reinvestment Unit, can talk to that.
Hi, Cassie Woods, Assistant Secretary for the First Nations Justice Branch. Senator, the Justice Reinvestment Program, as Ms McCasey mentioned, is a long-term commitment, and happily, as of the middle of this year, we will be moving to ongoing funding for those initiatives after their initial funding period. Being a long-term commitment, progress takes time, but in terms of how we measure with each initiative, we have a really community-led set of measures of success. We're looking at doing grants differently through justice reinvestment that is absolutely community-led. And those are all sort of documented in activity work plans, which we get reporting against typically every 6 months. Moreover, we actually engage at least on a monthly basis with each of our initiatives for yarns, essentially, so that we can actually understand the context behind the numbers that we see reported through these paperwork approaches that we do have to do as government, but aren't necessarily reflective of the actual progress in the communities. We also have a lot of positive stories coming through from our initiatives, which I think it's really important to balance, again, the numbers versus what that impact is in the words of community, which we get quite a few testimonials, we get progress reports. But for instance, I can sort of indicate that, you know, we have 27 active justice reinvestment initiatives funded at the moment who are all progressing. We have some of our more mature initiatives that are, you know, in one instance taking 46% of their referrals from state institutions, so redirecting out of systems into community-led initiatives to prevent contact or recontact. And we monitor that progress through that activity reporting and those monthly meetings as a, you know, real-time understanding of the impact that's happening in those communities.
That's great, Ms Woods, thank you very much. Are there any key themes or key features that are almost looking towards best practice in terms of delivering those real practical outcomes for the communities that they are serving, obviously acknowledging that they're different and need to be flexible?
I think what I would reflect is where our initiatives are, our more mature initiatives who have been funded the longest, the successes that they're drawing are coming through the themes of, you know, good connection into state services, so policing, institutions, etc., good connection in with the actual government itself, good connection with the Commonwealth, so a really kind of multi-part connected approach to delivery that retains First Nation community-led. So government's taking the lead, services taking the lead from the initiative rather than the other way around seems to be a really effective model to preventing contact. The other key themes I would reflect that are coming through are really the value of the cultural grounding in community as a preventative mechanism, as well as, I guess, the extension of that, which is seeing better education outcomes, better, I guess, activity outcomes in the sense of actually having something to do that is positive and connected.
That's great. Thank you, Ms Woods. Just a final question. That engagement with states and territories to encourage that sort of coordinated approach to justice reinvestment in and across Australia, could you tell us a little bit more or expand on that and how we're building that ecosystem of sharing both the lessons that we've learnt and also strengthening and building capability across this sector?
Certainly. So I guess there's, again, a multi-pronged approach that we take in that. 12 months ago, as we sort of came close to reaching the total number of funded initiatives committed to, we established a national justice reinvestment collaboration group, and that consists of the Commonwealth, not just Attorney General, but other agencies that do both justice reinvestment or place-based sort of funding, state and territory governments, peaks, JR bodies, philanthropy, because all of those sort of players, for want of a better term, all have some level of either financial investment or in-kind investment in justice reinvestment, both at Commonwealth and state and territory level. And so that group meets periodically for the express purpose of actually collaborating, connecting in terms of making sure that there's connection across jurisdictional and Commonwealth initiatives, making sure that there's appropriate support. Data sharing is a key feature of that, that collaboration group to strengthen data sharing arrangements. But moreover, sort of at the Commonwealth level, justice reinvestment is brought to SCAG routinely, the Standing Council of Attorneys General, as another mechanism to ensure state and territory collaboration, including sort of the development of memorandum of understanding that the department has been working with those jurisdictions around. And SCAG actually has a set of collaboration principles around justice reinvestment specifically that were developed in partnership and endorsed back in December 2023 as a foundation to those conversations. So, and what I would also say is that there are already instances of co-funding at a Commonwealth level, Commonwealth Justice Reinvestment Program level with state and territory governments. So we're well advanced in that sort of collaborative ecosystem for justice reinvestment.
That's great. Thank you, Ms Woods.
Senator, if I could just add, I mean, we would obviously welcome continued conversations with the states and the territories about opportunities for co-funding of justice reinvestment sites. The conversations at SCAG have been quite positive. I think all jurisdictions see justice reinvestment as a positive way to seek to divert. And I think also through the conversations that we've been having around the establishment of the justice reinvestment independent entity, that has been a theme coming through. And have you got anything that you would like to add to that, Mr.
Yes, Jessica Turk, Assistant Secretary leading the Interim Justice Reinvestment Unit. Part of the work of my unit is also the collaboration with states and territories, and we work directly on the ground with those 27 funded sites, and we engage them with the state and territory counterparts to ensure that there's a connection directly to those ones as well as through the Commonwealth, and we work together to help them build capability, capacity, any support, access to data that is required. So we have regular, usually monthly meetings between both the sites and those state and territory counterparts, and that's really become a really great relationship between them because they have direct access to the people required to help make sure that they're successful in their delivery of the initiatives.
Yeah, great. Thank you. Thank you all for your work, and I note that it's been a great amount of work that the department have put in the last 12 months, and I think that we're now seeing that come to fruition. So well done, everyone.
Thanks, Chair. Thank you, Senator Cox. Senator Shoebridge.
Oh, yeah, thanks, Sam. I think on the last occasion, but it may have been before, when I asked questions, I think of you, Secretary, and your officers about the expert legal advice obtained by the National Aboriginal and Torres Strait Islander Legal Services and the Justice and Equity Centre regarding the Commonwealth's power to raise the age of criminal responsibility and create minimum standards for children and young people in detention. You indicated that when I asked about would you release the report and what was the Attorney's position, you indicated you would obtain the Attorney General's reviews on the advice and revert back to the committee. That hasn't happened yet. Well, you may have obtained the Attorney General's advice, but you haven't reverted back to the committee. What is the position on that advice?
Senator, I'd need to go back and check the record about as to whether I said I would come back to the committee, but what I did undertake is, what I noted is I had read the advice myself and that we as a department have briefed the Attorney General on the content of that advice. But I would note that that is part of broader engagement on issues associated with addressing incarceration rates for First Nations people, for working through SCAG around the minimum age of criminal responsibility. I know we've had that conversation here over numerous estimates hearings, the work that was done around the Bail and Reform Working Group and its report. And so there's a broad effort in this space, but all I will note is this: we did brief the Attorney General.
All right. My records have you saying you would obtain the Attorney General's views on the advice and then respond back to the committee. Did you obtain the Attorney General's views on the advice?
Senator, I think I just need to check that. It would be unorthodox for me to say that I would report back the Attorney's views to a Senate committee, so I just need to check that. And
and revert back to the committee.
Okay.
And then revert back. I don't think you gave a promise of being a conduit, and I accept that. you said you'd obtain the Attorney-General's position and then revert back to the committee. So what is the Attorney-General's view on this pretty obvious threshold point of does the Commonwealth have the power to raise the age of criminal responsibility across the whole Commonwealth?
Senator, we have... firstly, I think I would check the Hansard on that. I'm not sure if it was myself who undertook to revert back. Secondly, we do not provide legal advice to the committee. I note the advice from a KC or QC on this matter.
Two. I think it was a joint advice, but...
It was a joint advice, but my recollection is only one was KC, but I might be wrong. I'm
and
happy
the other
to be
was
corrected on that.
another senior lawyer.
Yeah, senior lawyers. And we have briefed the Attorney-General on that, and I can't go any further than that.
Well, are there any moves afoot for the Commonwealth to do the right thing and start a process of saying to the states, if you won't lift the age of criminal responsibility, if you keep putting 10-year-old kids in jail, kids with their milk teeth, well, the Commonwealth will act and lift the age of criminal responsibility. Minister, do you think it's acceptable that kids who have still got their milk teeth, aged 10, are being held for weeks in jails in Queensland? Do you think that's acceptable?
Well, it's obviously very distressing that young children should be in that situation, but this is not obviously my portfolio, direct portfolio interests, and I would be happy to get a formal response for you from the Attorney-General.
But Minister, this isn't just an academic discussion between you and me, and I accept you're going to get advice. Let me just finish the question.
I did respond.
No,
I acknowledge that
I'm not criticising
a distressing situation.
But Minister, that's.
But if you're wanting a formal response of the government to the issue that you're raising, then the appropriate person to do that is the Attorney-General. She's not here, I'm her representative, but I'm very happy to go back and ask for a formal response to your question from her.
And I appreciate that, Minister, but I will just point out that I did ask for that formal response in the last estimate session. I didn't just ask it on behalf of myself, I asked it on behalf as well of the millions of Australians who think it's wrong that 10-year-old kids are going to jail, and in circumstances where the Attorney-General has been briefed with high-level legal advice from the National Aboriginal and Torres Strait Islander Legal Services and the Justice and Equity Centre that you can fix it. You can legislate to make a minimum age of 14. Will you put that proposition to the Attorney and ask for the response?
I shall put every question that you ask to me that I am unable to answer on her behalf today to the Attorney-General, and I request that I will request that she will respond ASAP to your questions.
Thank you, Minister. Secretary, has that advice been provided to the Standing Committee of Attorney-Generals, and has it been fed into that process?
Senator, I think we have looked at that advice and have recognised that it is the considered view of two legal experts, but it's not a definitive view.
That doesn't answer my question. Has it been provided, that high-level advice from two highly regarded experts in the space, has it been provided and put on the agenda of SCAG?
Senator, I will have to take that on notice. I know that SCAG has discussed minimum age of criminal responsibility so many times over the last few years, but just that specific question, I will have to take on notice whether it has been given to SCAG as an organisation.
And just so as we can hopefully avoid more back and forth after another 6 months from now, if it has been provided, in what circumstances was it provided? And if it hasn't been provided, why hasn't it been provided?
We can take that on notice, Senator. Thank you.
Secretary, barely a fortnight ago, the United Nations Universal Periodic Review of Australia's record and commitment to international human rights obligations occurred in the UN on the 26th of January. You're aware of that?
I am, Senator. An officer from this department led our delegation.
Sorry?
An officer from this department led the Australian delegation.
Who led it?
Ms Catherine Haig.
All right. Well, you would know that 40 countries, including Germany, France, Norway, many of our friends who we would share cultural and legal values with, called on Australia to raise the age of criminal responsibility to at least 14 to stop incarcerating First Nations children. Are you aware of that?
I am, yes, sir.
And what have we done in response to 40 countries pointing out what I think the federal government should know, which is until you fix it, until you raise the age, we're going to keep incarcerating First Nations kids at an appalling rate. What have we done in response to that?
Well, Senator, as you noted, it was just 2 weeks ago that Australia's appearance occurred in Geneva. The process now is to look at the various recommendations that were made under our, I think the formal language is country report, and consider what response the government will take. So it will be considered as part of that process.
Well, the good news, Secretary, is you have high-level legal advice from Ms Eastman and another that you can do this. You can just respond to this call from 40 countries, including Germany, France, Norway, to raise the age. You can just do it. So why isn't that an action point?
As I said, Senator, the advice by Ms Eastman and her colleague has been noted, but it is not definitive advice.
Well, have you sought definitive advice?
Senator, I'm not going to go into the details of the...
I'm not asking for the content. I'm asking whether or not you've sought it.
Senator, we have done a lot of work through the SCAG working group around minimum age of criminal responsibility and working with states and the territories on that.
No, my question was, Secretary, have you sought advice, independent advice, about the matters raised by Ms Eastman and her colleague? Have you sought legal advice about that?
Senator, it's...
Or is it hear no evil, see no evil, pretend it's not a problem thing?
No, not at all. We don't, as a matter of course, seek independent legal advice on independent legal advice that's been given by a stakeholder group.
Well, you see, you're responding to my questions about why won't you act on it by saying, well, it's just the advice from these two lawyers and it doesn't necessarily reflect the opinion of the Commonwealth. So I'm asking you, what have you done to see what is the opinion of the Commonwealth on this core issue? Have you got the AGS to provide advice about it? Have you got any other senior member of the public sector to provide advice about it? You keep saying, well, that's just their opinion. I'm asking you, what have you done about getting the Commonwealth's opinion?
Senator Shoebridge, I'm going to indicate I'm going to rotate the call after the officials have answered this question.
What have you done? Have you got it?
Senator, we have done a lot of work over the last several years with the states and the territories, working with them about their laws. There have been some positive movements. As you know, the ACT has raised the minimum age of criminal responsibility from 12 to 14.
The NT has lowered it. Queensland monstered kids. Don't tell me this is a good news story. It's not.
It is a story of the Commonwealth working with states and territories in areas that are their constitutional responsibility.
After this round, I'll keep coming back and asking the question until I get an answer.
Sorry, we've got a point of order, Senator Shoebridge.
The Secretary is doing her best
to not answer the question.
Very
Senator
valiantly to answer the questions in a measured and considered way. And Senator Shoebridge, I know he's passionate about this issue, and I deeply respect that, but it is making it difficult to get the appropriate questions and answers on the record. So.
Well, I mean, to that, I've asked a simple question about what's been done with this advice, and I get non-answers, repeated deflection and non-answers.
Senator Shoebridge, Senator Scarr has put a point of order before the committee, and I agree with Senator Shoebridge that the Secretary is doing her best to respond to the questions, and I did indicate that I would rotate the call, and this seems like an appropriate juncture to do that. Senator Blythe.
Thank you very much. Chair, and I'll stick with this portion before I go back to AI to save the musical chairs. So I think, there is some great work that's happening, and obviously outcomes that we're wanting to get to in reducing crime rates, incarceration rates, and recidivism. The 2025 Closing the Gap annual data shows that incarceration for Aboriginal and Torres Strait Islander adults is actually now classified as worsening. So that's, and I can understand that there are programs like the Justice Reinvestment, but it seems to be that the data is actually tracking not in the way that everyone would like. So I guess from the department's perspective, what are you looking at doing to, I guess, modify what's happening to try and make sure that the outcomes of what you're intending to happen actually happen? Because that's the outcomes that everyone's hoping for.
Well, I might just start and then I'll hand over to colleagues. Obviously, this is a national issue. Yep. Whilst rates might be higher in some jurisdictions, the reality is it's too high in all jurisdictions in terms of adult and youth incarceration rates in the country. I think the tiers of work that we do in the justice sector are about prevention and diversion approaches, and that's where justice reinvestment plays a role for both adult and youth offenders. But one of the other things that we have been doing, working with colleagues across the Commonwealth Government, is in recognition of the fact that people interact with the justice system because of challenges in other spaces, whether it's education, housing, health, child protection systems that are state and territory systems. So whilst, yes, of course, we have to look at more measures in the downstream space of the justice area and law enforcement, one of the big areas of effort is around working across government with social services, education, health and housing in those spaces to try and prevent people from getting involved in the justice system in the first place. That, of course, involves talking all three levels of government, state, Commonwealth, state and local, working together across the systems that they're responsible for. But I think it is fair to say that a lot of the levers here with the states, it's their remand and bail laws that are having a significant impact on incarceration rates and the amount of time that people who have not been charged spend time in prison. So that goes to the work that Ms Bogart and others here have been leading, working with the states and the territories around addressing bail and remand. And I'll now hand over to them.
Thank you. I might hand over to Ms Woods to provide a bit more information about what we're doing in working with states and territories, but also working through the Closing the Gap architecture and policy partnerships. We are responsible for the Justice Policy Partnership, but there has been a real increase in the work we've been doing with other policy partnerships in recognition of what Ms Jones just mentioned around the different drivers into the system.
Yeah, I can, thank you, Ms Berger, expand on, I guess, the work of the Bail and Remand Reform Working Group, which was commissioned out of the Standing Council of Attorneys General and was made up of Justice Policy Partnership, state and territory governments and all Aboriginal Torres Strait Islander legal services to inform a really evidence-based and detailed report to Standing Council of Attorneys General. And I guess what I would reflect is that certainly at the Commonwealth level, there's action already sort of in place that aligns with a lot of those recommendations. And in fact, there is at state and territory level as well, to differing degrees. But the continued work of that sort of national dialogue with state and territory governments is kind of the real emphasis that we need to continue to place across all areas of justice conversation, because as the Secretary noted, it is state and territory governments who own justice systems, who control the levers that we are trying to pull. Yep. From our perspective, continued practical investment in things like justice reinvestment really go to the heart of what the Commonwealth can directly influence, and working directly with communities to ensure that that money is actually targeted in a way that works for community and will have the impact, continues to be a focus. And so while sort of the overall statistics might be disheartening to say the least, when you look at the community level where that investment is being made, you can see the improvements, and so that continued practical investment just remains a critical lever that the Commonwealth utilises.
And I can appreciate that the Commonwealth is trying to do what it can, but I think it's fair to say with the target of reducing youth incarceration by 30%, but it's actually up by 11%. So even with this additional $69 million or so, it doesn't seem to be budging the outcomes in the right way. So it sounds like it's sort of the approach is more of the same, hoping for a different outcome, noting that you're absolutely right, the states do have jurisdiction over it. But going to that, there is something like nearly 35% of Aboriginal and Torres Strait Islander young people in detention in 2023, 2024. They were between 10 and 13 years old, and it was their first entry into the system. And then when we have a look at those who are unsentenced, both adults and youth, you're sort of looking at, for the adults, 43.9%, which is up 10%, who are sitting in incarcerated and not sentenced. And then for Indigenous youth, you're looking at 76.8% of those in detention on an average night are not sentenced. So they are really sort of dire statistics. So are there any sort of plans in terms of, and this is, I guess, where you have control over some of the support funding, legal aid. There are a lot of people who are waiting in jail because they don't have access to legal aid. Are there things, so rather than, and I can understand why you would want to divert people away from the justice system altogether, but what are we doing about the ones that are there? Because it seems to me that all of the data is tracking in the wrong direction, and something probably should be done for people who are sitting incarcerated, unsentenced, who can't access legal aid.
So what I would reflect, Senator, is that in terms of the data, whilst the national aggregated figure is, as you state, there are 3 jurisdictions that are improving in relation to the youth justice targets. There are 3 that remain with no change from the baseline, and the others that are worsening, as you reflect. So we have seen quite a bit of movement in the youth justice space, notwithstanding that any incarceration without charge is obviously not a desirable outcome, hence our work in and around bail and remand being our strongest focus with state and territory governments, recognising that exact issue. But I also would like to sort of put it into sort of a numbers context for you. When we're talking about percentages, I think we get a little lost on the human aspect. So on an average sort of night, based on the AIHW's data, That equates to about 495 First Nations youth in detention out of our population. And so when we are talking about our strong focus also on justice reinvestment, where we're talking about hundreds of referrals for a single initiative, and you multiply that out over all of our 27 initiatives versus the 495 that are typically in detention, you can see even just on a numbers basis that justice reinvestment is such a pivotal part of addressing targets 10 and 11. Recognising also that people are going into detention. There is, the $3.9 billion investment in the National Access to Justice Partnership, which has been sort of outlined previously this morning, which provides substantial funding to ensure that there is that legal assistance access for those people entering into detention and custody. And there is also sort of the CNS measure that Ms McCasey mentioned earlier, which is actually also looking to the health and welfare of those people entering the system, as well as their legal access with a legislated requirement for contact of the CNS when a First Nations person enters the system, so that there is that immediate and direct legal and health welfare support.
And I can appreciate there are all of these support mechanisms in place, but what's being done to ensure that we don't have such a huge percentage, 76.8% of Indigenous children in detention unsentenced? What are you actually doing? Have you got targets that you want to get that down to? It's wonderful to have all of these different things, and we seem to be investing a lot of money and resources into programs across the board, but the reality is the stats aren't going and the outcomes aren't going in the direction everyone would like them to. So have you got targets that you are trying to get to, and practical outcomes where you're saying, we want 20% to be a target, whatever it might be? Have you set...
Senator, I'll talk to that. I think Ms Woods has given an excellent overview of actually that the justice reinvestment projects can target particular communities and make a difference to individuals, which I think is really important, as opposed to just the broader statistics, although the broader statistics are compelling and we need to look at them to understand that tracking. I would say on that issue of number of youth who are held on remand, that is a stark issue. It's to do with state and territory bail and remand settings. When this issue was considered in the Standing Committee of Attorneys General at the end of last year, all jurisdictions made it very clear that the banned bail and remand settings in their jurisdictions were a matter for them. But the paper that Ms Woods has spoken to, what I think is the most compelling part of it, set out examples of support services and programs targeted at people who are on remand, about whether it's legal assistance, whether it's being able to connect them back into community, or simple issues of being able to ensure that if they do exit being held on remand, there's a car to pick them up, to take them back to, like, very practical assistance to people. I think it's in that space where we would hope that all states and territories step up. Obviously, it is a matter for them ultimately what legal framework they will put in place in relation to bail and remand, notwithstanding that we would encourage thinking about measures that would reduce incarceration rates. But I think it's these support programs that we have been actively encouraging them to roll out more extensively.
And then I just have one last question, which is just, has the department commissioned any research into the impact of alcohol, drugs and gambling, and any correlation with the increased incarceration rate of youth and adults? since 2022?
Senator, we haven't commissioned research into that, but I know that the Department of Health, so alcohol and other drugs, usually sits within the Department of Health remit, and the National Indigenous Australians Agencies also does some work in that space. I can't tell you whether they've commissioned work. We certainly haven't, but that wouldn't ordinarily sit in our portfolio.
I would say that goes to the issue that I spoke at the beginning. We're highly conscious that broader issues that affect community safety but individual well-being, that are a responsibility in health, in education, in housing, definitely have an impact on contact with the justice system. And I think on that, there has been research over the years around the impact of alcohol and drugs on the criminal justice sector. It may not be specifically focused on First Nations cohorts, but more broadly. But we'll take that on notice as to whether there's any recent research that we could refer to.
Thank you.
Thank you, Senator Blythe. Senator Polley.
Thank you, Chair. I wanted to get an update from October in relation to the Copyright and AI Reference Group, if the officers are available. I was hoping you could give us an update in relation to the announcement that the government would not proceed with the text and data mining exemption. Can you give us some new information around that?
Yes, thank you, Senator. Jenna Priestley, Assistant Secretary, Commercial and Copyright Law Branch. As you've referred to, in October last year, the government announced that it was not considering a text and data mining exception, which would have allowed free use of copyright material for AI training. What it did point to, though, that it was undertaking consultation with the Copyright and AI Reference Group on 3 priority areas, the first being encouraging fair legal avenues for using copyright material in AI, and in particular examining different licensing options that may support that. The second was improving certainty by exploring opportunities to clarify or update how copyright law applies to material generated through the use of AI. And the third was considering avenues for less costly enforcement. Between October and December, the department ran a consultation process with the reference group, which comprises around 70 members from a broad range of sectors. That consultation closed in December. We received 57 submissions, which provided detailed technical, nuanced views on the issues in the paper, reflecting the complexity of copyright law and AI developments. We've provided the Attorney-General an initial briefing summarising what those submissions said, and we'll now work through the submissions in detail to analyse the issues and do our due diligence to provide informed advice to government on next steps.
Can you give us an indication of the kinds of stakeholder groups that made those submissions and those that have been consulted thus far?
Sorry, can you just repeat the second part of the question?
Yeah. Have you had consultation with any of those submitters from those stakeholder groups?
So the submitters were from a broad range of stakeholder groups, I think generally representing sort of the creative and media sectors, the technology sector, schools sector, universities, libraries, museums, archives, and also academics. We have regular consultations with a number of those stakeholders, but given that submissions only closed in December, we haven't had any specific follow-up consultations with them on the content of the submissions at this stage.
So in relation to the submissions, overall, in your summary of those, is there a preference for maintaining the status quo of voluntary licensing scheme in the Copyright Act versus the mandatory statutory licensing?
So Based on our initial analysis of the submissions, there appears to be no strong support for a change from the status quo towards mandatory licensing. However, I would say that there was a range of reasons put forward from stakeholders about why that was the case, and we'll now go through and do some more detailed analysis to provide further advice to the Attorney-General on that issue.
Can you give us an outline of those submissions and the reasons why they don't believe there should be a change?
I think there was 57 submissions made, and all gave quite different reasons. So I think it'd be difficult to give that level of detail at this stage. We need to go and do that further work.
Look forward to the next round of estimates. So what's the next stage then in relation to this group in the process? Where from here?
So, as I mentioned, we've provided the Attorney-General with a summary of what the submission said. Subject to any sort of further direction from her, our intent would be to do that detailed analysis on each of the 57 submissions. We'll focus on the first priority issue first because that was of the most interest to the greatest number of stakeholders, and then we'll focus on issues 2 and 3 as well, but our preliminary focus will be on the inputs question.
And the actual reference group, is there any further work for them to do at this stage?
We need to consider the submissions first, and then we'll decide on next steps for engagement with the reference group.
Okay. I have a few more, so are we going to come back after the break?
Yes, we are. Yeah. We are at 11 a.m. and it's time for us to break for morning tea. We will return and continue this outcome return, so Senator Polly can finish her block of questions. We'll return at 11:15.
I just
Thank
want to
you.
continue with the same officers, if I can. to
Yeah.
the table,
Senator
please. Yes. Just have to wait for the officers to come back. I was hoping you would be able to outline to the committee the purpose of the Copyright International Protection Regulations.
So the Copyright International Protection Regulations provide reciprocal protections for secondary uses of sound recordings to foreign countries in accordance with Australia's international treaty obligations. Secondary use rights for sound recordings are the rights to cause a sound recording to be heard in public. So, for example, playing recorded music in a gym and broadcasting a sound recording to the public. For example, a radio station broadcasting music.
So what additional countries have been added for this sound recording protection?
So we do updates from time to time. So on the 1st of January 2026, Cameroon and Uzbekistan were added to the regulations. We also updated on the 1st of January 2025 with St Kitts and Nevis, and Uganda added to the list.
Would you be able to just give us on notice the full list of countries that come under this protection for us?
Absolutely. There's 123 countries listed,
if you just
so we'll
give
do
that
it on
to
notice.
us, that would be really useful. Thank you. Now, how many countries have been prescribed under the regulation? Is that the same figure?
Yeah, 120. I'll take that on notice just to confirm, but I believe it's 123.
And can I just, my final question is, how has the establishment of the Copyright and AI Reference Group has changed the way there's and improved stakeholder engagement?
So I think the reference group has been a really helpful forum to engage with a range of stakeholders over, a cross-section of interested sectors, and it's really allowed us to mature our understanding of copyright and AI issues, how AI impacts different sectors, and also have all the stakeholders from different sectors in the room when we're discussing these issues as well.
Thank you, Chair.
Thank you, Senator Polley, for your efficiency there. Senator Payman.
Thank you, Chair. Good morning. I've got some questions around the Royal Commission into Institutional Responses to Child Sexual Abuse. It was recommended that the responsibility for the national strategy reside with the Prime Minister's office. When was this responsibility transferred to the Attorney General's portfolio, and what was the rationale for downgrading its priority?
Senator, I'll ask relevant officers to come to the table. I can say that the transfer of the National Office of Child Safety and with it responsibility for the national strategy went from Prime Minister and Cabinet to the Attorney General's Department in 2022 following the federal election. I wouldn't accept the characterisation that it was downgraded as a consequence of that transfer, but given the breadth of issues under consideration and under the strategy, the national strategy, and the work of the National Office of Child Safety, it was considered a more appropriate fit in an organisation like the Attorney General's Department that already had responsibilities around family law, family violence, and women and children, and so it fit well within the department. So it has been an area of significant priority for us as a department. I've met with the steering group that's responsible for supporting us in implementation of the national strategy on several occasions, and it continues to be an area of significant focus in the department.
Is the steering group the same as the National Strategy Advisory Group?
Correct,
cool.
Yes.
Can I please get a confirmation that the Attorney General received a letter dated 27th of November 2025 from the advisory group requesting $1 billion over 5 years for the second action plan?
I'll ask my colleagues to assist in answering that question, Senator.
Yes, thank you, Senator. Yes, that letter was certainly received.
Fantastic. And I was just curious to find out when will the government provide a substantive response other than just an acknowledgement, because I've met with people from the advisory group and they're concerned about what's happening and getting an update for that second action plan.
Yeah. Thank you, Senator. Obviously, there's a lot in that question. I'd start by acknowledging the membership of the National Strategy Advisory Group. That body brings together some of the foremost advocates, experts and leaders from the child safety sector, and they have been invaluable, not just to our department, but to government, state and territory governments on the ongoing work in what is an incredibly complex and difficult area of public policy, and one that's incredibly important to all of us. To your question around the timing of the second action plan, ultimately that is a matter for government. We have undertaken a considerable amount of work to date engaging with the sector, including experts and members of that particular advisory group on the second action plan and where it should focus. The national strategy clearly envisages that a second action plan would build on the efforts of the last few years, much of which were around establishing foundational frameworks and aspects that simply did not exist in Australia beforehand. But ultimately, the timing of a second action plan is a matter for government.
Okay. Minister, would you be able to shed light on, what funding the government is currently considering or committing to the second action plan, given that online harm has grown exponentially and one case of abuse is now reported every second?
Thank you for that question. This is not my direct policy area, but I shall forward your request to the Minister and ask for a response as quickly as possible.
According to the Australian Child Maltreatment Study, 1 in 3 girls and 1 in 5 boys are impacted by child sexual abuse. That's nearly 7 million Australians. Minister, does the government view this epidemic as requiring prime ministerial leadership, or will it continue in the AG's portfolio?
Well, it will continue in the Attorney General's portfolio, because that's the appropriate area for it to be dealt with. Obviously, the issue of child abuse is a serious issue. This government takes that issue seriously, whether it's in the online space or elsewhere, and we'll continue to pursue policies that try to eradicate this issue.
On the first anniversary of the national apology, Prime Minister Albanese said, "An apology cannot repair all the pain in your hearts, your souls, your minds." If the second action plan is not adequately funded, especially in the upcoming budget, what message does that send to the nearly 7 million Australians, the victim survivors of child sexual abuse?
Well, the message that this government would send to those people is that we understand the issues, we are concerned about the issues, and we will do everything that we can to remove this scourge.
And hopefully see a commitment during this budget?
Well, I'm not on the ERC and I'm not the Attorney General, but I'm very happy to refer that question to her for a response.
Thank you. We've obviously heard recent incidents in childcare centres which has shocked the nation. I'm curious to understand what actions will the government take to ensure child safety standards compliance is tied to funding and licensing in childcare, NDIS, sports and recreation and aged care sectors. The department can help.
Senator, I'll ask Mr Collett to talk, but some of the responsibility for that question goes to the Department of Education, but Mr Collett will expand.
The Secretary's anticipated my answer, Senator. Really important questions. what I would say broadly is that a country like Australia needs a multifaceted, multi-portfolio, multi-level of government, multi-sectorial response to something as horrendous and as complex as child sexual abuse. Your particular question goes to areas such as childcare. The Department of Education has very particular responsibilities. Certainly aware that the equivalent of the Standing Council of Attorneys General, the Education Ministers meeting, has led a whole range of reforms in that space, and we work very closely with our colleagues in the Department of Education. But your particular question should be directed there. When it comes to other areas, it's directing to those appropriate departments of state.
Thank you. I think that's all. I'll put the rest of the questions on notice since the Minister will be referring them to the Attorney General. I'm still curious about the funding allocation and when the government will publicly announce the second action plan, so I'll be waiting for that. Thank you.
I'll make sure the Attorney General responds in a timely manner, Senator.
Thank you, Chair.
Thank you for your efficiency there, Senator Payman. Senator Waters.
Thanks very much, Chair. Good morning, everyone. I have some questions about funding for the Family Violence First Nations sector. Do we have folk here for that?
Back to the table.
Thank you. Thanks very much. What proportion of family violence prevention and legal services program funding currently goes to specialist Aboriginal and Torres Strait Islander-led organisations versus programs within larger legal services?
So, Senator, what we can tell you under the National Access to Justice Partnership is how much goes to each, do you mean each part of the sector and how much funding they receive? So the Family Violence and Prevention Legal Services receive $366.8 million of the NAJP funding. But then, of course, community... which are entirely focused on First Nations women and children. Of course, there's also community legal services and women's legal services, some of which would provide services to First Nations women. I don't have exact statistics on how many of their services are for First Nations women. We do have some statistics around the percentage of services CLCs provide generally to Aboriginal and Torres Strait Islander people. We have the Aboriginal and Torres Strait Islander legal services that, of course, provide services to both men and women, specifically First Nations people. And legal aid commissions also do provide a percentage of their services to Aboriginal and Torres Strait Islander women and men.
Thank you. I'm more interested in the proportion of funding that's going to First Nations-led organisations to deliver services to people of all genders within the First Nations community, as opposed to that funding going to more generalist services that might have a subsection. Do you have that figure to hand?
So I don't have an exact percentage of the two combined.
So we could give you the dollar figure for the Family Violence Prevention and Legal Services and Aboriginal legal services. We might have to get some people to go away and do some mathematics to work out the exact percentage that represents of the total funding.
Thanks very much. I'd appreciate you taking that calculation on notice. I'll look forward to those figures in due course. Following the murders of 2 First Nations women in Lake Cargelligo just last month, has the department turned its mind to the adequacy of funding for First Nations family violence services with an emphasis on prevention and early intervention?
I would acknowledge that incident in New South Wales and the shocking circumstances of that. I think what I would say broadly is the focus of family violence prevention legal services is very much that support for people who are experiencing family violence. I think the precise lessons to be drawn from that incident are still a matter to be worked through the Justice Policy Partnership and other mechanisms. and I think we will continue to engage with stakeholders, but I'll just check if Ms Bogart has anything to add to that.
Nothing to add, Senator, other than to add that, of course, there is funding available to family violence prevention legal services, but I couldn't tell you with certainty whether that family had engaged with a service or whether there is a service in that particular area. There's 16 FEPLSs around the country as well as other legal services, but I couldn't tell you with certainty whether there was one in that particular or in the region.
So have those two murders prompted any action from the department to review the adequacy of funding of various relevant programs?
I would say, consistent with some of the questioning that we answered a little bit earlier on, obviously the demand on family violence prevention legal services, community legal services, women's legal services was something that was recognised in the National Access to Justice Partnership, and the additional $800 million with a real focus on women and children's safety that went through the budget last year. I think in terms of whether or not there, in this instance, there were particular challenges about accessing either preventative or assistance or support services or legal assistance. We don't have any clear advice yet, but I think we will continue to work with our New South Wales colleagues around what their understanding of the challenges in that part of New South Wales, and if there's anything more that needs to be considered around access to services.
Okay, you'll continue to consider that. Have you taken any action to reach out to your New South Wales colleagues?
We have a mechanism, we have an ongoing mechanism where we engage with New South Wales through the Justice Policy Partnership. I think we've got a meeting coming up.
It'd be through the National Access to Justice Partnership where we engage, and we do engage regularly with colleagues. I am not aware of any specific engagement on that particular incident. Senator, there are tragic incidents that occur around the country in the context of family and domestic violence, and we do have conversations from time to time where there has been a particular incident where someone wasn't able to access services. We haven't had contact that I know of in relation to this service on this occasion.
Okay, thank you. Could you take on notice for me how many instances of First Nations people being killed, and it's mostly women, as a result of family violence, have prompted you to take any form of action in relation to either raising it with your relevant state counterparts or triggering some kind of internal consideration of the adequacy of funding? Thanks very much for taking that on notice, please. Can I ask now, please, the First Nations National Plan, I understand, is being released tomorrow. Has the department been involved in any part of the development of that plan?
Do you mean the First Nations, the Our Ways, Strong Ways National Plan? Yes, Senator, we have been consulted at length through the development of that, but the Department of Social Services is the lead department on that.
Okay. And did any of your consultations lead to changes?
Changes to the plan? Probably a few minor changes here and there in terms of the way particular things were characterised or particular initiatives that are in place.
Okay.
That we're leading.
Is there recognition that the underfunding of the national plan itself, as well as the continued underfunding of frontline legal support services, in particular to First Nations communities, is there any kind of connection being drawn there between the rates of violence and murders and the state of underfunding? Has the department pointed that out in the course of your consultations on that plan?
Senator, I think the recognition that legal assistance and support services are critical in supporting First Nations women, but women generally, through domestic violence experiences is critical, and that is what led to the work to focus the additional funding under the National Access to Justice Partnership last year, and I think we would always acknowledge that access to legal assistance is critical in terms of responding to, unfortunately, the all too regular incidents of violence and death against women. We don't tend to do inquiries in relation to every single incident. I think it's the broader systemic issues that we respond to and we engage with other departments and with the states and the territories on.
Thank you. In the short time I've got left, I just have a few questions about the use of non-disclosure agreements in workplace sexual harassment cases, as I've asked about for quite a few years now. I understand that the Victorian state government has just recently passed some laws to restrict the use of NDAs in workplace sexual harassment cases. Is the department progressing this through SCAG or any other forum to seek to achieve a national preclusion of the use of NDAs in workplace sexual harassment cases?
Senator, I'm just reminded, actually, the people that are responsible for that are in the next group. It's in our international and security group, where the officers can assist in responding to that. I will ensure that they know that you've asked that question and be ready to answer it. I think the general response I would give, if the chair will indulge me just to be able to answer you, is whilst confidentiality issues have been on the SCAG agenda in the past, we haven't had a specific agenda item since the Victorian government have made their changes. So I think that would need to be a prospective conversation with other jurisdictions. Obviously, the Commonwealth has got its own policy in relation to the use of non-disclosure in any agreements, in particular around workplace harassment and sexual harassment.
Minister, perhaps with my final question, could I ask you to take it up with the attorney whether she will proactively place this issue on the next SCAG meeting agenda to have a uniform approach to precluding the use of NDAs in workplace sexual harassment cases following the Victorian state government moves?
I will, Senator, and I shall make that inquiry and I shall come back to you as quickly as I possibly can.
Thanks very much. Thanks, Chair.
Thank you, Senator Warder. Senator Bly. Thank you very much, Chair. And we'll jump back to AI. And I just had a couple of follow-up questions.
Senator, is it about the department's use of AI or AI policy more broadly? We've just got different people to...
AI policy more broadly. Okay. So, thank you. So I guess just picking up from where we left off and the work that's being done within the department, I guess looking more broadly into law enforcement and noting that the AFP-led Australian Centre to Counter Child Exploitation has had a 41% jump in reports of online child sexual exploitation in the 24-25 financial year. What tools are being made available to law enforcement to try and identify child predators and prevent child exploitation on the internet?
So, Senator, that would be primarily the Department of Home Affairs to respond to that. The AFP is part of their portfolio and would be better placed to be able to talk about what tools are available for law enforcement at the Commonwealth level.
Yep.
We have had engagement with the Australian ACE. I won't try to say all the letters, but ACE over an extended period of time, in particular to learn from them what they're seeing in terms of methodologies that are used by predators and whether or not that requires law reform change, and there has been some change. I would note that to the extent that we have responsibilities, it's in the next group, the International and Security Group.
So that will be where any changes, so I guess, and that's where it'll sort of get to. Is there anything precluding, I guess, at your department level law enforcement agencies using a range of things like Clearview AI in an Australian jurisdiction.
So I think I'd request if we could carry on this conversation
Certainly.
when the International Security Group are here.
Very happy to in the next part. Thank you.
Thank you.
Sorry, we have caught the chair. That was all that I...
Oh, we're done.
Yes, we're done. Thank
no
you.
more questions in this outcome?
Not from me.
Excellent. All right, I should get the right script in front of me. All right, so that's all the questions we have for the Justice and Communities Group and the Closing the Gap outcomes. So we will now, so thank you for your time this morning. We will now move to the Integrity and Security Group. And I'll give the call to Senator Scarr, and noting that we're probably waiting for the correct officials to come up.
So my first set of questions are in relation to the Royal Commission branch.
People to come to the table. So I think you just caught us. I think we've gone through the previous group a little bit more quickly than we'd anticipated.
No, that's okay.
I'm sure relevant people are coming in now.
Okay.
Sorry, we're running ahead of schedule, which is unheard of. Yes.
Don't jinx us.
I wasn't going to go there, but
Well, just whilst they're coming up, I might just ask some questions of you, Secretary, and also the Minister.
Thanks, Senator.
So, on 30 December 2025, the Prime Minister cited actual experts and current experts who advised against, at that stage, establishing a Royal Commission following the deadly terrorist attack in Bondi. Minister, can you name the experts the Prime Minister was referring to, and were any of them from the Attorney-General's Department that advised against the establishment of a Royal Commission at that stage?
Senator, thank you for that question. Look, I don't know the answer to that question, but I shall inquire of the Prime Minister and the Attorney-General and come back to you.
If you can. The Prime Minister also suggested that this advice came from heads of agencies. Minister, who specifically was the Prime Minister referring to?
I don't know, Senator, but I shall ask him and come back to you.
Okay, thank you. Secretary, were you asked to give any advice in relation to whether or not a Royal Commission should be established following the Bondi terrorist attack?
no, Senator.
So you weren't asked to give any advice? You weren't consulted?
I was... the Attorney-General's Department was consulted on some draft letters patent once the decision had been taken to establish a Royal Commission, but we had not provided advice previously.
Okay, so just to get that on the record and then I can close out this line of questioning. Yep. The Attorney-General's Department, no one within the Attorney-General's Department, including the branch dealing with Royal Commissions, which has the particular expertise of the Commonwealth in relation to Royal Commissions, the conduct of Royal Commissions, and I've always been terribly impressed by the responses from that branch to questions I've asked in this committee over the last 6 years. No one in that branch of the Attorney-General's Department with particular experience with respect to Royal Commissions was asked to give advice to the Prime Minister when he made the statement that actual experts and current experts had advised against a Royal Commission. Is that correct?
That's correct. Just to be very precise, up until recently we had disbanded that Royal Commission branch because all the recent Royal Commissions had concluded. We retained some corporate knowledge in the department, but we have now very rapidly re-established that branch.
But having said that, Secretary, I mean, the knowledge with respect to the conduct of royal commissions, the circumstances in which royal commissions should be established, letters patent, management of royal commissions, issues such as the timeliness of reporting, all of those sorts of issues within the knowledge of your department. That's correct, isn't it?
That's correct, Senator.
And that's where the knowledge within government sits with respect to royal commissions within the Department of the Attorney-General, correct?
We have responsibility for the Royal Commissions Act, and therefore all those related issues that you've just listed are matters for which we would retain oversight. But obviously, on a matter of such importance, the Department of Prime Minister and Cabinet also play a very significant role in terms of decision making.
But isn't the corollary of that being a matter of such importance that you'd actually get advice from all the relevant government agencies that have knowledge with respect to royal commissions with respect to this particular subject, and that includes the Attorney-General's Department? Doesn't it make it even more important to get advice from the Attorney-General's Department in relation to whether or not a royal commission should be convened, because the Attorney-General's Department is the department with the body of particular knowledge with respect to royal commissions?
Senator, I think I just repeat, yes, we're responsible for, we administer the Royal Commissions Act, and so have a role and have the expertise around Royal Commissions.
Well, Minister, I'm gobsmacked that the Prime Minister didn't seek advice from the Attorney-General's Department with respect to whether or not a Royal Commission should be established in response to the Bondi terrorist attack. And the Prime Minister actually went out and said actual experts and current experts had advised against a Royal Commission, and now we find that the department within the government that has the particular body of knowledge at its fingertips with respect to Royal Commissions wasn't consulted. How could that be the case?
Well, I think the Secretary indicated that particular area of expertise had been disbanded. I don't know when that was, but presumably sometime before the Prime Minister made his comment. Look, I guess we can kick over the traces about what's happened here. I would make the point, Senator Scarr, that the significant fact here is that the Prime Minister did make a decision to call a Royal Commission. He's done that in consultation with the New South Wales Government, which itself had set up a Royal Commission. And you might recall the Prime Minister made it very clear when New South Wales originally made that decision that the federal authorities and the federal government would participate fully and cooperate fully with that inquiry. We did set up an inquiry very, very quickly after that terrible attack in Bondi to put Mr. Richardson in charge of inquiring about what's gone on here. That process has been rolled into this Royal Commission process. So in terms of what the opposition was calling for, we have done what the opposition has called for, and we look forward to a quick and early response by the Royal Commission to all of the issues that have been raised.
But Minister, you recognise it wasn't, I mean, put the opposition to one side. This isn't about the opposition. This is about a response to the greatest terrorist attack, the worst terrorist attack Australia has faced. The Australian Jewish community was calling, beseeching the Australian government to convene a Royal Commission. Legal expert, retired high judges, members of civic society across the board were calling for a Royal Commission to be convened. And the Prime Minister in response said that actual experts and current experts advised against the convening of a Royal Commission. I'm trying to drill down into who were these actual experts and who were these current experts. Who were they, Minister, if they weren't within the Attorney-General's department that actually has the body of knowledge with respect to royal commissions?
With all due respect, Senator, the relevant point here is that the Prime Minister and the government did call a royal commission. That royal commission has been set up under former Justice Bell. It's incorporating whatever was going to take place under the auspices of the New South Wales Royal Commission, and has incorporated everything that Mr Richardson would have otherwise been looking at. So whatever might have led to that process, the fact of the matter is the government has called a Royal Commission. I agree with you. The events in Bondi were absolutely terrible and so un-Australian. The government has tried to have a measured response to trying to get to the bottom of what happened on that day. We have set up the Royal Commission, and I think now the appropriate course of action is to work through in a methodical fashion the processes of that Royal Commission, and the Attorney-General's Department will be of great assistance in that process.
So you recognise that the Attorney-General's Department has expertise with respect to the management and operation of Royal Commissions. It's a great resource for the Commonwealth Government. I again return to the question, why weren't they consulted in the lead-up to the decision to actually announce a Royal Commission? Why weren't they consulted when the Prime Minister was saying that current and actual experts were advising against the Royal Commission?
Well, I can only repeat my earlier answer, Senator Scarr, that having considered all of the issues, having considered it over quite a long period of time, the Prime Minister came to the view that it was appropriate to initiate a Royal Commission. He's incorporated New South Wales into that. He's incorporated the Richardson inquiry into that. And I think the best thing we can do right now for the Australian Jewish communities and the people who are grieving as a result of the loss of 15 lives is to let that organisation do its job. By all means, get the assistance of the Attorney-General's Department, but let the Commissioner do her job. Let's get as quick a result as we can, and let's see the best way forward to end the scourge of anti-Semitism in this country.
Thank you, Chair.
Thank you, Senator Scarr. Senator Polley.
Thank you, Chair. I have some questions in relation to anti-Semitism, hate and extremists, and the legislation that was brought in this year. So what I'm asking is, can you explain how the prohibited hate groups listing regime works?
Sarah Chidgey, Deputy Secretary, Integrity and Security Group. So the prohibited hate groups listing process, and I'll get my colleague Mr Muffet to provide more detail, has a number of steps to it and requires a recommendation from the Director General of Security, the head of ASIO, to the Minister for Home Affairs as the AFP Minister in this case. And then the AFP Minister has particular criteria around conduct that would constitute criminal conduct. So that could include state and territory vilification offences, other conduct that would cause serious harm, the death of a person, and that relates to conduct that is targeted at a group or individuals distinguished by race or national or ethnic origin, as well as then an additional consideration for future risk that the Minister has to consider and also the Attorney General's agreement is required as part of that process as well. And all of that is subject to judicial review, but I can get my colleague to take you through some of those further steps.
That would be good. We're just limited in time, so trying to get through as many before the break. Thank you.
Luke Muffet, Assistant Secretary, National Security and Criminal Law Branch. Look, I think Ms Chidgey has quite detailed worked through the listing criteria. The only thing I'd probably add is the result of that. So when the Minister is so satisfied, the Governor-General can make regulations listing a group as a prohibited hate group. The consequence of that is going forward after that date of listing, there are certain crimes that relate to dealing with that organisation, crimes such as directing its activities, providing support to it, being a member of the organisation.
So in relation to the changes, would groups protesting at a particular country or at a government be captured under this regime?
I think the key thing to go back to is that step Ms Chidgey referred to around they are engaging in hate crimes or other criminal conduct and related that is really targeted at race, religion or ethnic origin. So it's really focusing on that type of conduct. Oh, sorry, not religion, race, national or ethnic origin. It's really focusing on that conduct, not conduct targeting political opinion or other countries or policies of a foreign country.
It's really important, considering the emotion and the tragedy in December, that we have this information clearly on the record for everyone to have a full understanding. So do these laws offer protection to First Nations people? And if so, can you step us through that, please?
So the terms race, national, ethnic origin, the court in different contexts has ruled that First Nations groups form a race, so these laws would apply in that context as well.
Right. So these new laws introduce a new aggravated offences. Can you go through that process of what those offences are and how that will work?
So there are two different aggravated offences introduced by the legislation. The first is one in relation to where someone commits one of the existing Commonwealth offences for advocating or threatening violence, and they do that when they are the leader of a group. When it occurs in that circumstance, there is a higher penalty available because of that aggravating circumstance. Similarly, there is a new aggravated offence included where someone commits one of the offences around advocating violence against a group because of their protected attribute, and they are advocating that children are to engage in that violence. Again, that would raise the penalty because of that aggravated circumstance. Or when they're committing the offence of sort of the dissemination of violent extremism material. Again, if they are disseminating that to children or intending that children are the recipient of that, a higher penalty would be available.
So just to clarify, do these new aggravated offences extend to all protected attributes?
The underlying offences for those are not changed. They do have a range of protected attributes. Broader than race, national and ethnic origin, they include disability, sexual orientation, nationality, various other factors there. So what this does is if you commit one of those existing Commonwealth offences and that circumstance is present, a higher penalty is available.
So what's the purpose of the aggravated sentencing factor? Can you explain that to the committee?
Yeah, so look, that again is a separate measure. So what we've just worked through then is the aggravated offences where you get a higher penalty. The aggravated sentencing factor is really focused on ensuring that a court in sentencing a person, when the criminal conduct they're sentencing them for was motivated by hate because of race, national or ethnic origin, that they take that into account as a factor of seriousness for the offending. So it does not increase the penalty available to the court for that conduct, but it makes sure that they get a higher penalty within that existing range. So that's applying to the broader suite of Commonwealth offences, not the hate crimes offences, because that an element of those offences is hate motivation, so that's already factored into the availability of the penalty, but also the seriousness of the conduct is an inherent part of those offences. This is about committing any other Commonwealth offences.
Thank you. Perfect timing, Chair.
12 o'clock on the dot. That means we are due for lunch. So we will suspend for 45 minutes to take our lunch break. We'll return at 12:45. We'll return with Senator Polley. Perfect, thank you. We'll resume with questions and we'll go to Senator Shoebridge.
Thanks, Chair. Before the break, I think Senator Scarr was asking you questions about the Royal Commission headed by Virginia Bell, and I might just proceed on those questions. Secretary, the Royal Commission into Defence and Veteran Suicide pointed out in their interim report that there were significant problems with the interaction between the Royal Commission Act and statutory secrecy provisions, pointed out that prevented a number of current and former serving members of the ADF from coming forward and giving frank evidence because there was no express protection under the Royal Commission Act from breaches of those statutory secrecy offences that members of the ADF were subject to. Do you remember that in those recommendations in the interim report?
I do remember the issue being raised in general terms. I'd need to refresh my memory around the specifics of the recommendations.
Well, there was then a review of secrecy provisions, protections for individuals providing information to Royal Commissions. Do you remember that being undertaken by the now former AG?
I do, yes.
Well, at the request of the former AG? And I think that reported now more than 2 years ago and recommended that the government consider amending the Royal Commission Act to, and I'll quote, establish a framework that clarifies the application of secrecy offences to individuals providing information to Royal Commissions and establish appropriate protective security requirements for Royal Commissions. Do you remember that recommendation from the review?
I think now that you've articulated it, yes.
All right. Well, then we now have another Royal Commission which cuts right across a whole series of secrecy statutory provisions, whether it's ASIO or the Australian Federal Police, probably a dozen secrecy provisions, maybe more. Yet nothing's been done to fix that. Why not?
I'll see if my colleague can assist.
We are working on provisions to respond to that review of secrecy provisions, but they're not finalised. Obviously, introduction will be a matter for government. And we are also in terms of the establishment of the Royal Commission, working through those issues with AGS as well. So to date, not aware that secrecy provisions generally for all those agencies have been an issue.
Sorry, you say it hasn't been an issue?
Yes, to date.
How do you know? Have you spoken with the Royal Commission? Has Commissioner Bell told you that?
Commission has issued notices to produce and agencies have been responding.
And do you know to the extent to which people are willing to volunteer information to the Royal Commission even though they've got statutory secrecy provisions which maybe, like David McBride, see them in jail for 5 years? Do you know how many people have not come forward because of the statutory secrecy provisions?
So at the moment, the engagement has been with a particular focus on the terms of reference that the Richardson Review had been looking at, and the agencies have been responding.
Well, agencies have been responding, but the agencies are some of the entities that should be under close scrutiny. What about current or former ASIO agents who may want to give evidence to the Royal Commission? They won't have had any increased protections. They'll be facing the same barriers that happened in the Veterans Royal Commission that was pointed out by that Royal Commission.
So
why no protection for them?
It's not possible to comment on that without getting into legal issues, but it's not necessarily the case that secrecy provisions will all work in the same way and have the same issues.
So not necessarily the case. I can tell you now that if someone's a former ASIO agent and they've got evidence that they received subject to statutory secrecy provisions, and someone says to them, oh, it's not necessarily the case you'll go to jail like David McBride, that this exchange is proving why the failure to fix this, as identified by the Defence Royal Commission, is acting in the interests of agencies and the government to prevent perhaps critical information coming forward. This exchange is demonstrating that.
No, Senator, what I'm saying is I'm not going to comment on legal advice, but there are arrangements for individuals to obtain legal advice. What I'm saying is I can't give you legal advice on secrecy provisions, but the Royal Commission has issues to notices to produce, and agencies have been responding.
All right. Well, but it's not necessarily the agencies that's the issue. It's whistleblowers who have information that may harm the agencies, that may tell the truth about the agency's failure to cooperate with other security agencies, to investigate individuals. They're the people who need protecting, not the agencies. You don't understand that, Ms Gigi?
I do, and I'm saying that the individuals will have the ability to access advice and information. I just can't give you legal advice.
Well, the government accepted more than 2 years ago that they needed to fix this so that royal commissions could get the evidence that they need regardless of statutory secrecy provisions. Minister, we've got a Royal Commission now that's cutting across ASIO, AFP, Home Affairs, pretty much every statutory secrecy provision on the books, and yet your government hasn't fixed it like they said they would in accordance with a report that's now 2 years old. Can you explain why?
Senator, I'm just trying to get to the bottom of what it is that you're trying to ask here. The witness seems to be suggesting that there hasn't been an issue so far in the course of these proceedings. If you think there is an issue, particular issue out there, then perhaps you can identify it, because at the moment we're sort of talking in hypotheticals. If there is nobody out there who has a particular problem in that in this space, then there isn't an issue. Whatever might have previously happened at earlier Royal Commissions. I mean, do you have somebody who?
Well, just let's pick someone at random. The ASIO agent who was the subject of an ABC report, who is, as I understand that previous ABC report from some months ago, had significant fear of his life, not being provided by support from ASIO. ASIO at one point deny he was an agent, now say that in a statement that he's a disgruntled agent. He would be somebody who, when ASIO obviously doesn't like him, would be anxious about coming forward to the Royal Commission and giving their evidence, knowing they're at risk of going to jail for a statutory secrecy offence.
Well,
There's someone.
Well, we don't know that individual, and I don't know anything about the circumstances, I have to say, of those particular proceedings. But we don't know whether he is an individual who wants to come forward and give evidence to these proceedings.
And you'll probably never know, or you may never know about him or dozens of others, because they're fearful that if they put their hand up and tell the truth, they'll go to jail, just like David McBride went to jail for telling the truth about an agency. That's the point. That's why your government undertook the review. That's why they said this needed to be fixed for Royal Commissions. And I'm trying to understand why you haven't fixed it. Is it to protect the agencies?
I think in terms of your direct line of questioning right now, I think it is hypothetical, because I don't think we do have anybody who fits into the category that you're referring to. But you've asked the question. It's a legitimate question. I know you're interested in this area. So I will ask the Attorney-General what her view on this is, and I will come back to you.
Well, Ms Gigi, you say that the department's working on this. Are you going to have it fixed before this Royal Commission ends? Because if there's ever a Royal Commission that needs it fixed, it's this one that's looking at the AFP and ASIO.
Senator, timing of the introduction of legislation is ultimately a matter for government, but we have been working on the response to the provisions in response to the secrecy review. Obviously, aspects of that are complex.
In due course, at the fullness of time after the Royal Commission reports. Well, that's very convenient for ASIO, isn't it, Minister?
With respect,
it's very convenient for the AFP
Senator,
to not have those protections in place.
Senator, that is not what the witness said. I think that's not a fair description of what she has said.
Well, it's very convenient for ASIO, though, isn't it? It's very convenient for the AFP that these protections aren't in place so that whistleblowers can come forward and speak bravely and tell the truth without the risk of going to jail. They're two agencies that benefit, aren't they?
Well, we hope that particularly that aspect of these proceedings that has been dealt with by Mr Richardson, we'll get to the truth of these matters. And I personally, knowing Mr Richardson, have the greatest of confidence.
He's not even a member of the Royal Commission.
Well,
we'll come to Mr Richardson later. What's his moonlighting job?
Thank you. It's now a good opportunity to rotate the call, and I will remind senators to treat witnesses with dignity and respect.
Quite unfair.
He's not a member of the Royal
No, thank you, Senator Shoebridge.
Quite unfair to describe him as moonlighting, and I think.
Well, sorry, he's a very expensive.
Sorry, can we please suspend broadcasting?
Like he does.
Thank you, Senator Shoebridge.
Yep, I'm done. Oh, more questions?
No, are you happy to withdraw?
Oh, no, I thought I did, but I'll do it again. I withdraw moonlighting.
Thank you very much, Senator Shoebridge. Senator Scarr.
Thank you very much. I want to return to the role of the Attorney-General's Department in relation to the establishment of the Royal Commission into the Bondi terrorist attack, and also I'll be moving on to subsequent steps you've been undertaking to progress the Royal Commission. So just to let all prospective witnesses know. Secretary, I took the advantage during the office lunch break to go through all the Royal Commissions that have been undertaken whilst I've been a senator. We've had the Defence and Veterans Suicide Royal Commission, which reported on 9 September 2024. The Attorney-General's Department, you provided advice and assistance with respect to that Royal Commission?
I would take the opportunity to clarify that our role goes to the establishment of a Royal Commission, what's required in terms of setting it up, staffing it, the development of legal assistance schemes, etc. The decision as to whether or not to call a Royal Commission is one for government.
But surely, Secretary, I understand the point you're making, but at the same time, given that the Attorney-General's Department has assisted on the Defence and Veterans Suicide Royal Commission that reported on 9 September 2024, the Violence, Abuse, Neglect and Exploitation of People with Disability Royal Commission that reported on 29 September 2023, the Robo-Debt Scheme Royal Commission reported on 7 July 2023, the Aged Care Quality and Safety Royal Commission reported 1 March 2021, the National Natural Disaster Arrangements Royal Commission that reported on 30 October 2020. Given the Attorney-General's Department provided quality assistance with respect to the establishment, the management, from a legal perspective of all those Royal Commissions, it's fair to say that the Attorney-General's Department has a body of expertise, has the benefit of a body of expertise with respect to the establishment and operation of Royal Commissions, isn't it?
I think we obviously have done, we've supported all those Royal Commissions. I think the point of distinction that I was making was we do not generally advise government whether or not it should call a Royal Commission. That's a matter for executive government.
But there's nothing stopping the executive government, if it's seeking advice with respect to whether or not it's appropriate to establish a Royal Commission, to reach out to the Attorney-General's Department for their to obtain the benefit of their particular expertise with respect to the operation of a Royal Commission, is there? You'd provide advice?
The government will provide seek advice from us in relation to any legislation that we're responsible for from time to time, but the decision whether or not to call a Royal Commission is not one that we would generally provide advice. It goes to decisions of government.
But there's a whole range of issues where the Attorney-General's Department has expertise, including with respect to the powers of a Royal Commission to call witnesses, to subpoena documents, the management of a Royal Commission in terms of how it might interact with criminal proceedings that might be on foot. These are all matters within the domain of the Attorney-General's Department, aren't they?
They are things that we can provide advice on, yes.
Correct. And I note that some of the concerns that had been raised with respect to the establishment of a Royal Commission before the government changed its mind in relation to these matters, and bearing in mind the government said that it had sought advice from, quote, actual experts and, quote, current experts. Some of the matters on which they sought advice was whether or not a Royal Commission would provide a platform for hate, and surely the Attorney-General's Department has expertise with respect to whether or not proceedings might be held in camera or in open, how to manage those sorts of potentially difficult issues to manage. That's a body of expertise which is within the Attorney-General's Department, isn't it?
I think there's a distinction between issues that go to potential procedures and processes of a Royal Commission and the question of whether there's an assessment that it may provide a platform. So I think there's a distinction there. We could certainly provide, based on the experience of supporting past Royal Commissions, the different ways in which evidence or information can be provided to a Royal Commission.
Well, I would have thought that's directly relevant with respect to whether or not a Royal Commission could be used in bad faith to provide a platform for hate, how you manage witnesses, how you publish submissions, etc. That's expertise that would be relevant. Let me put it this way, Secretary, if the Royal Commissioner has concerns, if Ms Bell has concerns with respect to those sorts of issues, she can seek advice from the Attorney-General's Department, can't she?
I would make the point that once established, the Royal Commission is independent of the department, and to the extent that we can offer any assistance, we of course do in response to a request.
Correct.
Decisions as to conduct of the Royal Commission are very much the independent decisions of the Royal Commission.
Absolutely.
And the commissioners.
Absolutely, but she can still seek advice from the Attorney-General's Department, and your team will be cooperative and helpful as they always are, correct?
We would be, but at first instance, my experience, I've supported, this is now the fourth Royal Commission that's been on foot since I've been the Secretary of the Department, and it tends to be the exclusive domain of the Royal Commission itself as to questions about how it conducts its proceedings.
Okay. Can I ask, did the department give any advice with respect to the establishment of the Richardson Review? Secretary?
I'd need to check whether or not the Department of Prime Minister and Cabinet engaged with us.
Well, and just for the Hansard record, the Richardson Review, as I understand it, was established within the domain of PM&C, but my question is whether or not the Attorney-General's Department gave any advice with respect prior to the establishment of the Richardson Review.
I think I would need to take that on notice just to make sure, because it's possible that may have come in at different levels in the department, and I'd need to refresh my own memory of when I became aware of the Richardson Review and what I was asked. So if I can take that on notice, Senator, and I'll check with all relevant areas in the department.
Okay. The Royal Commission in relation to the Bondi terrorist massacre has a reporting date of 14 December 2026, which is quite, from my perspective, and I'm not expecting a response to this, quite an aggressive reporting date. So can I ask, where we're up to in terms of the establishment of the Royal Commission, the establishment of a secretariat or whatever you refer to it that's going to support the Royal Commission?
I can talk in general terms and colleagues can assist in specifics, but we moved pretty rapidly to establish the Royal Commission. Obviously, the government appointed Commissioner Bell and the Executive Council approved the letters patent on the date 9th, on the 9th of January. Very quickly thereafter, the Royal Commissioner made some key appointments. Official Secretary was appointed, Counsel assisting, Solicitor assisting. We have assisted them in identifying staff to join the Royal Commission, and I think Ms Williams and De Vries will be able to give you a sense of what that is looking like. We provided accommodation in Sydney for Commissioner Bell to commence operations, but we have now identified the permanent accommodation for them, and we're very hopeful that will be completely fitted out with appropriate technology and security in the very near future. So the Commission itself is functioning, it's issuing notices to produce, it's engaging with relevant agencies and has commenced its operations. And I don't think Commissioner Bell will mind me saying that she immediately on commencement started thinking about planning what she needed to do in order to be able to achieve that deadline.
Yeah. Okay. So just before we hear from you, Ms De Vries, I'm interested to know in terms of staffing requirements, full-time equivalent positions, you're looking to source, budget, any other of those sort of operational matters you can provide us information on, and if there's anything you need to take on notice, just let me know.
Thanks, Senator Scarr. Susie Williamson, De Vries, and the Assistant Secretary of the Royal Commission's branch. Maybe I can start with resourcing. The government's allocated $131.1 million from 25-26 to support the establishment and operation of the Commission. That includes $91.2 million for the Commission itself, which includes, of course, engaging the Commissioner, staff for the Office of the Royal Commission, and that, of course, includes Mr Richardson and his team as members of staff, as well as counsel and solicitors assisting the Royal Commission. Within that, there's also the property infrastructure that the Secretary mentioned. So that includes offices, hearing premises, IT, security costs, counselling services to support those who are engaging with the Commission. And it will also include, of course, support to individuals who participate in the Royal Commission. The department is currently establishing both an independent legal advice service and a legal financial assistance scheme, which you might recall, Senator, have been features of all Royal Commissions since 2014. Those are very much in the establishment phase. There's still a couple of weeks off, but they will be available to people who participate as witnesses. And then, of course, there's an allocation for the department that is $39.9 million, and that resourcing is to help us support whole of government engagement with the Commission and, really importantly, to manage Commonwealth's legal representation.
So how many staff?
For the Royal Commission,
Yeah.
I might have to take that on notice and give you the exact exact figures, Senator Scarr, but it does include, of course, the official secretary and then a number of solicitors.
Take on notice. Yeah.
Oh, sorry. Actually, we do have that. Apologies.
Size that we think the Royal Commission will get to.
Yeah, sure. So the ASL that we're working towards, that the funding provides, Senator, is 64.3 ASL for the Royal Commission itself and 25.4 ASL within the department. So that's a total of 89.7 ASL.
Okay, thank you, Chair.
Thank you, Senator Scarr. Senator Roberts.
Thank you, Chair. Thank you for appearing again today. Good afternoon. What are the legal services directions? Could you explain that, please?
So the legal services directions are established under statute in order to provide an overarching framework for the conduct of legal proceedings that the Commonwealth is party to. I have the experts to the right of me who can talk to that in detail.
Thank you.
Thanks for the question, Senator Roberts. Philip Ing, Acting First Assistant Secretary of the International and Public Law Division. So as the Secretary's indicated, the legal services directions are made by the Attorney General under the Judiciary Act, and they govern, in part, the conduct of much of the Commonwealth legal services.
So the requirements for sound practice in the provision of legal services to the Australian Government?
That's correct, Senator. That's one of the aspects they cover, is in relation to, for example, how the Commonwealth is to conduct itself in litigation, and so it's reflected in one of the appendices to the legal services directions reflects those model litigant obligations.
Thank you. Are they binding, and on whom are they binding?
Senator, the application of legal services directions applies in full to non-corporate Commonwealth entities. There are aspects of the directions that apply to corporate Commonwealth entities who are in a different category, and also just to mention that they won't apply to the Commonwealth Director of Public Prosecutions, which are not covered. They're referenced in a couple of points, but not directly covered.
Thank you. Does non-compliance have to be reported, and if so, by and to whom?
So, Senator, there are provisions under the legal services directions where non-compliance with the directions are reported to the Office of Legal Services Coordination within the department. It remains responsibility on agencies, relevant agencies or named agencies, to assess those allegations of non-compliance, but the department maintains an overarching role in supporting those agencies to deal with to assess and to deal with the complaints that they may have received.
So it's the department's responsibility?
No, Senator, how I'd characterise it was that agencies have a responsibility to notify our department of possible or actual breaches of the legal services directions and to assess their compliance with that. The department has a role in that, in supporting those agencies in meeting their obligations and in addressing non-compliance. So absolutely the department has a role, but the agencies themselves are the ones who, of course, are responsible in running their own cases and where some of these complaints may arise.
So who enforces non-compliance?
Senator, the Office of Legal Services Coordination is not a regulator as such, so so our role here as a department is to support agencies in the assessments they make. They submit what are called agency notification forms to the department that identify both the allegation of the breach, but also where there are instances that the agency would themselves have assessed as non-compliant, the corrective steps that are taken, and the corrective steps they intend to take as well. And so the department plays a role in ensuring and engaging very closely with those agencies to ensure that those steps are taken.
Were the legal services directions applied in the Brittany Higgins mediation and settlement?
Senator, the matter you refer to is a matter that was managed by ComCover, is probably the first thing to say in that instance, but to say that ComCover as a non-corporate Commonwealth entity is required to comply with the legal services directions, and that was managed in accordance with the legal services directions.
So they did comply. Are the legal services directions being applied in Linda Reynolds and Fiona Brown's cases?
Both of those cases are, again, Senator, managed by ComCover within the Department of Finance. ComCover is obliged, as I've outlined earlier, Senator, to comply with the legal services directions in all aspects of the management of those cases.
Were they complied with?
Senator, if your question goes to, is there I'm sorry, I'm just trying to clarify your question, Senator. Is it that whether there's allegations or of non-compliance, or what is it?
Whether legal services directions being applied?
From the department's perspective, the legal ComCover is complying absolutely with the legal services directions, noting that they're managing those claims.
Thank you. Does the Attorney General's Department and the Australian Government Solicitor now accept the findings of 2 senior Australian courts that the workplace allegations made against Fiona Brown were without foundation?
Senator, it's not a matter for us to accept the finding of court judgments. We note the judgment, but those matters dealt with issues. Those proceedings dealt with issues that were separate to the settlement that we had a role in administering.
Thank you. What are the total legal costs incurred to date by the Australian Government Solicitor and external legal assistance by the federal government in relation to Fiona Brown's claim against the Commonwealth? What are the total costs?
We'd need to take that on notice. It's a matter for ComCover, in fact, I would request that question be put to ComCover. They are the instructing agency.
What external legal assistance has been engaged, from whom, what rates have been agreed, and who approved any extra rates?
Again, that is a matter for ComCover. They are the instructing agency.
Who does ComCover report to?
The Department of Finance. They're a division within the Department of Finance, although set up as a separate entity.
Thank you. The bureaucracy is so big we can't comprehend it all. Why is the Commonwealth not mediating with Fiona Brown?
We couldn't provide a view on that, Senator. I think that goes to the conduct of that matter, which is a matter for ComCover.
Moving to Linda Reynolds.
Legal proceeding, of course, would not be appropriate for us to comment.
Does the Attorney General, the Attorney General's Department and the Australian Government Solicitor now accept the findings of 2 senior Australian courts that the workplace allegations made against then Minister Reynolds were, in the words of Justice Lee, quote, without reasonable foundation and verifiable fact, and Justice Toddle, quote, objectively false and misleading, end of quote, and, quote, dishonest?
Senator, I return to my previous comment. It's not a matter for us to accept or not accept comments that are made by judges in the course of their decisions, and those proceedings related to or address separate issues to the issue of the settlement of Ms Higgins' claims.
Have these judgments that I just referred to given you cause to review your actions in relation to then Minister Reynolds over the Brittany Higgins settlement?
I think I just repeat my previous comment that the settlement in relation to Brittany Higgins' claims went to related but slightly different issues than to the matters that were the subject of the 2 judicial observations that you've referred to.
Is the current Reynolds litigation being handled as an exceptional case or a major claim, and who made that determination?
No, I think... Oh.
It's a matter for ComCover again. I'm not sure what you're referring to, Senator.
Senator, I will say it's been reported as a significant issue under the legal services directions.
Thank you, Chair.
Thank you, Senator Roberts. Senator Payman.
Thank you, Chair. Good afternoon. My line of questioning is around glasses fitted with cameras, in particular Ray-Ban's Meta Wayfarer glasses. And from what we've read and understood recently, they're being used to covertly record people without their knowledge, often for social media posts. Now, in terms of both recording audio of conversations and filming them, could you walk me through the federal legalities of recording someone covertly without their permission?
So I think it obviously raises privacy issues. So I'll ask the colleagues who are the expert in this space to talk to that issue.
Thank you.
Might just say, Senator, we can obviously talk about the provisions of the Privacy Act, but couldn't comment on its application in particular cases. And the regulator is the Office of the Australian Information Commissioner and Privacy Commissioner.
Thank you.
Thanks, Senator. Would it be possible for you to repeat the question while we were walking up?
Yeah, no, that's totally cool. I just wanted to get some information about the federal legalities of recording someone covertly without their permission, in particular when you've got Ray-Ban's Meta Wayfarer glasses that's doing that, both recording audio of conversations and filming.
Thanks, Senator. Catherine Fitch, Assistant Secretary for Privacy Reform Task Force. Just in general, I understand there was a question on notice asked about this and answered by the department in writing at the last hearing, so I'll try to find that for you to give you some more information. But generally speaking, the Federal Privacy Act applies to regulated entities, not to individuals directly. So if a person was wearing one of these smart glasses and videoing somebody, they wouldn't be subject to protections under the Federal Privacy Act. There are, I think, some state and territory laws which might apply, like relating to surveillance technologies and those sorts of things, but generally speaking, it would be outside the scope of the Privacy Act, with the exception of the newly legislated statutory tort that the government brought in its first tranche of privacy reform. So commencing, the legislation was passed at the end of 2024, but the new tort came into effect in June of last year, and where there are thresholds met for the tort, which relates to serious invasions of privacy and has a range of other criteria that must be established, then that could potentially apply.
So individuals cannot make complaints, but what happens on a federal level? Are there penalties for individuals who record others without permission?
It's not something that comes within the purview of Australia's federal privacy law. I can't speak to the content of state and territory privacy laws, but individuals wearing those technologies are not subject to the Privacy Act. Might be, if there was the possibility for an entity that was covered, there might be different rules that would apply, but that's not what you're asking.
No. And without going into, I guess, details of specific cases, how many complaints of recording without consent have been made in the last 12 months?
Senator, it's difficult to say. It might be a question that you could explore further with the Office of the Australian Information Commissioner this afternoon, but because they're not, as I've said, they're not within those situations that you're asking about are not within the purview of the Privacy Act, then technically that they wouldn't have jurisdiction to accept and investigate a complaint if it related to an individual's conduct.
Okay, and so can we say that the Attorney General's Department has no, I guess, not intention, but if it doesn't fall within your purview, does that mean you cannot take any action to address this issue?
Well, I think the question you're asking is a slightly broader one. What the evidence that I'm giving you is just that it's not a matter that's covered by Australia's federal privacy legislation. That's not to say that there might not be other relevant statutes that would apply, but I think primarily in the case you're referring to, it's state and territory law, not Commonwealth law.
Okay, so yeah, so federally there isn't any protections for individuals who may be subjected to covert recording of their audio or being filmed, and that's something that falls within state and territory jurisdictions. Is that what you're saying?
I mean, I think, Senator, that's largely correct, although if it were to hit the seriousness thresholds and the other thresholds that have been legislated as part of the new privacy tort, then that might apply, but I'm not able to speak to specific situations.
Sure. What are those thresholds? Can you outline what would meet those thresholds? How serious must the offence be, or, especially if it's not within the federal jurisdiction?
Yeah, sure. Thanks, Senator. The new statutory tort for serious invasions of privacy by and large applies where the privacy invasion was serious. The plaintiff had a reasonable expectation of privacy under the circumstances. The conduct by the defendant was intentional or reckless, so not merely negligent conduct, and the public interest in the plaintiff's privacy outweighs any countervailing public interests. So that's a balancing test, and there are factors in the legislation that go to outline what should be considered.
And how does one go about making such complaints to see whether they meet the threshold or not?
They would, in the usual course of events, seek some legal advice and then make a claim to I think the jurisdiction applies in federal courts and state and territory courts also.
Okay. I think there's a few loopholes there, but thank you for the responses. Thank you, Chair.
Thank you, Senator Payman. Senator Shoebridge.
Thanks very much, Chair. To return to the Royal Commission, there is widespread concern amongst that part of the community who want to be able to advocate for a free Palestine, for human rights, for the end of the genocide in Gaza, about the government having referenced the government's definition of anti-Semitism being the IHRA definition in the preamble to the Royal Commission. Was that what is the effect in the Royal Commission of that reference in the preamble? Because I note it's not a defined term in the Royal Commission. What's the effect of it?
It means the definition is a matter that the Commission, under the letters patent, would have regard to.
All right. But there are a number of actual defined terms in the Royal Commission, in the letters patent. It's not a defined term. What is the community meant to make of that? Have regard to, what does that mean?
Well, I think it's plain language, meaning that the Royal Commission should reference that definition in terms of its consideration of anti-Semitism.
But unlike the defined terms, not bound by it as a defined term. Well, I'm trying to work out what the distinction is. There's express defined terms, and then there's a reference to the government having adopted the IHRA definition. What's the difference?
Well, I think Ms Chigi has summarised it by saying it would be a definition for the Royal Commission to have regard to.
All right. Now, the great bulk of the concern about the IHRA definition isn't the definition itself, but the multiple examples that are included alongside the definition include those which conflate criticism of Israel with anti-Semitism. What's the situation in relation to the letters patent to the examples outside of the definition?
Well, the reference is to the definition,
not the examples.
And it's to the fact that the government has adopted it, but the Royal Commission obviously has the scope to make its own determinations and recommendations.
Indeed. Commissioner Bell can form her own view about it, but to be clear, Secretary, and I cut you off at the end there, I'm sorry for that. The reference in the letters patent is to the definition only, and it doesn't pick up, I think on a plain reading of it, it doesn't pick up the examples. Is that your position?
That is my position, yes.
All right. And is that mindful of the federal court decision of Wertheim and Haddad, which was one of the sort of legal lines of authority which clearly distinguishes between criticism of Israel and anti-Semitism. Is that mindful of at least that line of authority?
Certainly we are aware of that decision, yes. Yes.
All right. All right, thank you. Could I ask about the, and it may need to, I'm moving off the Royal Commission for the moment.
Okay, thank you.
Was your department asked by the Prime Minister or the Foreign Minister to provide any legal advice either before or after Israel's President Herzog was invited to come to this country?
I'll ask relevant officers to come to assist.
So were we asked by who?
Well, we asked by either anyone, the Prime Minister or anyone to do with the Prime Minister, or the Foreign Minister or anyone to do with the Foreign Minister. That was my initial request.
And we have provided legal advice to Department of Prime Minister and Cabinet and the AFP, and provided a copy of that to Department of Foreign Affairs and Trade.
Sorry, Ms. Chigi, I didn't hear that. Maybe the microphone's not working.
So we have provided legal advice to the Department of Prime Minister and Cabinet and the AFP, and a copy of that legal advice was provided to the Department of Foreign Affairs and Trade.
All right. Was that at the request of the AFP and or the Prime Minister and Cabinet?
Senator Nathan Kenzie, Assistant Secretary, Office of International Law. We were involved in meetings convened by Prime Minister and Cabinet, at which AFP attended as well, and certain issues were raised in those meetings which prompted the request for views from this office.
Okay. What matters were raised?
Well, Senator General Counsel Jessie Clark, Office of International Law, we wouldn't comment on the content of our legal advice, Senator.
Well, I'm not asking you to comment on the content of your legal advice. You said matters were raised. Matters were raised in the meeting. My assumption, Mr. Kenzie, was that matters were raised by either PM&C or the AFP or some other agency. So I'm not asking you about what you said in response. I'm asking you what those matters were that were raised.
I think discussing those issues inevitably takes us to the content of legal advice.
Well, it absolutely doesn't. The nature of the matters that you're asked to provide that prompted legal advice is not disclosing the legal advice. No one could pretend that. So again, Ms. Kenzie, you were there. What matters were raised that prompted the legal advice?
Senator, I'm sorry, but I agree with Ms. Chigi's assessment, and going to any of those specifics goes to the issues that we were asked to provide advice on.
Well, I'm going to press for an answer. You heard the chair at the beginning of this thing. You heard that. Let me finish my point.
Well, I've got a point of order.
Well, I'm in the middle of a sentence, and I was just.
You've got to hear the point of order first.
Point of order, Chair. The Secretary has given a response to Senator Shoebridge's question. He can, in his words, press for an answer, but he's simply going to restate the question, presumably in pressing for an answer. And I'm just not sure that's we've got limited time.
Yeah.
I'm not sure it's going to be helpful for people just to ask the same question again and again.
This is the advantage of.
I do tend to agree with Senator Scarr in that the officials are being clear at the table that in providing that answer, that it would be going to the matters that were provided in the legal advice.
This is the advantage of waiting for the sentence to end, because I listened carefully to your opening address, Chair, and your opening address said clearly that officials have to answer questions, but if they think they have some privilege or other reason to not answer a question, that they need to raise a public interest immunity response in response to that and not simply just avoid answering the question. You said that as Chair. I think it was important. So I'm pressing for an answer, and if they don't wish to answer it, they have to raise a public interest immunity claim consistent with how you started this meeting. So I'm pressing for an answer. What were the issues that were raised in the meeting that Mr. Kenzie referenced that prompted the legal advice?
So we would then need to take that on notice, Senator, because any public interest immunity claims properly a matter for the Attorney-General. Obviously, it's a long-standing position that officers don't disclose the content of legal advice.
Yes, and to be clear, my question is not for the content of the legal advice, but for the matters that prompted the obtaining of the legal advice. And we could revisit that again if you want. That would be useful.
And our evidence, Senator, is that disclosing those issues will disclose the content of our legal advice.
And so it sounds like from what I've heard is that the officials at the table are going to consider what they can provide and whether they need to make a public interest immunity claim in response to your questions.
Thank you. Now, the AFP said that the legal advice they'd been given, which is obviously the advice you gave them, was that they couldn't prosecute President Herzog because he had immunity as a head of state. The AFP, obviously, having disclosed the legal advice, matter for them, they're your client. Was that the advice you gave them?
We won't go to the content of any advice that we provided.
Does President Herzog, in the eyes of this government, have legal immunity even for the most heinous crimes of war crimes and complicity in genocide? Is that the government's position, that President Herzog has immunity even for those most heinous crimes?
We will not provide legal advice to the committee.
All right.
Thank you. Now seems like a good time to rotate the call, given we are at our time. Thank you, Senator Shoebridge. Senator Scarr.
Thank you very much. I want to return to the Richardson review, so issues relating to royal commissions, etc. So if the team could return, and I might just start asking the question whilst you're coming up. Has the Attorney General's Department resolved the issue, or have you given advice with respect to the resolution of the issue with respect to how the Richardson review will dovetail with the Royal Commission that's been established by letters patent?
Yes, Senator. So when the letters patent were issued, those terms of reference in the letters patent covered all the matters that Mr Richardson had been asked to look at. So from the establishment of the Royal Commission, it encompassed the Richardson review and the issues it was to look at. And then to formalise that, Mr Richardson or other staff are members of the Royal Commission, and the Royal Commission processes have then also are underway in terms of notices to produce, etc.
Okay, so is it a fair summary to say that the Richardson review has been subsumed into the Royal Commission?
That's right.
Okay, all right. Has the department ensured that the council assisting the Royal Commission has the necessary expertise to effectively address the unique, complex issue of anti-Semitism? So, and just to provide a bit more context to this question, there have been some matters raised by members of the Australian Jewish community around the particular lived experience of anti-Semitism and the benefit of a Royal Commission having an insight that's looking at anti-Semitism, amongst other matters, the benefit of a Royal Commission having expertise in that regard. How's that being addressed?
Senator, I would note that any decisions relating to the engagement of council assisting are the exclusive independent decision of the Royal Commission and the Commissioner, and it was a matter for Commissioner Bell as to who to appoint. Once the Commissioner has made the decision as to which council assisting they wish to engage, there is a formal step in the process where the Attorney General endorses that decision, but it is the decision of the Royal Commission itself.
Okay. Has Ms De Vries, have you given any assistance with respect to staffing of the Royal Commission with respect to potential staff with particular expertise, experience in relation to anti-Semitism? Have you been asked to find staff with that cohort of experience?
Certainly, we have a register for people to express interest, both in working in my branch within the Attorney General's Department, but also within the Office of the Royal Commission. So that will be a matter for the Official Secretary of the Royal Commission to determine staffing, but also training requirements as well. I think members of the committee have asked about training requirements, and they're currently under consideration.
So we've asked, you're correct, we have asked questions around training requirements. I'll put it generally across the department with respect to anti-Semitism, and the Secretary gave some very useful responses to that. My more particular question is whether or not, in discharging your duties in providing staff for the Royal Commission, whether or not one of the aspects of those duties, one of the matters you've had to consider is finding people with particular expertise in relation to the scourge of anti-Semitism.
It's probably just worth clarifying, Senator, that the Office of the Royal Commission engages staff for the Royal Commission independently. We obviously provide support on the processes for that, but the decisions about staffing are made by the Royal Commission itself.
Okay, all right. I won't belabour the point. Have you had any discussions with the Royal Commission, or have they asked for any assistance with respect to making sure that the Jewish community remains central to the set-up and work of the Royal Commission?
I think the way I would answer that, obviously the way the Royal Commission is conducted, it is very much a matter for the Commissioner and the Official Secretary, but I think there are a whole range of mechanisms that could be employed to engage with relevant stakeholder groups, whether it's requesting submissions. It may be, you've probably noticed in other Royal Commissions, there's been roundtables of relevant stakeholders. There's experts that can be brought in to provide particular evidence. So I think there's a broad toolkit that's available to a Royal Commissioner. We've certainly briefed the Commissioner and the Official Secretary on the availability of those. So I think I would say I feel quite confident that the Royal Commission will be reaching out to relevant stakeholder groups to ensure that it's well informed in its consideration of issues associated with anti-Semitism and social cohesion. Okay.
I want to move on to a different topic now, and that's the Combating Anti-Semitism Bill, which was originally presented as an omnibus bill and then was then split into two different bills and was passed in January with the support of the government and the Liberal Party. So, again, reiterate my respect and regards for all members of the department who are involved in the preparation of that bill. I want to put to you a statement which former Home Affairs Department Secretary Mr Pizzullo made during the PJCIS inquiry into the bill, and he basically said that, and I'll quote, "There is no way that the package," and he's referring here to the legislative package, "in its form could have been developed in the time that's occurred." And he also referred to at least elements of the proposed laws being, and to use his words, in bottom drawers, end quote, for years, and then being taken out of the bottom drawer and presented. Ms Chidgey, how would you respond to that characterisation of the legislative process?
We did do the work on the legislation urgently following the attack in Bondi. So it was very much focused over that period of about a month.
Okay, so
Senator, I was hoping I could jump in and answer that, because I am aware of those comments.
Maybe I should have put it to you first, Secretary. Ms Chidgey always handles these things very diplomatically. Well, see how you go.
I don't know how I should respond to that, but I think I am aware of Mr Pizzullo's comments. But in this instance, I would note that this legislation and the work on it was done urgently. There wasn't a pre-prepared package of legislation. The team responded to the decision of government to proceed urgently with hate speech legislation, and they are working very closely with the Office of Parliamentary Counsel, who should really be called out for the extraordinary work they did in drafting the legislation and working with this team and others here. But I can hand on heart say that they developed this legislation. I think the word from scratch is right. I mean, there may have been some thinking in some other spaces, but essentially that legislation was developed in that time period.
Okay, I understand your answer. Just one final question, because the Chair needs to rotate the call. Just to drill down into that, and I must say, when I saw and I was watching the inquiry and Mr Pizzullo gave that evidence, and I was thinking of different parts of what was initially presented as the omnibus bill, and so if I can just drill down into the different parts and just get your confirmation that each of those different parts was started from scratch, because there was the prohibited hate groups part, if I can put it in those words, which was eventually passed. There was the racial vilification offence, which was excised from the bill, and the bill was split, and then there were the gun control-related laws, customs-related laws. Was each element of the legislative package as originally presented in the exposure draft started from, to use your word, Secretary, from scratch?
I'll ask Ms Chigi to answer that, recognising that the firearms and migration element were done by our colleagues in Home Affairs, and we can't answer to that.
Yes, so just speaking to the criminal law changes in Schedule 1 for which we were responsible, the development of the provisions very much did start with instructions to Office of Parliamentary Counsel shortly following the attack in Bondi. There were sort of one aspect, I think, on the hate symbols and some of the improvements to those provisions. We'd engaged with the AFP, actually had some advice that had come through from them just earlier in December, but we hadn't, the work really on the solutions to address those issues we very much did as part of this package.
In relation to the hate symbols, and that was based on the experience of the AFP attempting to enforce the law, correct?
That's correct.
Okay, understood. Thank you, Chair.
Thank you, Senator Scarr. Senator Shoebridge.
Thanks very much, Chair. In addition to President Herzog, there's a significant delegation coming from Israel at the invitation of the Prime Minister. One of those individuals is Doron Olmog, former Major General in the Israeli Defence Force, who had a warrant issued for his arrest by a UK magistrates court because there was credible evidence put before the magistrate that Mr Olmog had breached the Geneva Convention Act 1957 in relation to extensive destruction of property carried out unlawfully and wantonly in 2002 in Gaza. Are you aware of that warrant having been issued to then Major General Doron Olmog by a UK court?
We've seen media reporting.
All right. Well, was there due diligence done by the Attorney Generals about the fact that the UK, a magistrate in the UK, thought it appropriate to issue a warrant for the arrest of Mr Olmog for breach of the Geneva Convention because of the evidence about his extensive destruction of property carried out unlawfully and wantonly in the Gaza Strip?
So, Senator, I think what I would say is that the Attorney General's Department doesn't do vetting of foreign visitors to Australia. So those matters aren't something we can comment on.
Did your legal advice that you gave to the AFP and to Prime Minister and Cabinet deal with Mr Olmog former Major General who was the subject of this warrant under the Geneva Convention?
I think that would go to the content of our legal advice, and we can't assist with that.
Well, you'd agree with me, wouldn't you, that he's not covered by any immunity protecting a head of state, is he?
Senator, we don't give legal advice to the committee.
Well, did Home Affairs seek any advice from the Attorney General's Department before permitting former Major General Almog into this country, given that he was the subject of a warrant issued by a UK court for breaches of the Geneva Convention because of the appalling destruction he did in Gaza in 2002?
Senator,
Did Home Affairs seek advice?
Obviously a more appropriate question for Home Affairs. I don't know when they're meeting, but tomorrow. There you go. There's an opportunity to ask that question.
Minister, I really appreciate the suggestion, and I will also raise it with Home Affairs, but I'm asking now this agency whether or not they had a request for advice from Home Affairs before their minister, the Home Affairs Minister, permitted Doron Olmog to enter this country, given a UK court was satisfied that there was credible evidence he'd been in breach of the Geneva Convention.
Senator, I think Ms Chichi's answered your question. She's described the legal advice we gave. It was provided to PM&C and the AFP and copied to DFAT.
Yeah, but that was the advice that was generated because of the issues raised, the now secret issues raised to Mr Kenzie in that meeting. I'm asking whether it's at that meeting or at any time otherwise, Home Affairs has sought the advice of the Attorney General before permitting this former Major General, who a UK court found credible evidence that he'd breached the Geneva Convention, was permitted into this country.
Senator, I mentioned that advice because that's the advice that we've given. That's the only legal advice we've given in relation to the visit by the President and other delegates coming at it as part of that visit or associated with it.
And so Home Affairs hasn't requested any legal advice from you about the visit of President Herzog or any of his entourage. Is that the situation?
Well, Senator, again, that'd be a matter you could raise with Home Affairs. What our evidence is we've given one advice and I've identified to whom that was given.
All right. But I'm asking you whether Home Affairs asked advice of you. You may not have given it. You may have had a reason not to give it. I don't know. Have they requested that advice from you?
I am not aware of such a request, Senator, but you're better off asking Home Affairs.
But see, if they'd asked you, you would know, the department. And so you keep telling me that I can ask Home Affairs, I will. But I'm asking you whether or not this department received an advice from Home Affairs. Only you know if you've received a request from Home Affairs. Have you received such a request from Home Affairs?
Not to my knowledge, Senator.
All right. Thank you. Are there occasions in the last 2 years where Home Affairs has sought legal advice from your department secretary about legal issues involving somebody who's seeking to visit Australia?
Senator, we would need to take that on notice. We engage with the Department of Home Affairs on a daily basis on a range of legal issues, so I would not be able to give you an accurate answer.
All right, but I'm asking about, perhaps, well, by all means take it on notice, but I'm asking, it's not a generic, it's not an at-large question, it's about advice being sought from Home Affairs before someone enters the country in the last 2 years? If so, on how many occasions and in relation to which individuals or parties?
We'll take it on notice. I don't think all those details will be something we could provide without disclosing it, and we'll just have to see how feasible it is because that's reasonably open-ended.
Well, you see, I mean, the reason I'm asking you is if Home Affairs are doing this regularly about much lower profile visits, but they choose not to do so in relation to an incredibly high profile visit, I think the community has a right to know. It seems to me, Ms Chidgey, your evidence is this is happening all the time, and therefore it might be onerous to tell us about all the occasions that Home Affairs is asking you legal advice about invitations, but they accidentally, somehow or other, chose not to ask about Major General Olmog and others.
With respect, Senator,
Yeah,
I think
I don't
you've drawn a
think that's
conclusion from Ms Chidgey's
Am I wrong?
comments that is not accurate. We have said that we'll take it on notice. I would also note that the Department of Home Affairs has its own large internal legal division that provides internal advice.
But when it comes to compliance, Australia's obligations under international law and compliance with international law, your department has the principal responsibility for that, doesn't it?
Shared with the Department of Foreign Affairs and Trade, obviously the Department of Home Affairs, in the context of its migration responsibilities, has to turn its mind to a range of issues associated with Australia's international legal obligations.
And Senator, I'd just add that there are times where the department provides general advice on international law principles and obligations, and then a department may choose to use that in different factual scenarios.
Well, have you provided general advice on Australia's obligations to ensure compliance with the Geneva Convention, being the Geneva Convention Act 1957, under which a UK court issued an arrest warrant for Mr Olmog, who's currently here?
Senator, I think that is very broad. We've taken on notice to see what we can provide you without disclosing the content of individual legal advices. Obviously, from time to time, the Office of International Law has provided advice on Geneva Conventions generally.
Right. Well, have you provided advice on the Genocide Convention, or that Geneva Convention, or war crimes in relation to the conflict in Gaza to any government agency since the 7th of October 2023? And if so, under which such international laws and to which agencies?
We'll take that on notice.
Thank you, Senator Shoebridge. Senator Blyth.
Thank you very much, Chair. And I'm just going to ask one question on the Royal Commission and then shift over to mandatory minimum sentences for child sexual abuse. So sorry, just for this one clarifying.
Perhaps you can ask the Royal Commission question. We may be able to assist. Oh,
yes.
I didn't realise the team was so close at hand. There we go. They beat me.
Thank you. Just in relation to the terms of reference for the Royal Commission, are you aware of whether it is going to look beyond just anti-Semitism within Australia, or look more broadly at social cohesion more generally? Is that?
Well, I'll start off, but
yes.
The letters patent have a point in there about social cohesion in Australia. I'm sure someone will bring up the exact language. There is an expectation that the Royal Commission will need to look more broadly at social cohesion in Australia, and I think Ms Chidgey might have the exact language called up on her screen now.
So there is scope for the Royal Commission to make any recommendations contributing to strengthening social cohesion in Australia and countering the spread of ideologically and religiously motivated extremism in Australia.
Okay. So, and I guess that, so it could potentially go from anti-Semitism into Islamophobia and cover a whole range of...
Its primary terms of reference sort of very focused on anti-Semitism, but there is scope to look further to social cohesion more broadly.
Excellent. Thank you so much for that. And so going into mandatory minimum sentences for child sexual abuse, there was a bill before Parliament in 2025 that wasn't successfully passed, which was recommending mandatory minimum sentences for Commonwealth child sex offences. I've already sort of mentioned earlier that there has been a 41% spike in online child exploitation cases reported or received by the AFP. Can I just ask what factors the department considers when advising government on mandatory minimum sentences for Commonwealth child sexual abuse offences, particularly given the rise, and looking at cases like DPP v Maloney 2024, where sentences fell well short of community expectations?
Senator, we engage with the Australian Federal Police, Commonwealth Director of Public Prosecutions, about sort of any issues in how the criminal offences and penalties are functioning. We did a review of mandatory minimums, I think in the last couple of years, that looked how they were, whether they were sort of functioning in accordance with the intent of the legislation that introduced those mandatory minimums. Broadly speaking, partly because that period of review had occurred over the COVID timeframes, I think it was too early to entirely assess them fully, but we found that broadly speaking they were operating as intended. I think with mandatory minimums we also do look at a range of perspectives on their effectiveness. So there's obviously a lot of literature on mandatory minimums, some of those issues around the potential impact on offenders pleading guilty and convictions that have to be weighed up alongside sort of the limitation on judicial discretion.
Thank you. Looking at the Australian Institute of Criminology, where they confirm that child sex offenders have a reoffending rate as high as 54%. Do you see mandatory minimum sentences in something like child sex offences as acting as a deterrent to that?
So I don't think we could give an opinion on that. On that issue. There's obviously a lot of academic literature on the extent to which sentences act as a deterrent. I think it's probably fair to say there's differences of views on that issue.
Okay, it's not something you take into account though when providing advice on how things are working when you're assessing and reviewing and evaluating?
I think we would just say that it's not clear that a mandatory minimum would necessarily have that effect.
Okay, and I guess this is probably going to go on if people are released earlier because there is no mandatory minimum, and at the moment that's sort of what's happening is the average is well below what the recommended mandatory minimum sentence period was. Do you take into account the reoffending that could happen in terms of, so if someone's released earlier and they're 54% likely to reoffend, do you take that into account as well, or that's not part of what you're looking at in reviews either?
Yeah, so I think obviously the department's role relates to the legislation rather than the management of any individual cases, other than that we do have a role with federal offenders and parole decision making. The mandatory minimums that are applicable at the moment do take account of a sort of two-strike application of those mandatory minimums, which has an application obviously where there is recidivism.
Okay. So, and just looking at this, the Victorian Sentencing Advisory Council research showed that the medium sentence for sexual penetration of a child under 12 was just 4 years, and that's despite the offence carrying the same maximum penalty as rape. In relation to minimum mandatory sentencing federally, did your department provide any advice to government on why that would be a good deterrence and promote community safety at a Commonwealth level?
So, Senator, I'm not sure whether you're sort of crossing from state to federal offences and sentencing. So
no, all federal. So where we're looking at the child, so there was a bill that was before Parliament looking at mandatory minimum sentences for child sexual abuse that didn't go through Parliament, so it wasn't successful. But I'm just wondering what advice the Attorney General's Department was providing to government in relation to that, and whether all of these things were taken into account.
Can I just check on the figures, whether they were for federal or state offences?
So for federal offences, it carries, this is what I've sort of got here, is that it carries the same maximum penalty as rape.
Sorry, I thought you had the, which is different to
the Sentencing
sort of
Advisory
actual
Council
sentencing.
research was a state-based research, but it's looking at federal offences. So state-based research looking at federal offences.
Senator, I wonder whether we just undertake to take that on notice.
Certainly, I can provide.
It's an important area, and I'd like to ensure that we gave you accurate advice.
Yes, certainly. What I can do is a lot of these are quite specific, so I'm happy to provide the rest of those on notice to assist.
Thank you.
Assist you with that. Thank you.
And Senator, I'd just say that the review that we did had a lot of information on all the sentences under the existing
Is that available
regime.
publicly?
Yes,
the
it
review?
is.
Okay, fantastic.
We can provide that link on notice.
That would be fantastic. Thank you. Sorry,
Thank
and that was
you,
1 minute.
Senator. Senator Cox.
Thank you very much, Chair. I'd like to ask some questions of the Pacific branch. Good afternoon. I understand the department has done some work to support Australia's engagement with the Pacific. Can the department please provide an overview of the strategic focus of the Pacific branch and outline how this work complements the work in other departments?
Thank you very much, Senator. Rebecca Vontotov, Assistant Secretary of the Pacific Branch at Attorney General's Department. The department has a really long and proud history of working with our Pacific partners in the law and justice space. We've had a particular focus on criminal law and justice and that sort of side of things. It extends for over 40 years. We've been members of and funding and logistical supporters of the Pacific Islands Law Officers Network, which is a network of senior law and justice officers, so attorneys general, solicitors general, heads of public prosecutions across 19 Pacific jurisdictions that's been operating for over 40 years, as I said. That network chooses a series of priorities to focus its resources and significant efforts by Pacific lawyers on over time. Currently, those priorities have been, since the last 2 years, cybercrime, sexual and gender-based violence and anti-corruption efforts, as well as support ongoing for Pacific legislative drafters. A substantial part of the work of my team is providing technical support for that network and for its secretariat, which is based over in the Office of the Attorney General in Samoa. My team also then runs AGD's own bilateral Pacific law and justice programming, which again is a long-standing program that we've been very proud to run in support of our Pacific colleagues. So our flagship program under that is our Pacific Legal Policy Champions and Twinning program, where we're bringing law and justice officials, police officers, legislative drafters, prosecutors to Canberra from countries across the Pacific to really focus, I guess, on the thing that is our bread and butter here in Attorney Generals, which is how do you take an idea from policy through to whether it's producing drafting instructions for a piece of legislation or internal policies and procedures for police, for example, when they're implementing things like new cybercrime laws, for example. So it's very timely that you're asking this question today, Senator, because we're pleased to have 18 Pacific Law and Justice officers just down the road with us actually at the moment running that annual program.
Great.
Should
have brought them to the back of the room then. Would have been great. That all sounds wonderful. How long are these? Did you give us a figure of how long they've been running for, the programs?
So Pacific Island Law Officers Network was first established under a slightly different name in 1982, and we've been members since that time. Our Pacific Legal Policy Champions and Twinning programs have been running for, I think it's about 15 and 10 years respectively.
Great. And what sort of numbers of participants are we seeing through that program? I don't know if you have them on hand.
So this year in our Legal Policy Champions program, we have 18 officers who are with us from 9 different jurisdictions, and there'll be 4 of those officers who remain on for a further 6 weeks after that 2-week Champions program. And those 4 officers will be spending time sitting with us in the department and engaging with experts across government and state and territories and academia to progress real-life legal policy projects that are priorities for their jurisdiction.
So what's the feedback once they return to their home countries? How do you receive feedback from the participants that have been part of that program?
Thank you, Senator. We do follow up with all of our participants for, I guess, immediate feedback when they're finishing the program, through surveys, through discussions with participants and the like. And then as part of our broader program, which includes the Policy Champions and Twinning program, we do more longitudinal sort of follow-up there to inform us on, I guess, what's the impact of participating in that program sort of over time? Have the participants been able to take the skills that they've learned and apply those in practice in their home countries? And also importantly for us, I guess, share and help build those skills in their home agencies, because part of our program is to, I guess, train the participants to do legal policy training themselves back in country.
That's great. My understanding is that the Attorney-General recently visited Papua New Guinea, and can you tell us or provide an update on the purpose of that trip and the engagement the Attorney had while she was in the country?
Yes, absolutely. Thanks, Senator. So it was in September 2025 that our Attorney-General, our Secretary and the Australian Government Solicitor travelled to Papua New Guinea to discuss priorities in our long-standing law and justice partnership, and also at the invitation of Papua New Guinea's Chief Justice to celebrate the opening of Papua New Guinea's Waigani National Court Complex. And that as well was part of Papua New Guinea's broader and very significant celebrations of their 50 years of independence. So the opening of the courts, the gathering of law and justice officials associated with that was, I think, the key sort of feature of law and justice in the 50th anniversary celebrations. That visit was an opportunity to reaffirm at a really senior level and ministerial level the close and enduring partnership between our country's judiciaries, legal professions and justice sector institutions. And those, again, are really long-standing partnerships that continue to be key pillars of the broader Australia and Papua New Guinea bilateral partnership. So during the visit, the Attorney and the Secretary attended the opening of the courts there, and the Attorney also engaged with ministerial counterparts, including the PNG Minister for Justice and Attorney-General, the Deputy Prime Minister and others while she was over there. And I would just add to that as well, the partnership with Papua New Guinea is a particular focus for us in the department and the portfolio. We've had a bilateral relationship with the PNG Department of Justice and Attorney General, again dating back a number of years, and we've had a kind of posted secondment arrangement that's been formalised there since 1993. So it was a really good opportunity to sort of consolidate and keep strong that relationship.
That's great. Sounds very exciting. On matters in relation to the Pacific and how they're managed within the department, is it solely the responsibility of the Pacific branch, or are there other parts of the department that provide support to this region?
So Pacific Branch, in addition to running our programs, we try to really support and swing in behind the rest of the department and portfolio with their own significant work in the Pacific. For example, the Australian Government Solicitor runs pro bono legal skills training for lawyers across the Pacific, including in Papua New Guinea, whether that's sort of core legal skills or looking at subject matter areas like contracting, procurement, legal ethics, that kind of thing. So our branch can help support that, but I can confirm it's definitely the case that there is work going on across the department and in portfolio agencies as well to really swing in behind the Pacific law and justice sector.
Excellent. Thank you very much for the update. Thank you, Chair.
With indulgence, can I ask one follow-up question just in relation to that in particular? And first, let me compliment everyone involved in those initiatives, and I say that as a PNG admitted lawyer. I lived and worked in PNG between 1999 and 2001, passed the PNG law exams.
You're moving into Don Farrell territory here with my stories.
That's a very high bar. That's a very high bar, the Don Farrell bar. Very high bar.
Chair, I missed that.
It was complimentary to you, Minister.
No, it was definitely complimentary. I said you're veering into Don Farrell territory here with the personal stories before you're asking a question.
And I said it was a very high bar to esteem to. But my question was just in relation to judges who are serving on Australian federal courts and other superior courts. How many judges do we have who are Australian judges who are seconded from time to time or as temporary appointments or working on superior courts in PNG and other places in the Pacific, and how important is that in terms of embedding that relationship between law officials across the Pacific?
Very important, and I would draw a distinction between federal court judges, of which there have been two at any given time over recent years. And I just need to confirm whether, Justice John Logan has for many years been appointed to the PNG Supreme Court, or Supreme and National Court, and then Justice Berna Collier. I believe both of them are still appointed to the PNG court at the moment. And in addition to that, the former Attorney General, Mark Dreyfus, did quite a bit of outreach in Australia to draw to the attention of either retired judges or people from the bar about opportunities to be appointed to the PNG court. And that resulted last year, over the course of last year, I think, I'd need to check, but I think between 6 and 8 Australian lawyers being appointed as judges, and the Chief Justice of the Supreme and National Court was very grateful for those judges to be appointed and support PNG in its law and justice area. And I think there are other examples through the Pacific where Australian expats have been appointed to courts. We can take on notice a specific number of Australians that are there at any given time.
Thank you.
Thank you. Senator Shoebridge.
Thanks, Chair. Just to round off the questions about President Herzog's visit, CNN has reported in the last 24 hours, and I'll quote, an Israeli official told CNN that Israel's Justice Ministry had assured Herzog and his delegation there was no threat of arrest, partly because it was a state visit and also because no warrants existed for anyone in their party. Do you know if your department was in any way involved in providing such assurances to the to Israel? Was your department in any way involved in providing such assurances to Israel?
So the department doesn't have any role in doing that. So no.
All right. And are you aware whether or not any advices you've given to DFAT were provided to Israel to give Israel that assurance that Herzog and his delegation were under no threat of arrest?
No.
All right. Could I ask some questions about the Combating Anti-Semitism, Hate and Extremism Bill? There is very real concern in the community about the extent and the reach of this bill. One provision that was added to the bill, it appears in haste in the last few days of negotiations between the government and the opposition, was 114A(3), which included in the definition of hate crime a series of offences under state and territory laws. And I think there are 7 different state and territory offences which were roped in. Are you aware of that provision?
Yes.
Yeah. Mr. G, again, I don't think the microphone's picking up your answers.
Yes.
Yep. And that wasn't included in the original draft, was it? It was added in at some point in the parliamentary week. Is that right?
That's correct.
All right. Now, I won't read each and every one of the state and territory offences that were roped in, but one of them, for example, is the Victorian Crimes Act provision 195N, which says that if you're in Victoria and you engage in conduct that includes serious contempt towards another person based on one of their protected attributes, that can be a criminal offence in Victoria. Are you aware of that one, Ms. Chigi?
Yes.
All right. So if you live outside of Victoria, is your conduct now governed in part by that provision by reason of 114A(3)? Does the Act apply that test now across the Commonwealth? Is that how it works?
So again, we would avoid giving legal advice to the committee, but can say that that it's conduct within the scope of the particular state offence that is captured by that provision, obviously, and then it's about the AFP minister being satisfied that that's the case.
But people are asking, not unreasonably, there are now 7 different state and territory offences which previously applied to distinct jurisdictions. They're not unreasonable. People in New South Wales are asking now, is their conduct going to be governed by laws that previously only applied in Victoria? Are those provisions now governing their conduct in New South Wales? And they're asking the same about the Queensland provision, the 2 provisions in WA, the South Australian provision and the ACT provision. Does the bill have the effect of effectively applying those tests, multiple tests in each jurisdiction now?
So to take you to the wording of subsection 2 that defines hate crime as conduct that involves publicly inciting hatred of another person because of race, national, ethnic origin, and would constitute an offence against a provision of a law of a state as set out in that. So it has to be conduct that would constitute one of those offences within the terms of those offences.
Well, because of the territorial application of state and territory laws, there are two ways of reading that. If it would only constitute an offence if you did it in Victoria, because that's the extent of the reach of that Victorian provision under the Crimes Act. Or it could be conduct that if you did it in New South Wales, the conduct, whether or not it was in New South Wales or Victoria, but the conduct is such that would breach the law in Victoria, therefore you're also caught.
So we can't give advice on the terms, what conduct would specifically be within the terms of each of the state and territory offences, but it would apply according to the terms of those offences, some of which would capture conduct with an effect in that jurisdiction.
So if you're in the Northern Territory, which doesn't have any of these criminal offences, I think, will conduct in the Northern Territory be tested or potentially tested under the statutory offences that have been listed in 114A3 sub 3? Well, does it extend to conduct happening in the Northern Territory?
Well, it would go according to the terms of those offences. So New South Wales, for example, can capture conduct with an effect in that state, even if the conduct doesn't occur within the state.
But I mean, that's already so if, for example, the Victorian offence, right? The Victorian offence has an exclusion in it, basically excluding conduct engaged in outside of Victoria. Does that mean that under this Commonwealth law, there's different tests, different gateways about whether or not you committed the same conduct in Victoria or New South Wales? Is that what the effect of it? So if you're not caught under the terms of the Act and the territorial application of the State and Territory Acts, then it's not roped in. Is that what you're saying?
I'm saying that provision sets out that it's conduct that constitutes an offence against the provision of a law of a state or a territory as set out in subsection 3.
So that means if that's the case, that means under this law, there are 7 different Commonwealth tests for conduct that could see you breaching this law and having your conduct, having an organisation banned, because there's a different test in Victoria, which has a test of serious contempt, than there is in New South Wales, than there is in the Northern Territory. So that's the effect of it, is that there are 7 different alternate gateways, depending where you live, though. Is that the effect of it?
No, because as I've said, that's not, taking the New South Wales provision as an example, it could capture conduct outside New South Wales with an effect in New South Wales.
Yeah. So, but if you did the conduct in New South Wales, let's take the Victorian one. If you did this serious conduct that meets the serious contempt threshold in Victoria and it impacts in Victoria, then it's covered by the Victorian Act. If you did it in New South Wales and you were targeting people in Victoria, then it might cover the Victorian Act. But if you did it in Queensland, targeting people in Queensland, it doesn't meet the test. That's the effect of your answers, Ms. Gigi.
Well, I don't have all of the state provisions in front of me, but obviously they certainly overlap for conduct.
Are there other examples that you can point to where the Commonwealth has passed a law which is putting 7 different thresholds, 7 different legal tests for breaches of a Commonwealth Act dependent upon which state or territory you live in? Can you point to other examples where you've done this?
Senator, the other thing I would take you to is this is just one aspect of all the considerations that apply as part of the listing process.
Well, we may get to them. I'm asking you about this one, though. I'm asking about this one. Can you point to another example where the Commonwealth has provided for, in this case, fairly extreme powers to ban and criminalise organisations, to criminalise membership of organisations, where there is a different test, 7 different tests being applied in the 7 different state and territory jurisdictions across the country? Can you point to another example where the Commonwealth's done this?
I'm going to indicate I'm going to rotate the call after your response to this question.
We'd need to take that on notice.
Thank you, Senator Shoebridge. Senator Scarr.
Thank you, Chair. And I had one quick question. No personal stories before we. And then Senator Blythe. Okay. I just wanted to quickly come back to Royal Commission. You might be able to, Ms De Vries, we may not need you at the table, so just. We might need you though. I don't know. The solicitors assisting the Royal Commission. So I note that senior counsel assisting the Royal Commission has been announced. Will the solicitors assisting the Royal Commission, will that be the Australian Government solicitor?
Two very senior Australian Government solicitor officers have been appointed to the Royal Commission in the solicitor assisting role. And I'm saying that carefully because there's a distinction between AGS, who support the Commonwealth in its engagement with the Royal Commission, and these officers who have been appointed to the Royal Commission to be solicitors assisting. They were very early appointments that the Royal Commissioner made. Okay, so there won't be, just to confirm then, there won't be an external law firm appointed? There will be to complement that. So the Royal Commission itself has undertaken a procurement process to engage a firm to support the work. Ms Gigi can assist.
Gilbert and Tobin will assist those AGS lawyers in performing the solicitor's assisting role.
So Gilbert and Tobin will be reporting to the 2 senior Australian Government solicitor officers who've been seconded or for the duration of the Royal Commission. Is that correct?
That's right. That's correct.
And was that an open tender process?
There was a request for quote. I think it went to the panel of Commonwealth Legal Services providers. Okay.
And is there a budget for that external legal service provider?
We might need to take that on notice. I think the official secretary is responsible for the allocation of the budget within the Royal Commission. And I would just note the 2 senior solicitors assisting have enormous experience in Royal Commissions, so I think will be enormously helpful to the work of the Commission. So, Minister, were those senior legal officers from the Australian Government solicitors with their office, with their enormous experience in Royal Commissions, were they consulted by the Prime Minister before he made his comment that he'd consulted experts in relation to whether or not a Royal Commission was necessary?
Look, I don't formally know the answer to that question, Senator Scarr, but by the smile on your face, I think you know the answer. And I think the answer is no. But if it's any different from that, I shall let you know.
I appreciate that. Thank you.
Thank you, Senator Scarr. Senator Blythe.
Excellent. Thank you very much. I'm going to move to the Religious Discrimination Bill. So, sorry, it's like musical chairs. Thank you. So this bill was first introduced in 2021 by the then coalition government, and the idea is to provide protections against discrimination based on religious belief or activity. There was certainly chatter at the end of 2025 where we understand the Attorney-General met with religious groups to discuss a new religious discrimination bill. And the coalition, we haven't ever seen a draft of that bill or don't necessarily have oversight or any kind of view of it. Can the department provide clarity on the stakeholders that were consulted in 2025 regarding the push to revive the Religious Discrimination Bill?
No, Senator. It was representatives of faith groups, but we're not able to provide further detail.
Is that because of the NDAs that they were asked to sign as part of the negotiations or discussions?
We're not aware
Consulted?
that they were asked to sign any NDAs.
Okay. So your department hasn't asked them to sign NDAs?
No.
No? How is their feedback being incorporated into the current proposals?
Senator, I think what we would say about that is that the Prime Minister has made it clear on a number of occasions that legislation on religious discrimination would only be introduced with bipartisan support. So the department's not preparing further legislation.
So there's no new version of that bill that you're preparing?
We're not preparing a further bill.
Are you working on the original bill that was introduced in 2021?
No.
No. Okay, that's probably the end of that line of question then. So there's no bill there.
No, Senator. I should just expand that the Prime Minister has said he's open to discussions with the opposition should there be any interest.
Yes, and we haven't seen anything or had any discussions. So we've just had faith groups coming to us asking what's going on. So interesting. I can move on to a slightly different question then, which is going around the fee increases for council.
We'll just get the right people back up to the table.
Thank you. And this occurred sort of shortly after the Bondi Beach terror attacks. There was an announcement by the Attorney-General who will be implementing a 43% increase in the maximum pay rates for barristers representing the Commonwealth, and that will come into effect from March the 2nd this year. Senior counsel day rate has gone up to $5,000 and for junior barristers from $2,300 to $3,300. Given the current budget pressures, what was the reason for the 43% increase?
Senator, I'll ask Mr Ng to respond there. I would note that the timing for that announcement was coincidental. You referenced it to Bondi, but it was in no way connected to that matter.
Thanks for the question, Senator. Just to give you a bit of context around the increases to the approval thresholds and the legal services directions that you're referring to. So there was a broader review of the legal services directions that was conducted by the department following the Robodebt Royal Commission recommendations. And one of those recommendations went to clarification and simplification of the directions generally. The rates, the way that the council rate threshold regime works under the legal services directions as they stand and as they will be under the new ones, is that these are not, these are approval thresholds rather than absolute prescription as to the Commonwealth setting the rates for council. That remains a matter for agencies to do in negotiation with council. I will say that the thresholds that were in the previous directions or the 2017 directions were in place since 2011. And so those rates of which were $2,300 per day for junior counsel and $3,500 per day for senior counsel have been there for some close to 15 years. And as part of the review of the directions, the department consulted with other Commonwealth entities and recognising the changing market conditions and CPI increases and a different operating environment now compared to 15 years ago, it was judged appropriate by the Attorney to increase those rates to the $3,300 for junior counsel per day and $5,000 for senior counsel. Just a couple of additional points, if I may. So the first thing is to say that we would say these thresholds are significantly lower than the commercial rates for many of these counsel, and so they don't operate as a standard rate that's payable for a brief to counsel. Secondly, I would say that in a number of cases, and we've got some figures on this, but in a number of cases, one-off approvals can be sought and given by either the Attorney General or the Attorney General's delegate, which is a departmental delegate, for rates that are different there. But I will say, as I mentioned, I think earlier, that the exact rate that is payable by a Commonwealth entity must take into account the thresholds, but also the value for money principles under the Commonwealth procurement rules.
Excellent, thank you. And I will go into the quoted diversity quotas that were also included as part of that change. And you have rightly pointed out that these rates are well below what the commercial rates are that are available for counsel to seek privately, so not Commonwealth or government work. You're requiring at least 40% of briefs from the Commonwealth to now go to female barristers. If you're really looking for gender equity, why, I guess, disproportionately brief female barristers at a pay that is well below what the market will pay?
Senator, if I might just clarify one aspect of your question, which is the way that it is reflected in the directions is that it's an encouragement but no compulsion for entities to engage a diverse range of counsel, and that the 40% target that you referenced earlier is one that entities are encouraged to the extent practicable to consider, and that is broadly consistent with the way that the current 2017 directions operate, which encourage Commonwealth agencies to brief a broad range of counsel and in particular women.
Do you think that exploits young female barristers to accept a pay rate that's well below commercial because they need to find or get work?
Senator, I won't express an opinion, but I will say that the intention of the gender equitable targets is to encourage a greater retention of women barristers within the profession. It's reflective of some work that the Law Council of Australia did in 2016 on an equitable briefing policy, and it reflects the way that the directions operate at the moment, which is to encourage those targets, and they're reported on, and there are, I can take you through some of those statistics, but just to say that the intention is not to disadvantage female barristers, but rather to improve the retention rates of those women barristers within the profession. But as I mentioned, it's not a compulsion. These are targets that Commonwealth agencies are encouraged to move towards.
Thank you very much, Senator Blyth. Senator Shoebridge.
Thanks, Chair. I feel like doing an anecdote about being a hungry young barrister and taking any brief that came across the desk. You know, there's rent and food and all that stuff. But Minister Farrell would object, so I won't.
No, I'm very happy if you want to tell your log cabin stories.
Oh, no, now's not the time. Thank you. But I do. Look, perhaps I take a different view in relation to that line of questioning. But I think everything that the Commonwealth can do to ensure that women in the law, young barristers who have so much to contribute to getting access to Commonwealth briefs, the more you do, the better. Good for the law, good for society. Thank you for doing that. Can I go back to the Combating Anti-Semitism, Hate and Extremism Act? I'll ask through you, Secretary, but there may be officials who can answer it more clearly. Which non-government stakeholders were provided with the draft bill before it was tabled in Parliament?
Senator, I will defer to Ms Chidgey or Ms Sanders or Mr Muffet, who had the lead. I was involved in one consultation, but they did most.
Sure. I'm happy if Mr Muffet's got the list there. And while Mr Muffet's finding the list, who determined which stakeholders would be consulted with? Was that a decision of the Minister, or was it a departmental decision? Did it come from the Prime Minister? Who made the decision?
Ministers determined groups that were consulted.
And when you say ministers, in this case, Prime Minister, Home Affairs Minister, the Attorney General, are they the ministers?
I can't say because a number of ministers were involved, but the Attorney General, Minister for Home Affairs, Minister for Multicultural Affairs, I think, had conversations. So I'm not sure about sort of all the ministers that were involved
but it was
in that.
Ministers who did it. The list, Mr Muffet?
Thanks, Senator. So on the 29th of December, I started too early. So in terms of ones that were provided draft provisions, on the 8th of January, the Executive Council of Australian Jury and the Special Envoy to Combat Anti-Semitism and her office were provided a copy of the draft provisions. The Law Council of Australia was provided draft provisions on the 8th of January and the 9th of January. There was two different representatives from the Law Council. And the Australian Catholic Bishops' Conference were also provided draft provisions on the 9th of January 2026.
That's it?
That was the list of stakeholders who were provided the provisions that related to the hate crimes component of the bill prior to the exposure draft being made public through the referral to PJCIS.
And are any of you able to shed light on why none of the ministers thought, for example, the National Council of Imams or other religions weren't consulted?
Senator, Sarah Samios, First Assistant Secretary, Integrity and Criminal Law Division. I should say this is the ones that we're aware of, so we can't speak to whether there were provisions provided through any other mechanism. There were consultations with some others in that period, but to my knowledge, provisions weren't provided.
All right.
And the National Imams Council, there was consultation before the bill was public, but not on the basis of draft provisions.
All right. Then some of the consultation began, I think, at the end of last year, in or about 29 December. What can you first of all describe what that consultation was, and then secondly, who was part of that consultation?
So, to our knowledge, again, I can't speak to completeness as to...
I'm not asking you if Home Affairs did something over there or the Prime Minister did something somewhere else. I'm asking.
So we're
from your
aware
department.
of consultation on the 29th of December with representatives from the Executive Council of Australian Jury and the Office of the Special Envoy to Combat Anti-Semitism.
And only those that you're aware of?
On that, beyond the list we already provided, yes.
All right. And I asked you questions about draft bills and draft legislation, or the legislation before was there any... and I'm assuming that in the 29th of December you didn't have draft legislation. It was about the concept, was it, of bringing laws forward?
Certainly we didn't have anything that was ready for sharing.
Okay. It was about the project more broadly.
That's
Would that be a fair description of it? Was anyone else consulted about the project more broadly between the 29th of December and the 8th of January?
Not that we were involved in.
I have to tell you that this legislation has raised incredible concerns about the extent of its reach into legitimate criticism of the actions of Israel in Gaza or the actions of other nation states whether it's Indonesia and West Papua, China in the northwest of China, Russia in Ukraine. It's raised enormous concerns about its reach. It's raised concerns particularly amongst members of the Muslim community that they feel it was legislation that was being potentially targeted against them. How is it that the government didn't consult, for example, with official representatives or representatives from the Muslim community before you bring legislation forward like this? How did that slip through the cracks, Secretary?
I think we just put on the record that the National Imams Council was consulted.
After the laws were in Parliament?
No, it was on the 11th of January.
But by then, the bill had already been out. The draft bill had already been out, and
it wasn't public at that point.
When did it become public?
It became public on the 12th, so it was referred to PJS in the afternoon. That was prior to it being made public. I think our evidence was that they weren't consulted on the provisions of the bill, but they were consulted on the policy of what was contained in it.
So on the day before the bill came out, unlike other groups that got actually consultation on the provisions of the bill, they were consulted about the fact that something was about to happen, but they weren't given a copy of any draft provisions. Is that right?
In the consultation that we were involved in, that's correct.
All right.
We've said we know that ministers were engaging directly themselves, so we can't comment across the board.
All right. So how, given the very real sense of being targeted that much of the Muslim community in Australia has felt, how is it you gave them such cursory engagement? You didn't even give them a copy of the draft provisions, and you basically gave them a 24-hour heads up. How is that reasonable?
There was also a Parliamentary Joint Committee on Intelligence and Security inquiry that accepted public submissions and considered those as well. Which I think pretty much every group criticised as being woefully inadequate, filed too little time, and not a genuine review. You're aware of those criticisms of that process, aren't you, Ms Chidgey? We're aware of that, and the government has obviously made clear that it was committed to acting with urgency in response.
Ms Chidgey, I'm not holding you responsible as a member of the public service for the decisions the government made. I want to be clear. You do what you're directed to do by the executive. I'm not holding you responsible for it, but I'm asking if you're aware of those criticisms.
And I said yes, and I've said what the government's response has been.
Was input received from the AFP and ASIO in relation to the offences before the legislation was handed to the PJCs?
We worked with those agencies to develop the legislation.
All right. Secretary, what safeguards are there in this legislation to ensure that peaceful protests and advocacy concerning Palestine, Israel and other international justice issues are not caught up in this and are not potentially criminalising groups and by dint of that criminalising membership of those groups? And I reference you to the Attorney General's failure to rule out criticism of Israel triggering this in her public media following the passing of the bill. What checks and balances are there?
Senator, I would say that a lot of work went into crafting the provisions to get the balance right. Obviously, to ensure that the legislation was, in our view, consistent with constitutional advice and sought to get the balance of addressing hate speech, but recognising constitutional limitations on implied freedom of expression.
Yeah, so your concern wasn't whether or not the Muslim community might feel targeted, whether or not those are calling for a free Palestine may be targeted. Your concern was the constitutional limitations of how far you could go. Was that the restraint, the constitutional restraint? not the social unease?
So, Senator, obviously there were consultation processes that did occur, and for any criminal legislation, we obviously also take into account whether legislation has sufficient and appropriate thresholds to criminalise the conduct of individuals, as well as also considering that range of constitutional factors, including the implied freedom of political communication.
All right. Secretary, in case my earlier questions somehow missed something, because some were in reference to broader consultation, some were in reference to the bill, I'll perhaps ask a general question. Will you table a list of all non-government stakeholders consulted from the 29th of December to the passage of the legislation on the bill, and the dates of the consultation and the nature of the material consulted on and shared?
So, Senator, the department can take on notice those consultations that it has knowledge of,
of course.
I'm very happy to take that on notice.
Yes, all right, thank you. Given the degree of community unease and disquiet about this, is the government intending to produce some fact sheets or guidance for government agencies to provide some detail? For example, I assume those state provisions operated the other way. I assume they imputed that conduct across the country. A bunch of senior councils I spoke to thought they imputed that across the country. Ms Gigi now tells they didn't. If senior council are being confused about the application, I can tell you now that the community's confused. Will you provide some fact sheets and guidance material?
So we don't produce legal advice on provisions that we administer, but I mean there are areas with the bill where we would produce some information, for example, on hate symbols, but we don't provide legal advice in general to the community.
Well, I'm not asking for legal advice, but surely government has a process where you pass an incredibly complex pieces of legislation where there's like 7, 8, 9, 10 different gateways to find an organisation prohibited and prescribed under this. Surely the government has some guidance to ASIO and Home Affairs. Surely you go through that sort of sensible administrative process, don't you?
So those agencies seek legal advice where they need to do so. There was also quite a comprehensive explanatory memorandum with the bill.
Yeah. So the short answer is you're not intending to produce, your department's not intending to produce any such fact sheets or guidance for the community, notwithstanding the fact that the community has no idea what's going to be roped in, and they're deeply anxious about it.
We'd mentioned that we're looking at guidance on hate symbols.
Yes, but hate symbols are defined list. But apart from symbols, notwithstanding the degree of anxiety in the community, the fear about what is or isn't being caught, statements from the Attorney-General that criticism of Israel may see your organisation banned, you're not intending to try and sort out any of that or provide advice or guidance for the community. That's where we've landed.
Senator, if it assists, so following the passage of the hate crimes bill back in February 2025, we published a series of information and fact sheets on our website, which gives further context to those. We are in the process of doing the same for this bill as well. Just wanted to flag too, so that would cover the new aggravated offences that complement those existing advocating and threatening violence offences, as well as an explainer on the new hate groups listing framework. So we're in the process of developing that. That will go up on our website alongside the sort of fact sheets and explainer material for the other recently passed offences. Where there was a lot of concern was around the racial vilification offence, which the government had proposed in the exposure draft. As you're well aware, that was removed from the bill that was introduced. So what the guidance will focus on the measures that were passed by Parliament.
Yes. Thanks, Ms. Muppet. That was actually useful. But I want you to not be under any misapprehension. There is incredible unease in the community about the prescription powers and what conduct will be a gateway to seeing your organisation banned, whether standing up and saying human rights should be respected across all of Israel and the occupied West Bank and occupied Gaza, whether or not that'll see your organisation banned and you potentially go to jail. I can tell you there's huge concern about that.
I understand that, and to build off Ms Chidgey's evidence earlier, those provisions you were discussing go to the listing threshold. They are one component of the listing threshold. They themselves don't make offences. Really, what it's saying is if the minister is satisfied that the group is engaging in conduct that is one of those state offences, as well as those additional layers on top of that where that conduct is not only a state offence but involves inciting hatred based on race, national, ethnic origin, and a reasonable person of the targeted group would feel fear. Noting those elements are not present in all of those state laws, it actually adds that as additional factor on top. That then just goes as one of the factors in the listing threshold. It does not make a crime. It's saying if a group is engaged in conduct that is already criminal, then they, subject to the other factors, may be listed, and then prospectively engagement with those groups would be criminal.
Of course, as Anne Toomey has pointed out, the test is not incitement. The test is actually significantly lower than incitement, which is, of course, one of the concerns that groups have. You'd be aware of Anne Toomey's concerns and criticism in that regard.
The focus in the bill is on whether the groups have engaged in those crimes, supported them or advocated, and advocated is defined in the legislation.
Yes.
Thank you, Senator Shoebridge. Now that it's 3 o'clock, we will suspend for afternoon tea, return at 3:15 with the Integrity and Security Group.
With the which?
Thank you. We'll now resume with the Integrity and Security Group, and we'll go to Senator Scarr.
Thank you very much, Chair. I've just got a few short questions in relation to the prohibited hate group regime. What's the role of the Attorney General's Department with respect to the potential listing of a group as a prohibited hate group?
So we would support the Attorney General with advice when the AFP Minister seeks the Attorney General's agreement to a particular listing.
Okay, so the AFP Minister's the Home Affairs Minister, correct?
That's correct.
Okay, so you will only get involved when the Home Affairs Minister approaches the Attorney General to seek advice, correct? Or the department seeks
yes,
advice?
That's the formal role. We also engage with Department of Home Affairs regularly as part of a process and as part of officers groups that they have across government as well.
Okay, all right. So are you involved at the moment? Have you been asked to give advice in relation to the prohibition of any particular hate group?
So the Department of Home, in the structure of the listing regime, there's the role for the Director General of Security giving a recommendation and advice for agencies, and then Department of Home Affairs would compile a statement of reasons for their minister, and we would be involved at the point the Minister for Home Affairs.
Okay, so are you involved at this point in time, as we're here today, in terms of giving any advice to anyone in relation to the prohibition, the active application of the now passed prohibited hate group provisions? Are you providing advice to anyone in relation to the prospective nomination of a group as a prohibited hate group?
So we work closely with Department of Home Affairs on the construction of the listing regime and considering different scenarios.
So I'm moving forward now post Act
Department
pass.
of Home Affairs would seek legal advice from the Australian Government Solicitor, as well as agency advice in compiling that statement of reasons.
Right, so have you been asked to give any advice in relation to compilation of a statement of reasons for any group?
We're not giving advice as part of that.
Are you giving any related advice with respect to preparation of a statement of reasons or in relation to the prospective prohibition of a prohibited hate group?
We're not giving Department of Home Affairs advice on the statement of reasons. They would go through that process of compiling agency information and seeking AGS advice, and we can't. We wouldn't comment on the specifics of processes and consideration of individual organisations.
But you can, and I acknowledge you can't. I've been pretty particular the way I'm putting my question, so I haven't asked you to comment on the potential prohibition of any particular group. I'm simply asking whether or not you're giving advice in relation to the prospective prohibition, possible prohibition of a group as a prohibited hate group.
No, so that is not the department's role in the process, but we obviously engage with Department of Home Affairs and would provide advice to the Attorney General at that point in a process.
Okay, all right. Okay, all right, I'll leave it there. Thank you. Thank you, Chair.
Thank you, Senator Scarr. Senator Shoebridge.
Thanks very much, Chair. Is the department aware of the investigation, the current investigation that the inspector of the NAC is undertaking in relation to possible officer misconduct by the NAC and the NAC Commissioner? Are you aware of that investigation?
Yes, I am, Senator.
When were you advised about it?
The inspector contacted me on Friday to advise me that she had taken that decision, and she provided me with a copy of the letter that she had provided to the PJC NAC.
All right. As usual, the inspector is thorough and transparent in the inspector's work. Now, the attorney in October of last year raised concerns directly with Commissioner Brereton. I think the letter is the 10th of October 2025. Secretary, were you aware, were you involved in the drafting of that correspondence?
Yes, we assisted in the preparation of a draft.
Yeah. Now, that raised serious concerns about the way in which Commissioner Brereton had addressed conflicts of interest and potential conflicts of interest, and included concerns about his transparency to the former Attorney General and transparency in answers to the Senate, didn't it? Who's best to answer that? Ms Jones?
I think how I would characterise that letter is that the Attorney General wrote to the Commissioner asking that he provide clarification on his engagement with the IGADF. My understanding is the Commissioner did provide that clarification on the 22nd of October, and in that provided a further declaration of interest containing more detail on his assistance to the IGADF.
All right. Well, to perhaps, so I don't get accused of misrepresenting, this is what in part the attorney said on the 10th of October to Commissioner Brereton. Your recent declaration of interest and your earlier declaration of interest provided to the former Attorney General on 11th August 2023 do not provide details of the nature and extent of the activities you are undertaking at the request of the IGADF. Now, that's not ambiguous, is it? It's a statement that they do not provide details on the nature and the extent of the activities being undertaken. Was that the view of the department as well as the attorney at the time? You'd obviously undertaken some research and looked at the disclosures.
I think we supported the view that clarification would be helpful.
Mm-hmm. The attorney also said to Commissioner Brereton, no declaration was made of the extension in June 2024 of your compulsory defence retirement age to August 2026. Now, Secretary, you know that the decision to give an extension was a decision of the Chief of Defence Force. It was delegable, and I think in this case the CDF delegated it to the Chief of Army, but it was a discretionary decision, wasn't it? It was within the gift of the CDF or their delegate to either extend or not extend. It was an open discretion, wasn't it?
I think that's an accurate way to describe it.
And an open discretion like that, having to seek a positive outcome from somebody where they've got an open discretion, it obviously raises questions of conflict of interest. Because if they don't like you, if you've been criticising them, if you're holding them to account, you know, those matters may impact an open discretion, won't they? And that's why you need to declare it. Is that right?
If you're saying in general, yes, I would agree.
Well, both in general and in this instance, the Chief of Defence Force and or their delegate had an open discretion about whether or not to extend Commissioner Brereton's commission as a Major General. And this was at the same time that Commissioner Brereton was reviewing a whole bunch of defence referrals in his role as the NAC Commissioner. And he didn't tell anyone, did he? Well, he didn't tell the former Attorney General, and he didn't make a public declaration, did he?
I think that's correct, yes.
Now, did Commissioner Brereton accept that was wrong? Or did his very lengthy answer try and justify that and say it didn't need to be done?
I think in his response to the Attorney-General, he provided more information.
Yeah. He sought to justify not doing it. And in the course of like a 10-page essay, sought to justify all of his non-disclosures, didn't he? And defend all of his non-disclosures and say nothing to see here. That's what the response was, wasn't it?
I wouldn't go to exactly that clarification, but that characterisation. But he did provide further information in order to, I think, provide some assurance and explanation as to his thinking.
Maybe for the sake of the committee, could you provide to this committee a copy of the correspondence from the Attorney-General in October and the NAC Commissioner's response?
We can take that on notice and table, yes.
Yeah. I mean, I have with me a copy of the Attorney's letter, but I don't have, just in my papers at the moment, the NAC Commissioner. So I'm happy to table the Attorney's letter just to help keep moving things along.
Senator, can I just clarify? I think the Commissioner's response to the Attorney-General has been largely released under FOI, but I think the request to table a copy of the full letter would probably be best directed at the NAC itself.
Well, it was sent... the NAC may or may not support transparency. They're independent. They'll make that decision themselves. But I'm asking you to provide to this committee a copy of the correspondence. And I don't think you should assume that the independent NAC will provide a copy. It's a matter for them. So will you provide a copy, or are you...
I'll take that on notice to provide it. It would normally be the agency that wrote the letter that would provide a letter on request from a Senate committee.
Well, speaking of normal conduct, why wasn't the Attorney-General's letter raising these very real concerns, why wasn't it provided to the Parliamentary Joint Committee that oversights the NAC? You would have thought that in a matter of good governance, the Attorney would provide that correspondence to the Oversight Committee, particularly given there's a government majority and a government chair on the Oversight Committee. Why wasn't it provided?
Senator, it was correspondence between the Attorney-General and a statutory office holder, and that would normally just be a direct engagement between the two.
Well, there was very real public discussion then and continuing about this. Why didn't the Attorney make the letter public? These are matters of very real consideration about public administration, a debate that was happening in the public domain and continues in the public domain. You know, for my own part, I took some comfort in the Attorney having concerns and raising these concerns. Why wasn't it made public?
I have nothing further to add other than in the usual course of events, Minister writing to a statutory agency is a direct engagement. I can't add anything further than that.
All right. Has there been any more correspondence between the Attorney-General and Commissioner Brereton since these exchanges of letters?
Not that I'm aware of. We can take that on notice to be 100% sure.
All right. And if there is, please provide a copy to the committee, whether it's come from the Attorney-General to the Commissioner or it's come from the Commissioner to the Attorney-General.
We'll take that on notice.
All right. Ms Farrell, you said last week that Commissioner Brereton retains the full confidence of your government.
That's correct.
He's been schooled by the inspector on the robo-debt and his failure to deal with a conflict of interest and perceived conflicts of interest on robo-debt. There's now a second investigation about potential officer misconduct formally initiated by the inspector? Is it the enormous public disquiet about his failing to disclose his connections and ongoing connections with Defence, including from the Attorney-General? Are you saying he still holds the full confidence of the government?
Yes.
Okay. Secretary, I asked Senator Farrell last week whether or not the government was aware if Commissioner Brereton had resigned his position as an assistant to the IGADF, and Commissioner Farrell said and it's not unreasonable, he didn't have the facts to hand, he's not the minister, you take it on notice, but you have responsibility for the oversight of the NAC. Are you able to answer whether or not the government knows if Commissioner Brereton has resigned his position as an assistant to the IGADF?
Senator, my department doesn't oversight the NAC. There is an oversight framework that was built into the legislation, and the inspector of the NAC plays that role, providing oversight. Obviously, I have a role as the Secretary of the department to work with portfolio agencies. So I just wanted to clarify that. In terms of whether or not Commissioner Brereton resigned from the position as Assistant IGADF, my understanding is yes, and that occurred on the date. One of my colleagues will clarify it for me. That became effective on the day of his appointment as NAC Commissioner.
You say it became effective. You see, the difficulty I have is the actual IGADF, Mr Gaynor, said that he had a conversation with Commissioner Brereton, I think it was in or about March, maybe it was May, or before his appointment commenced on the 1st of July, where the then Major General Brereton said that he intended to resign. And then Mr Gaynor has said, in answers to questions on notice from the Senate, that a search of the IGADF's records shows no evidence that it happened. Now, do you have knowledge different to Mr Gaynor? And if so, what is your statement to this committee that he resigned effective 1 July 2023 based upon?
So my understanding is that he provided that resignation verbally.
Well, you see, Mr Gaynor's evidence was that the verbal statement was that he intended to resign, not that he was resigning. And he's given that formally in answer to questions to the committee. And then Mr Gaynor goes further and says the search of the records found no evidence of it happening. So do you know something Mr Gaynor doesn't? If so, what?
I have a copy of the answer that Mr Gaynor provided, and the question was, has Major General Brereton submitted a resignation from his position as Assistant Inspector General of the Australian Defence Force, and if so, when was the resignation submitted? Mr Gaynor's response is yes. Major General Brereton verbally resigned to the Inspector General of the Australian Defence Force his appointment as an Assistant IGADF in May 2023 with effect 1 July 2023.
But you see, Mr Gaynor has since gone on and said the conversation in May was that he intended to resign, and a search of the records has found no evidence of the resignation. So which answer? Is it that answer, or is it his statement where Mr Gaynor said the conversation was he intended to resign?
Sorry, I'm not aware of the other statement. I can only go by what's in this.
It is the answer the Secretary read out. So it is common that the resignation, this was, I don't know what date that the answer was given, but it was an answer to a question on notice from the 2025-26 supplementary budget estimates.
But you haven't seen obviously haven't seen any written resignation.
We understand it was a verbal resignation.
Well, perhaps Mr Gaynor will be able to shed some light on this later.
And I think that they have, and that verbal resignation from those roles is a common practice. So there is no expectation that there would be a written resignation.
Well, as I said, perhaps Mr Gaynor will shed some light on his divergent answers at some point.
Sorry, Senator Shoebridge, are you about to move on to a...
I am.
Yeah. So before you do that, I'm just going to say that the committee tables the document, the letter from the Attorney-General. Thank you, Senator Shoebridge.
Cool. Could I ask what the... I've got a couple of other matters to deal with. One is whistleblower reforms. Now, last time we asked, we were told that it was a matter for government when the whistleblower reforms were brought before Parliament. Many stakeholders thought it was imminent last year, and it was imminent earlier this year. You know, it's like waiting for Goddo. It never turns up. Is Goddo going to walk in with any whistleblower reforms at some point?
Timing does remain a matter for government.
All right, Minister, do you know if the play will ever end? Is anyone going to walk in with whistleblower reforms?
I first saw Waiting for Goddo in about 1970.
And he still hasn't turned up, and he still hasn't turned up. So, and he still hasn't turned up.
No, the playwright. The playwright wasn't there. It was at a place called Carclew in North Adelaide, and I still very, very vividly remember the play.
Did you have a glass of red before or after?
No, I was still at school, I'm afraid to say.
Did you stay to the end, Minister?
I did.
Did he turn up?
It was compulsory. No.
It's a lot like your whistleblower reforms, isn't it?
No, he didn't. But I shall inquire of the Attorney-General what progress is being made there on that score, and I'll come back to you, Senator Shoebridge.
All right. Could I ask you then, Minister, about the government's intent with its friendless FOI reforms?
May not be friendless.
Well, who apart from the Labor Party is friends of it?
The Minister is still, talking to people about it, so don't...
Who's the Minister talking to about it?
Well, I hope she's talking to everybody.
Everybody?
In the Parliament. In
Very
fact,
heterogeneous, isn't she?
If you're happy to have a conversation with her, I'm sure I can get her to talk to you about it.
We've found 3 provisions we support, so we're happy to run those 3 different clauses through any day.
All right. Well, I'll tell
provided
her,
all the rest is withdrawn. All the rest is withdrawn.
I'll tell her the good news.
It's more of an F than an FOI for us.
I'll pass on the good news. No, look, don't. There's been many occasions when I see reported in the paper that legislation won't get through, and then when push comes to shove, it does. So that will be an important reform. The FOI process is currently being abused. It's not fit for purpose in the modern age. There are some senators, former senators in this place, who are simply making a business out of writing these requests. It's tying up far too much time of public servants when they should be doing other things.
They should be working for defence contractors, which is is that
no,
what you think, rather
be,
than helping the public do FOI requests?
No, they should. Who's this, the senators or the public servants?
Well, you're critical of senators helping people do FOI requests, but you're not critical of former senators joining defence contractors and trying to get billions of dollars for private defence contractors.
Well, I'm not sure who you're talking about there, but...
there's a list.
Is there? Okay, well, there you go. The observation I make, and this is, also the view of the Prime Minister, is that this system is not fit for purpose. Too much time is being wasted and the valuable time of public servants, and that we need to reform the way in which the FOI system works. Now, if you can suggest some ways of improving that. I'm sure the Attorney General will, happily receive your advice, but something has to happen to make this system fit for purpose, and the government will continue to persist until we get that fit for purpose legislation through the Parliament.
All right. Speaking about FOI, Minister, and this may be to you, Secretary, in the October estimates, I asked your department about whether you'd provide advice about legal exposure following the ICJ's advisory opinion on the obligations of states in relation to climate change. You said you wouldn't discuss the content. Following those questions, the Australian Conservation Foundation sent an FOI to your department, and you confirmed that you'd provided, and I quote, high-level summary in relation to their decision, and 2 formal legal advices in September and October, but refused to produce any further material under FOI. Did your department give advice about Australia's federal and state territory granting of exploration licences or production licences for fossil fuels, and whether or not that was or wasn't in breach of our obligations in light of the ruling?
Senator, we wouldn't go to the detail or the legal advice we've provided, but I'll just see if Mr Clark has anything further he can add.
And Mr Clark, rather than do this in 10 different points, I was going to ask the same question about, did the advice cover subsidies for fossil fuel production, the export of fossil fuels, and the absence of climate impact assessments?
Senator, sorry, I was just trying to absorb your question as I came to the table. I think you identified, in response to FOI, some advices we've given in relation to the advisory opinion on climate
Mr Clark,
change.
just to repeat, because I saw you
that
come
will be
into the
helpful,
thing.
Senator.
The ACF did an FOI following that questioning earlier to the department, and the department confirmed that it had provided a high-level summary immediately following the decision, and then 2 formal legal advices in September and October 2025.
Senator, that remains the case. I would add that we continue to provide advice to a range of departments on the potential policy implications of the advisory opinion.
Right. Well, what are the policy implications of the advisory opinion? It basically said states have an obligation to deal with climate change under international law.
Well, the policy implications would be the responsibility of the Department of Climate Change, Energy, Environment and Water. Our involvement is providing them and other interested agencies as necessary with legal advice, and as you know, we wouldn't disclose the content of that legal advice to the committee.
And then, Mr Clark, as you were coming forward, I specifically asked, did you provide advice, and I'm not asking for the answers, but simply did it address the granting of exploration licences or production licences for fossil fuels, fossil fuel subsidies, and the exports of fossil fuels, core issues for the climate struggle here?
Well, Senator, as you'll appreciate, a sort of rule in, rule out, what was in our advice, what wasn't, starts to disclose the nature of that advice. I can say that our advice broadly covers the major policy implications raised by the advisory opinion.
All right. I can see we're going to get caught in a doom loop here, so I will think about further questions on notice. Has there been any advice provided, formal advice provided since October 2025, and if so, when?
Senator, we are currently preparing an advice, and that advice has not been finalised and provided to relevant agencies. It's underway.
All right.
I would expect, Senator, that on an issue like climate change, we will continue to be responsive to policy agencies' requests for advice, including on the advisory opinion.
All right. But my answer was specifically about the advisory opinion, and the advice that's in the process of being prepared.
There is further advice being prepared
addresses
on
the
the advisory opinion. Correct, Senator.
All right. Can you, are you able to identify, was that at the request of agencies?
It's certainly in consultation with them, Senator. I'm not trying to be difficult. I just can't quite remember the genesis. But it's an ongoing engagement, particularly with the Q, DFAT and others.
Okay. So just, if you can, just which agencies are part of that consultation?
Senator, the main client for our advice on these matters has been DQ.
All right. Thanks, Mr. Clark.
Thank you, Senator.
The final question in this section is about the privacy reforms. I can't think of another play, but I won't go to a play because as much as I enjoy your cultural pursuits, Minister, we're short of time. Privacy reforms. When, if ever? And you know, I'll put it in. There's a wave of attacks against our privacy. Most recently, Bunnings succeeded in a review about the facial recognition, to permit ongoing facial recognition of all the customers going into Bunnings, because our privacy laws don't protect this. It was found by the Administrative Review Tribunal. And that has happened only in the last week. The more these reforms are delayed, the more our privacy is being impacted. When are we going to get them?
So, Senator, obviously there's been a huge amount of work done refining proposals, but I'll defer to Ms Moran, who can expand.
Thanks, Senator. Celeste Moran, First Assistant Secretary, Identity and Information Division. Senator, I think at the last two estimates we've given you the information we're able to in relation to these reforms. You're aware that the Privacy and Other Legislation Amendment Act passed the Parliament in late 2024, and that implemented approximately 23 of the proposals from the Privacy Act review. I think you're also aware that the government and the Attorney-General have made a commitment to a second tranche of reforms, and that commitment is to make sure that it's in the best interests of Australians, that it's workable and it provides a basis for both innovation and the protection of personal data. There's also a commitment to do targeted consultation on the draft provisions, but Senator, you'll appreciate the timing of that is a matter for government.
So that consultation hasn't happened?
No, Senator, it hasn't.
And you don't have a time frame even about the consultation on the draft provisions. This is tranche 2, isn't it?
That's right.
And tranche 1 was in, forgive me, was it sometime in 2024?
Late 2024, it passed the Parliament.
All right. All right. All right. Thanks, Chair.
Thank you, Senator Shoebridge. That now means that we can release the Integrity and Security Group. We will take a short suspension while we welcome the Australian Human Rights Commission. Thank you. We will now resume with the Australian Human Rights Commission. President, would you like to make an opening statement?
A brief opening statement. Thanks, Senators, I acknowledge we're meeting on Ngunnawal and Ngambri country. I acknowledge their elders and ancestors, their ancient and ongoing culture and their unbroken connection to this country. Senators, since we last met on 1 December last year, 15 people had their lives taken in the anti-Semitic terror attack at Bondi, and many more were injured physically and mentally. The attack has deeply affected the victims' families, the Jewish community, first responders and the broader Australian public. Then on 26 January, a man threw a homemade bomb into the crowd at a peaceful protest by Aboriginal and Torres Strait Islander people and allies in Perth. Thankfully, the bomb did not detonate. The man has now been charged with terrorism and other offences by law enforcement authorities. The attack has deeply affected First Nations communities across the country. These two events underscore the urgent need to address racism in this country. The Commission's National Anti-Racism Framework, published in 2024 and drawing on extensive consultations and research, makes 63 recommendations to government and beyond to eliminate racism in this country. Many recommendations align with the recommendations of the reports of the Special Envoys to combat anti-Semitism and Islamophobia. And we stand ready to work with government to swiftly progress the recommendations. We also stand ready to assist the Bondi Royal Commission to deliver on its important mandate, which includes addressing anti-Semitism and strengthening social cohesion more broadly in Australia. Senators, 2 weeks ago, Australia had its major 5-yearly UN Human Rights Review at the UN Human Rights Council in Geneva. Known as the Universal Periodic Review, it's a peer review process where UN member states assess each state's human rights performance and make recommendations for reform. The Commission, Australian civil society and UN human rights bodies informed Australia's review. At the review, 120 nations made 343 recommendations. Protecting the human rights of Aboriginal and Torres Strait Islander people was a key focus, including in relation to improving outcomes in health, education, employment and addressing over-imprisonment. Around 40 countries recommended that Australia raise the age of criminal responsibility so that children as young as 10 cannot be arrested, prosecuted and locked up. The need for a National Human Rights Act was another focus. Other issues included addressing racism and hate speech, promoting the rights of people with disabilities, tackling gender-based violence, promoting LGBTIQA+ rights and strengthening discrimination laws. Many nations, including from the Pacific, called on Australia to do more to address climate change. Australia will formally respond to the recommendations at the Human Rights Council in June-July. We urge the Australian Government to accept and implement the recommendations. When human rights are respected, our lives are better and our communities are stronger, safer, healthier and more prosperous. Finally, Senators, our Race, Sex and Age Discrimination Commissioners are unfortunately unable to participate today due to prior commitments that were arranged before today's hearing was scheduled. I'm able to take questions relevant to their work, and anything we can't answer today we can respond to on notice as soon as possible. We look forward to today's dialogue with this committee.
Thank you, Mr. De Kretser. We'll proceed to questions and go to Senator Blythe.
Thank you very much, President, and thank you for your opening statement. And I will just make a comment on your statement for the Sex, Race and Age Discrimination Commissioners who haven't appeared before us. I would like to note, and I know that you have received correspondence from our committee, that Senate estimates always occurs now in February, and personal leave from your commissioners is really, as I see it, unacceptable. This is where the Senate, elected members of Parliament, get to question commissioners who should be held accountable. And from my perspective, particularly given the very tragic events that happened in Bondi and other things that are happening within the broader Australian context of social cohesion, I think of all estimates to miss, this is probably one of the worst. So I would just note that from the Coalition's perspective, the expectation of us is that commissioners turn up to answer questions at estimates, and this is something that is a regular thing in the calendar. It's not an estimates that has been called at the last minute or anything like that, and certainly the dates for this have been available since November last year. So it is very disappointing that they haven't turned up. I think the Australian people deserve better of commissioners that are appointed on their behalf.
I understand. Just on that, President, Did you try and make arrangements for them to participate by online? So in the past, and I've been on this committee for six and a half years, or attending the committee for 6.5 years, and it's not unusual to have commissioners or other witnesses appear online, even navigating through difficult time zones. That wasn't possible in this case?
So for 2 of the commissioners, they're overseas on pre-arranged annual leave. We were advised, I think, in early December that the dates for this hearing were 9 to 12 February, and Commissioner Sivaraman, for example, is available on the 10th, 11th and 12th of February, but wasn't available on the 9th of February, and the date of the 9th of February was only confirmed to us, I think, 10 days ago.
Okay.
And so for us, you're looking at 7 commissioners, a president and the chief executive, setting aside a 3 months notice, 4 days. And we had, I think on Thursday, every single one of us available if estimates had been held on Thursday the 12th. Monday the 9th of February was the worst possible day, which 2 senators were overseas on annual leave.
Well,
sorry, 2 commissioners. Sorry.
Murphy's Law of Estimates.
Yeah.
Can I just ask you, is everyone going to be able to attend the budget estimates, the 2-week period? Is that... Are you making arrangements to make sure all the commissioners can be in attendance then?
What dates are those?
Oh, I couldn't tell you off the top of my head, but the dates are public.
Yeah, so we'll make every endeavour to make sure people are available. I think I think we're talking about. Sorry, I don't want to
after the budget.
Preempt it.
Yep. Okay.
But understand the importance of this and understand the importance of this Parliament's oversight of the operations and expenditure of the executive, and I'm here on behalf of the agency to answer as best I can.
Thanks, President.
25th to the 28th of May.
Yeah.
Fantastic. Thank you. I will now move into some questions, and it does go to the Human Rights Commission's response to anti-Semitism. Are you able to give a summary of the specific actions that your office has taken since October 7, 2023 in relation to the rise of anti-Semitism in Australia?
Yeah, so completely agree. Anti-Semitism has risen in Australia. That's been well documented in a number of ways. The principal way, if you look at our sort of core function, it's through the legislation that we administer by receiving complaints of racial discrimination. So we have received around 50 complaints of anti-Semitism or similar racism and prejudice since 7 October 2023 under the Racial Discrimination Act. We have conducted the Seen and Heard project. So that's a project which is engaging with communities in Australia affected by the violence and war in the Middle East, and that includes engaging with Jewish communities in Australia, and so we've had good participation from Jewish communities in that consultation, looking at their experiences of racism and anti-Semitism in Australia and how to respond to that. We have been asked by the Australian Government to conduct the largest ever study of racism at universities. So we've conducted the Racism at University study that involved sending over 1 million surveys to students and staff at 42 universities across the country about their experiences of racism more broadly, but the government's terms of reference or reference to us asked us specifically to focus on issues including anti-Semitism and racism against First Nations people and Islamophobia and anti-Palestinian racism, and we've had good engagement from Jewish students and staff in responding to that survey. I think we received around 76,000 survey responses in total, and we're working with the government on the timing of the release of that survey data and the report that comes with it. And then spoke in my opening statement about the National Anti-Racism Framework as well, which is a framework to address racism more broadly in Australia, but obviously has specific relevance at the moment with the rise in anti-Semitism in Australia. And on top of that, we've engaged regularly with Jewish community organisations, the Special Envoy for Anti-Semitism and the like.
In light of the recent Bondi terrorist attack, do you think that you have done enough in the lead up to the tragedy? Is there anything looking back that you would do differently?
Yeah, I think obviously a horrific tragedy where people lose their lives because of hatred and racism is always a cause for reflection on whether you have done enough within your powers and mandate to address that racism. And I think you can always do better. I certainly, when I started this job in July 2024, there was feedback from parts of the Jewish community that we hadn't done enough to condemn anti-Semitism. I took that feedback very seriously and made it clear my position that anti-Semitism was rising. It had to be condemned. It was dangerous. If it was left unchecked, it leads to violence. And particularly around, so that there was no doubt around issues like we saw the celebration of the killing of innocent people in Israel in the October 7 attacks. We saw that celebration here happen in Australia, and I condemn that. I think my colleagues, I think we've made at least 43 statements on anti-Semitism, condemning anti-Semitism since October 7, but I don't think that includes media commentary and the like.
Okay. I guess, what specific programs and initiatives have you adopted within your office to combat anti-Semitism?
Well, I'd refer you to my answer before,
So
particularly the seen and heard.
Okay.
So there's the core function in terms of receiving complaints of racism, anti-Semitism. It's covered by the Racial Discrimination Act. We inquire into those complaints. We attempt to conciliate them. Some of those complaints are resolved at conciliation. Some we can't resolve, and they go on if the complainant continues them to the court system. So the complaint by Peter Wertheim against Wissam Haddad, for example, is one that we received that went through to the federal court and was determined at the federal court. That's our core function. But we also had those specific projects, the Seen and Heard project, the Racism at University project, the National Anti-Racism Framework, as well as responding to government inquiries and around specific measures to respond to anti-Semitism. So we engaged with this Parliament's review of laws to address doxing, the prohibition of Nazi symbols, the recent debate around the hate speech laws and the laws that were passed through this Parliament. So we've been closely involved in those, providing our expert advice as to how to achieve the human rights goals of that legislation in the most effective way.
We might rotate because I might pick up on some of that, so it's probably a good time to...
Thank you.
Can I
Super
ask one
helpful.
follow-up question? Just one.
Very brief, yes.
President, I think you would have seen some comments that have been made about why it was up to Mr Peter Wertheim to have to bring that case under 18C. So why was it up to the Jewish community to have to bring that case, ultimately successful case, under 18C? Why can't the Australian Human Rights Commission or indeed any other agency, government agency, actually step in and take the burden of actually taking those sorts of matters to court, get an outcome and send a message to the broader community?
Yeah, thanks for raising that. And I think I've heard that feedback now a couple of times, and it's important to understand our role under our legislation. So we do not have regulatory powers in relation to bringing civil action around racism. We do have some regulatory powers around sex discrimination and sexual harassment. They're new as part of the Respect at Work reforms. And so we are a regulator of that positive duty to prevent sexual discrimination and sexual harassment in workplaces. We've argued that that positive duty should be expanded to the Racial Discrimination Act, the Disability Discrimination Act and the Age Discrimination Act, so that there's that positive duty and we have appropriate regulatory powers. We don't have those powers at the moment. 18C is a civil provision which allows an individual person to bring a complaint. The case law around when a group can bring a complaint. So we've engaged with the Executive Council of Australian Jury on this to say, do you think the law, what's your views about whether the law should be changed? And this was in the public debate in December after the Bondi attack around the ability of a representative organisation to bring a complaint on behalf of an individual, so the individual doesn't bear the stress and potential cost and of bringing that complaint. And so we've had discussions with the government around whether that reform should be made or not, and there's different views around it, but certainly it's an issue where we agree individual people should not have the burden of trying to address racism, systemic racism in our societies. People should have that pathway should they choose it, but there should be other ways to prevent and address that.
Okay, thank you.
Thank you, Senator Scarr. Senator Polley.
Thank you, Chair. I just have a couple of questions, if I can, in relation to the Sex Discrimination Commissioner, Cody. So to you, President, how do you engage with the Safe Work Australia to provide a consistent message to employers on the proactive steps that they need to take to protect their workers from sexual harassment in the workplace?
Yeah, thanks for the question. So I think what we, as I mentioned just before, have the positive duty regulatory powers now. So this is an obligation on workplaces broadly across the country to take positive steps to address sexual harassment and sexual discrimination. Those issues are workplace health and safety issues, so it's important for us to collaborate with workplace health and safety agencies and Fair Work Ombudsman. And so we have regular regulator roundtables where we actively collaborate with those agencies to look at how we can most efficiently and effectively use the resources and powers that we've got to address inappropriate workplace behaviour. From our perspective, addressing sexual harassment and sexual discrimination and related conduct from the WorkSafe Australia and similar bodies to address safe workplaces more broadly. And the preventative approach that has been in occupational health and safety laws for many decades now, it's that mindset that we're bringing to the positive duty powers in the Sexual Discrimination Act.
So what resources and communications do you use to be able to get that message out to employers?
Yeah. So we have a suite of we want to make it as easy as possible for employers to comply with these laws. So we have guidelines, regulatory guidance, information targeted at workers and employers as well about what the positive duty is and how employers can satisfy their obligations to provide a safe workplace in relation to sex discrimination and sexual harassment. We collaborate with other agencies, the State and Territory Commissions, Fair Work Ombudsman, Safe Work Australia. We're hosting a breakfast with business leaders in the retail sector this month to raise awareness of that and talk about effective strategies. We want people to share their knowledge. We want people to be proactive, and it is far better to prevent sexual harassment and sex discrimination than respond after the fact, after the damage is done.
So in your engagement with employers, do you think there's really enough awareness of the positive duty under the Sex Discrimination Act? And if not, what are your priorities around raising that awareness? Because we still get lots of reports. So can you step us through what the priorities have been about raising that awareness?
Yeah. Awareness is increasing. There's surveys that have documented levels of awareness. The Human Resources Institute of Australia did a survey that provided some positive feedback about what employers think about the benefits of the positive duty in terms of creating better and safer workplaces. We're taking we conduct a periodic prevalence survey around sexual harassment in workplaces, and we've looked at that data to identify workplaces which are at the highest risk of having sexual harassment, and that's why we're focusing on retail and hospitality in particular in terms of raising awareness of the positive duty and engaging with workplaces there to address the risks of sexual harassment. We've proactively engaged with large retail employers to, on a voluntary basis, engage with them and say, we're seeking information from you about how you are responding to these legal obligations, which are relatively new. So there's some of the examples that we've used through social media, animations, videos, resources and the like.
Would you be able to table some of those examples of how you're actually getting that awareness out? Because in those particular areas that you identified, it's well known that they're, as a young person starting out in retail, don't feel that they have the experience. They're hesitant about losing their jobs, so there's a lot of intimidation, as I said. So any further information for the committee would be most useful.
Absolutely.
Thank you. Thank you, Chair.
Thank you very much. Senator Faruqi.
Thank you very much, Chair. Good afternoon, everyone. I might start with some questions for the President. President, you earlier spoke about rising anti-Semitism. Would it be correct, and would you also agree, that Islamophobia has been rising and pretty much skyrocketing, and racism against First Nations people continues on unabated, and the most recent terror incident, the First Nations people experienced of racism and hate was the bomb that was thrown at an Invasion Day rally in Bulu?
Yes, so on Islamophobia, for example, you can look at a range of data points. The Scanlon Foundation Social Cohesion surveys points to rising negative sentiment against Muslim communities. The Islamophobia Register has registered a significant rise in incidents of Islamophobia. After the Voice referendum in particular, there's been evidence of an increase in racism against First Nations people in communities. So, you're correct. If we look at anti-Palestinian racism, we've received an increase in complaints of anti-Palestinian racism since 7 October 2023, recognising that different communities are affected by, Australian communities are affected by the violence in the Middle East in different ways.
Yeah. So, President, given this context of rising racism, have you had a response to the National Anti-Racism Framework from the government yet?
The government's public response has been that they have received and are considering the recommendations of the National Anti-Racism Framework. And I think the government...
No, keep going.
I think the government has said that their response was to receive the reports of the special envoys. Our National Anti-Racism Framework was delivered in November 2024, and we've now delivered the Racism at Uni study and that report as well to government, which we expect will be made public soon.
Mm-hmm. So I think the framework was delivered to government now about 15 months ago, and the two reports by the envoys probably 5 months ago.
November 2024 was the launch of the National Anti-Racism Framework, and the envoy reports were around mid to late last year.
Yeah. President, do you know which government minister is responsible for the response to the National Anti-Racism Framework and the overall implementation of it?
Well, I think it affects different portfolios within government. Obviously, our minister is the Attorney General, but it also affects Home Affairs, Multicultural Affairs, First Nations issues. So our engagement is with different ministers and portfolios, but our responsible minister is the Attorney General.
Yeah. So if I could go to the minister. Minister, last year when I asked you about who is responsible for the National Anti-Racism Framework in your government, you couldn't really tell me. You said everyone is. So could I ask you again, which minister is responsible for responding to the National Anti-Racism Framework?
I think the President has just answered that question, Senator.
I don't think it was very clear. It is you, the government, I'm asking.
I'll ask him to repeat his answer. Could you please repeat your answer?
So, President, who do you expect a response from? Will it be like 5 different ministers who will give you a response on the anti-racism framework? Because that's not usually how it happens. Obviously, every strategy like this that is developed, the implementation of it might be a responsibility of a few ministers, but surely there is one point of contact in the government who would take overall responsibility for it. And did you say it was the Attorney General in this instance?
Yeah, the Attorney General is our responsible minister, so this is, from an agency perspective, we're part of the Attorney General's department portfolio agencies, and that's our principal engagement. But we recognise that and understand that racism is an issue that affects different communities and portfolios, and that's why we've been engaging with different ministers in response to the implementation of the recommendations of the National Anti-Racism Framework.
Minister, do you know when the government will respond to the National Anti-Racism Framework?
No, I don't, Senator, but I shall inquire and come back to you with an answer. You appreciate this is not my area of direct responsibility, so I shall
yeah, I understand that, but you're representing the government.
I am, and I'm answering your question as best I can.
Yeah, and could you also, if you don't have a response to this, please inquire as well or notice if the May budget will have any funding for the implementation of the National Anti-Racism Framework.
Well, we wouldn't.
President, if I could come back to you.
Senator, just on that, we wouldn't generally foreshadow what is going to be in the budget ahead of time. I think you may have to simply wait until the Treasurer hands down the budget to get an answer to that question. I don't think I can release that information, even if it is available, ahead of the budget.
Even if there is any intention, because the Treasurer has said there will be tax reforms and other things in the budget. So if there is even any intention of, committing some funding to this, would be good. President, just coming to another topic, were you consulted on the Combating Anti-Semitism, Hate and Extremism Bill?
We weren't consulted on the bill directly. We gave evidence. We appeared before the Parliamentary Joint Committee on Intelligence and Security earlier this year and gave evidence which was that we had some engagement with the government. Senator Scarr asked a question about Section 18C and potential reform there, so individual people don't have to bring those cases. So we had some engagement with the department and the government around possible reforms to that provision. That was in
yes, that is the recommendation of the NAF. What I'm asking specifically is because the government did consult with some stakeholders on this particular bill. They showed some the draft copy of the bill, others they didn't show the draft copy. Were you shown a draft copy of the bill and consulted directly by the government? No, we had an initial high-level consultation around principles around hate speech and that specific issue which I mentioned around potential reform of Section 18C. Mm-hmm. Was anyone in the AHRC consulted? Not that I'm aware of. Okay. So beyond what I've said before. Yeah. No. So the Race Discrimination Commissioner was not consulted on a bill that is purportedly all about combating hate and racism. The consultation that we had was what I said before, and that was through myself. Are you concerned that the AHRC or no one in the AHRC was concerned on such significant changes to political and human rights and democratic rights, which so many legal experts have opposed?
I should have clarified before that that consultation that went through me with the department was in consultation at our end with the Race Discrimination Commissioner, the Human Rights Commissioner and others. In terms of whether or not, I mean, it's a matter for government about the extent to which they share the draft legislation with us. We absolutely said we stood ready to provide that support if it was helpful for government. We received the draft bill when it was released, and we had a consultation with the department shortly after it was released, around the time we were giving evidence at the Parliamentary Joint Committee on Intelligence and Security. And that consultation was very useful.
Thank you, President. This last question from me. You are, President, the highest human rights officer in the country. So I would like to ask you if it is appropriate for the Government of Australia to roll out the red carpet for the head of a state which is committing the atrocity of genocide on Palestinians. And will it help or hinder social cohesion?
So the question of who the government invites is a matter for government. I acknowledge that there are very strong and different views in the community more broadly about the issue of President Herzog's visit, and within the Jewish community, and particularly that the visit causes, the purpose of the visit is to provide comfort for the Jewish community who's mourning the deaths of 15 people through that attack. But I also understand that for the Palestinian Australian community and for people who support justice in Palestine, it is a source of great distress.
Thank you, President. Thanks, Chair.
Thank you, Senator Faruqi. Senator Blythe.
Thank you very much, Chair. And I will sort of pick up a little bit of what Senator Faruqi, just in terms of the consultation for the bill. So in terms of even, I guess, proactive advice in the lead up to Bondi, so it's anti-Semitism was rising in Australia for years prior to the terrorist attack in Bondi. Did your office sort of provide any advice to government or any recommendations on what could be done to sort of temper what was happening out there, other than your recommendation for 18C?
So if you're talking over that period of 2 years, there was a range of submissions and engagement that we had with various inquiries at the federal and state level, because, for example, in New South Wales, there's been various reviews around hate speech laws pretty much in all Australian jurisdictions at different times. There's reviews of these laws, and to the extent within our resources as a federal agency, we try to provide our expertise around how to make sure those laws are effective, and how to make sure that in addressing hate speech and incitement to prejudice-motivated violence, that you uphold freedom of expression and freedom of association and freedom of and peaceful assembly to the greatest extent possible. So I mentioned before, we engaged with the inquiry into doxing laws, for example, the prohibition of Nazi symbols, the various federal and state criminal law responses, the incitement to violence provisions in the Federal Crimes Act, also reviews of the New South Wales provisions. We, in response to community concern and public debate around protest and when it's legitimate to restrict protest to address hate speech and incitement to violence, we published, for example, an explainer on our website around the human rights, what international human rights law says about where and when you can draw the line, and how law enforcement should respond to particular forms of protest. and then I mentioned those specific projects that we've had, seen and heard, racism at university, National Anti-Racism Framework. National Anti-Racism Framework has 63 recommendations. Racism at University project has recommendations in it. We're engaged with the Special Envoy into anti-Semitism and Islamophobia as well. We have had a lot of dialogue with her around how to address the common forms of racism and then the unique forms of particular forms of racism like anti-Semitism or Islamophobia or First Nations racism.
I guess in this case I'm referring predominantly to anti-Semitism because that is what has resulted in the tragic death of 15 innocent people. So in terms of the escalation that was happening for the 2 years prior to the Bondi attacks, where we did see, protests, there were lots of things that were said that were inciting violence. I guess, did you make any specific recommendations to government around those things in terms of what could be done to bring down the heat, I suppose?
Yes, certainly if you look at the Anti-Semitism Envoy's report and the National Anti-Racism Framework recommendations, there's strong alignment on issues like education to...
And I guess those recommendations were there. They've only been adopted post-Bondi by the government. And so that's for the Special Envoy to make those recommendations. And then, but I suppose, did you make any specific recommendations to the government as the Human Rights Commission?
Yeah. So in November 2024, we made recommendations around education, law reform, better measurement of whether racism is increasing or decreasing, addressing mis and disinformation online, recognising that there is a sewer of hatred in social media. Those are things that we discussed with the Anti-Semitism Envoy and that align with those recommendations in her report as well.
I guess in terms of current enforcement of federal laws, do you think that the laws that we currently have are sufficient to address anti-Semitism?
I think that we've talked at this hearing about Senator Scarr raised the issue of should individuals have the burden of bringing race discrimination complaints to address systemic racism in our community and in workplaces and institutions and the like. Our view, like we talked to Senator Polley, asked me about the positive duty to address sex discrimination and sexual harassment. We recommended in 2024 that positive duty be implemented in the Race Discrimination Act so that you expand that positive duty from Sex Discrimination Act in workplaces to the Race Discrimination Act. There's a review underway around the Disability Discrimination Act, which will be looking at the positive duty there as well. Certainly we've been engaging with the government around those recommendations
But they didn't pick that up for this new bill that's just gone through. You weren't asked, or your advice wasn't taken into account.
Those reforms.
That's extraordinary.
You can look at aspects of that bill. One aspect that wasn't followed was the criminal incitement of racial violence. Since 1975, when Australia signed up to the International Convention on the Elimination of Racial Discrimination, we've had a reservation, which means we say we comply with all of this international treaty, but we won't comply with these parts, or we have a reservation on those parts. One of them is the criminalisation of incitement to racial violence and racial discrimination. Another one was the prohibition of groups that promote race discrimination. And we have consistently over many, many years asked for the Australian government to remove that reservation and take action to address those provisions. So we welcomed the actions of the Australian government to in the recent legislation to address those two issues. One of them ultimately was dropped from the bill through negotiations in the Parliament, and we had views about the scope and safeguards around them, but we've been calling for action on those two issues for many, many years.
But I guess that's not in relation to anti-Semitism, which is what the bill was. Like, I just find it extraordinary that you weren't consulted to provide your, I guess, advice from the experience that you have within your department. But
I've talked about the engagement.
Yeah, no, that's fine. Thank you.
Thank you, Senator Blythe. Senator Cox.
Thank you very much, Chair. Thank you, President, and other commissioners that are appearing here today. I have a couple of questions in relation to whether there are any statistics, and Commissioner Kiss might join you at the table as well, given this is quite relevant to First Nations racism. Any statistics that on the prevalence of racism experienced across Australia, whether it's in workplaces, in communities, in schools, what does that look like from the Australian Human Rights Commission's perspective currently?
Thank you for the question, Senator. Katie Kiss, Aboriginal and Torres Strait Islander Social Justice Commissioner. I don't have exact stats, Senator, but we do know that there has been an increase in race discrimination complaints by 28%. And some of that is obviously Aboriginal and Torres Strait Islander people making those complaints and bringing them to the Commission. We also are aware that the Jumbunna Call It Out racism register has also seen an increase, particularly since the voice referendum on complaints made directly by Aboriginal and Torres Strait Islander people and witnesses to racism as well, making complaints under that register or notifying that they've been subjected to that.
Great. I don't know, President, on behalf of the Race Discrimination Commissioner, could you comment on that more broadly?
There's different data points, as Commissioner Kiss said. You can look at our complaint statistics. First Nations people under the Race Discrimination Act, I think around a quarter of the complaints are made by First Nations people. The Scanlon Foundation survey, which I mentioned previously, documents experiences of racism or attitudes towards different communities. I think the Reconciliation Australia barometer after the voice referendum documented a rise in racism against First Nations people. My colleagues just shared 20% of our complaints under the Racial Discrimination Act are from Aboriginal people, less than 1% from Torres Strait Islander people. So it forms a significant part of that work under the Racial Discrimination Act. But more broadly, we think there should be better data collection to be able to measure progress and regress on racism in Australia. The Racism at Uni survey, we talked about anti-Semitism, that has had a big focus from, as the government asked us to, on experiences of racism by First Nations staff and students in universities across the country. And so that survey, when it's published, will have really important data as a baseline that we can then measure whether things are getting better or worse over time. We want them to get better, and we've got recommendations in that report and in the National Anti-Racism Framework about how to address racism and reduce the incidence.
That's great. Which sort of goes to the heart of my next question, is that, and referenced within your opening statement, was the recent incident in Perth at an Invasion Day rally that was directly linked to and now called an alleged terror attack, but towards First Nations people and the rise of racism in and across Australia. Are there any practical steps that you think could assist us with breaking down some of those racial barriers towards, as I said, both in community, in employment, schools? Like, what does that look like in relation to those practical steps that the Australian Human Rights Commission could think about telling us a bit more about, because they're so important to our social cohesion and our unity as a nation?
I might make some initial comments and then hand over to my colleague. The National Anti-Racism Framework recommendation the key recommendation is for the Australian government to set up a task force to work through and implement the recommendations of the framework and have a specific implementation plan for First Nations racism, recognising that there are unique aspects to First Nations racism. And so...
and just on that point, that's about the truth-telling aspect. Am I correct? Just to clarify.
So your truth-telling was a specific recommendation in the National Anti-Racism Framework. And, you know, Senator Stewart and I, Victoria, would work closely on that. We've seen the power of truth-telling as a means of building understanding and connection, and that understanding of historic injustice and the connection between that historic injustice and what's happening now around issues like child removal rates, inequality in employment, housing, education, over-imprisonment. And so that's why we're calling for national truth-telling. And the National Anti-Racism Framework has a range of recommendations around media, around social media, around education, around employment, healthcare, and so on.
Fulsome sweet, thank you. Commissioner, did you want to add anything to that?
Thanks, Senator. The Commission's also had a number of campaigns around addressing racism. So the Racism It Ends With Me campaign is something that's been activated by the Commission. Obviously, we also have the National Closing the Gap Agreement, which Priority Reform 3 requires systemic structural transformation by government for its institutions and agencies to eliminate and eradicate racism across its systems. We're working closely with the Attorney General's Department to have and progress those conversations about how do we do that in a constructive way. There's also obviously the United Nations Declaration on the Rights of Indigenous Peoples, that if we followed that blueprint that has been established, developed and lobbied for by Indigenous peoples across the world and adopted by the Australian government, if we implemented that, that would go so far in terms of addressing the issues that result in structural and systemic racism for Aboriginal and Torres Strait Islander people. So I think there's a number of things that we can do in addition to the full implementation of the National Anti-Racism Framework, and those things create a full response.
Thank you. That's all the questions for me. Thank you.
Thank you very much. Senator McLaughlin.
Thank you. I'd like to go to the issue of the social media ban and intersection with human rights. I think we had a discussion last time. I just have a couple of questions.
Yeah, so I might ask Commissioner Finlay to respond to that.
You've previously introduced yourself.
Yeah. Commissioner Lorraine Finlay, I'm the Australian Human Rights Commissioner.
Thank you. Just building on our previous discussions, because I had a concern, like some others, that it would prevent young people from, say, advocating for changes to how we treat the environment. But I'm interested whether the Commission has received any correspondence or engaged in any dialogue with international civil society organisations regarding Australia's approach to the legislative framework.
Perhaps the best way I can answer that, Senator, is to say there has been informal dialogue, but certainly I've received, and I'm sure the Commission more broadly has received correspondence from members of the public in Australia, but not formal correspondence in terms of any other international civil society groups or indeed other countries that might be thinking about policy along these lines.
So have you, post-legislation, and given there seems to be ongoing community interaction with the legislative framework and commentary, done a comprehensive assessment or formal examination of its compatibility with our international obligations?
If I can answer that in two parts. The first is at the time the legislation was introduced, we certainly did make a submission and put an explainer as well up on our website that outlined the human rights impacts, both positive and negative, in relation to the social media ban. Subsequent to that, we haven't done a full analysis of the impacts flowing from implementation, but that's something that I understand is being done by the officers that are responsible for the regulation of the ban, like the Safety Commissioner. And certainly one of the recommendations we made in our submission related to the need to have clear data sets and clear evidence so that we can assess the effectiveness of the ban and understand those impacts.
Yeah, that's what I'm trying to tease out, because it's a work in progress and it's new legislation and it's unique. So my questioning is sort of coming from that perspective of process and the process that it will take if it finds its way back to you for a more formal assessment. And what would drive it back into your arms? Increased complaint, public debate, or are you expecting to sort of stay in the house of the E-Commissioner, and in future estimates I direct my questions there? I just want to give you the sort of, I'm not coming from a negative perspective, I'm just trying to understand, given there's human rights debate ongoing, other jurisdictions are looking at it, will it come back into the Commission at some point, or
we
possibly?
certainly have a continuing interest, Senator, in terms of the human rights impacts from a principled level. In terms of the actual evidence base that would allow you to assess the effectiveness of the ban, that's simply not something within our capacity in terms of being able to collect that evidence or make an initial assessment of it. That really is within the realm of the E-Safety Commissioner.
Yes, the Minister Wells did indicate on the Today show that no humanitarian rights were being violated. Yet there's a body of community dialogue, if I could put it that, at the lower level, at the higher level, international debate. Is there a point where we're going to? At what point does that juxtaposition, does that come back to the Parliament, or I suppose, rather than necessarily back to yourselves? Maybe I've asked the same question twice, but I'm trying to understand if this is continuing to be an issue in the community, do members of Parliament take it on board? I suppose the answer is yes. Or is there some point where we get guidance from yourselves, or do we seek it out? It's more, it's part process, part philosophical question, so I appreciate it may be difficult answering.
So our functions are around promoting public acceptance and understanding and discussion around human rights. So this is a very topical human rights issue about banning people under 16 from using a form of communication. There's cases before the High Court of Australia, so there's limited protection of human rights in the Australian Constitution. One of those protections is the implied freedom of political communication, and there is a case, two cases before the court, which is progressing at the moment, so the court will presumably rule on that at some time this year. And we provide advice to parliamentary inquiries and law reform inquiries around making sure that Australia's laws and policies comply with human rights. It's up to the Parliament about what the Parliament does in response to our advice. So that's the engagement we had previously.
Yes.
We could potentially conduct an inquiry around something like that, but those would be our functions. In terms of the regulation of those laws and administration of laws, that's not our function. That's the E-Safety Commissioner and similar bodies.
Yes. If I could just perhaps add in, of course, there is also the function for the Parliament in terms of inquiring into legislation that exists, and we would engage with any inquiries of that nature that might come up over time.
Yeah, I'm not asking for a place of naivety. I'm just trying to look at the environmental aspects of, I mean legislatively, and look at the trigger point. And I think I come back to the next trigger point from my perspective is probably the High Court judgment on revisiting the intersection of the rights. So that's all I have, Chair. Thank you.
Thank you very much, Senator McLaughlin. Senator Shoebridge.
Thanks, Chair. Thanks all for your attendance. And I'm sorry not everyone can be here, but I understand this was possible notice, and I heard your description earlier, President, about how this came to be. There is currently significant division in Australia. We see thousands and thousands on the streets, deeply distressed that the Prime Minister has invited the Israeli President here. for myself, I think that that was an invitation that was certain to cause division and certain to cause distress. But was the Human Rights Commission consulted by the government in any way before the invitation was issued? Did they come and approach you?
No.
Is there, are there resources and is there capacity in the Human Rights Commission to provide that kind of advice to the government if they ask? Are there any circumstances where you can remember it happening?
I think it would be unusual for the government to ask our advice about a visit from a foreign head of state.
But it's unusual to have a foreign head of state visit while senior members of that government have arrest warrants out for them in the International Criminal Court, while there are international tribunals that have stated that the actions of the president were complicit in the crime of genocide. And it's unusual to invite a head of state here who's actually signed artillery shells and bombs that have been sent into an occupied territory. I mean, it's an unusual circumstance, isn't it?
Yes, but we weren't consulted.
You weren't consulted. I think my colleague Senator Fariki was asking you about other measures that could be done to address racism and, deal with racism in all of its forms. Sorry, I should draw that. Senator Fariki was asking you some questions about, recommendations you've made. I think dozens and dozens of recommendations that haven't been funded and implemented yet. In terms of sort of overcoming some of that divide, going in the opposite direction of division and sort of bringing people together to sort of some common healing. What do you think the most urgent of those recommendations are to be funded and implemented? I know it's hard to ask, but if you're in the invidious situation of saying, well, I'm just going to grab a handful of them and I'd love these funded and implemented now. Yeah. Where would we start?
It's a good question. The National Anti-Racism Framework, the primary recommendation we're focusing on is for a task force to be developed with representatives from government and from civil society to work together looking at the 63 recommendations we have to develop an implementation plan with a prioritisation matrix around saying these are the most, so you're weighing up, the resources and effort against the impact and the timing and the urgency to say that these are the things that should be implemented. So that's our primary recommendation. We think the task force should be established and that can then work through the recommendations to prioritise them and implement them.
And can you remind me when those recommendations, which start with the task force, when they were given to government?
November 24.
You see, the longer it's not implemented, and then the more often decisions like, we've seen. I'm going to be critical. I'm not asking you to necessarily adopt my criticism of decisions like the Prime Minister's invitation to President Herzog and those sort of divisive decisions are made. The task is getting harder, not easier, isn't it? When it's not being addressed, when drivers of racism are not being addressed.
Yeah, I think...
So delay comes at a cost is what I'm trying to say.
We've seen rising racism in Australia, particularly, after the Voice referendum against First Nations communities, after 7 October 2023, rising anti-Semitism, Islamophobia, anti-Palestinian racism, anti-Arab racism. And there's various sources that have documented that. The Director General of ASIO has given advice to this committee and to Parliament around the risks and the threats that have flown from that around anti-Semitism, but also around Islamophobia. And so we think it's absolutely urgent to address racism in Australia.
Now, WA Police, only a few days ago, when they announced that there were going to be terrorism charges in relation to the attempted bombing of a First Nations rally in Bura in Perth, they said that the hateful ideology that was that had generated that attack, that attempted mass casualty bombing of a First Nations rally, was, I think, white male hate. And then when I asked the Australian Federal Police about to what extent that kind of hateful white male ideology was driving potential terrorism and threats of terrorism, they said over a third of the matters they're investigating are driven by that ideology. To what extent are you seeing that in complaints or the work of, or the reports or the feedback you're getting with the community?
We don't administer anti-terror laws, and so the criminal laws, it's more our engagement with, so we've had dialogue with the Australian Federal Police and with ASIO around what they're seeing in relation to rising threats and extremism and terrorism, and the changing nature of those threats over time, recognising that the trend that you just spoke about is happening, and also that younger people with often conflicting and incoherent ideologies are being radicalised, particularly online, and so we're seeing those changes that have been documented by law enforcement agencies.
Are you having any engagement with law enforcement agencies to try and address some of their conduct? And I'll tell you my personal experiences, having gone to, I couldn't tell you how many public rallies and protests for First Nations justice. It's my experience in those rallies, the police are there not to protect the First Nations peoples and their allies, but to, in their eyes, protect whatever organ of the state they're protesting against, the Parliament or the police or whatever. And when you have a look at how slow it was, the lack of police, what looked like effective police liaison over at Buru, and the difficulties in clearing the crowd because there wasn't a degree of trust, it seems to me. Are you talking to police about perhaps changing their mentality from policing those rallies to protecting those rallies? Is there any of those discussions?
I don't know if my colleague Commissioner Kiss wants to.
Yeah.
Commissioner Kiss met with WA Police about this specific issue.
Yeah. Thanks, Commissioner.
Thank you, Senator.
Yeah, so it's my experience in those rallies, the police are policing the rally, not protecting the rally. You know, horses and often riot squad directed at the rally, not directed at threats to the rally. But at Boorloo, we see the reality of the threats. Are you having any of those conversations with police?
I have had those conversations with police, particularly last week in the wake of that attack. I was briefed by Commissioner Cole Blanche last week, myself and the Race Discrimination Commissioner. We did talk about the fact that the majority of our experience has been policed at gatherings of First Nations people, rather than a focus on keeping us safe during our right to gather and to have discussions that we need to have about issues that affect us.
Yeah, and you know, to the extent you feel, I mean, I think those frank conversations with the police, I'm really glad you're having them, Commissioner, and I think they've been a long time coming. To the extent you feel safe, can you talk about what the response from the police were in those rallies?
Commissioner Blanche accepted that there's been a tense relationship between First Peoples and police over generations. He accepted the fact that our experience is often that we are being policed rather than being kept safe. Obviously, my communication with Commissioner Blanche was relevant to the relationship with his officers and the community of Perth and the Noongar community over there. So I haven't had conversations more broadly about that with other jurisdictions, but I would be keen to engage in that. Because I think it's not just an issue for Western Australia, this is a national issue.
Yeah, well, I can tell you from my experience, it's an issue in my home state of New South Wales, and you know, when I've been out and about in a place like the Northern Territory, there's a very similar feel about not being protected but being policed. When
and
First
I'm from
Nations
Queensland, so
well, yeah.
yeah.
Thanks, Commissioner, and to the extent to which you can make that work visible.
Yeah.
And report on it.
Yep.
I think it would be an incredibly useful contribution, and I thank you for doing the work.
Thank you. Thanks for asking the question.
Chair, I have just another but I'm happy to hand over the call if others have questions.
Yeah, I think Senator Scarr's got a very short
question. Just very short. And Commissioner Finlay, perhaps you through you, President. One issue I can't remember touching upon with the Australian Human Rights Commission in the context of budget estimates before is the position of our diaspora community. So certainly, President, you referred to the position of people of Palestinian heritage, also many people of Jewish heritage come from Israel or wherever. We've talked in that context. There's been some terribly upsetting events in Iran recently, and, well, over a number of years, the Woman Life Freedom Movement, and then we've seen the demonstrations that occurred in late December and through January, the disgusting response from the existing Iranian regime. Iranian Australians and their allies have exercised their right of peaceful protest in our country, and I've certainly received reports, and I'm sure my fellow senators have received reports of threats, intimidation, the attempt to silence members of the Iranian Australian diaspora who are seeking to speak out for human rights for their own, for their people and their families, their brothers and sisters in Iran. Has the Australian Human Rights Commission undertaken any activities with respect to the right of political freedom expression of diaspora communities in the context of foreign interference and intimidation?
We have, Senator, and possibly the two things that spring immediately to mind are, firstly, we did engage with the parliamentary inquiry that happened a few years ago now and provided a submission to that. But more recently, on the 10th of December this past year, I spoke on a panel at an Amnesty International Human Rights Day breakfast on that very topic, and there were representatives from a number of different communities who all reflected the same experience that you just spoke about, and the need for this to be recognised as a human rights issue of significance here in Australia.
Because many of these diaspora communities, I can think of the Eritrean community as well, are extraordinarily brave in terms of speaking out for human rights in their countries of origin. Do you liaise with any of these community groups? Do you actually engage with them and try and provide support in terms of their advocacy?
We certainly engage with a wide variety of community groups, not only myself but all of my Commissioner colleagues, both through the formal project work that we do, but also through the various community engagements that we have. I would say that our focus in all of those activities isn't so much on the global context or the international affairs aspect, but more the impact on Australian communities, reflecting our primarily domestic mandate.
Because it seems to me it's a phenomenon of overseas regimes that trample on human rights in their own home jurisdictions, then seeking to intimidate voices in diaspora communities who are residing in countries which in many cases gave them refuge and who are seeking to exercise their political freedoms in their countries of residence. So it's a particular pernicious form of extension of human rights violations beyond the countries where the regimes exist to countries which are liberal democracies. So it seems to me it requires a particular response from those liberal democracies, including ours. Would you agree?
Yes, I would, Senator.
Okay. All right. Thank you.
Thank you, Senator Scarr. Senator Shoebridge.
Thanks, Chair. And yes, to all of those concerns that Senator Scarr raised, and it's the Iranian community in particular have felt it, but I know the community, the Pakistan-Australia community, the Hong Kong-Australia community, they have, I could, the list is extensive, and the reach into our open and free society is real, and they're feeling it.
Yes.
I've seen it with the Sri Lankan community as well.
Absolutely. The Tamil community in particular feel it. Well, actually, which is a useful move to the next line of questioning.
Segue,
thank you. recommendation 17 of the anti-racism framework supports putting in explicit legal protections against caste discrimination. Is that to you, Commissioner Finlay, or
to the President?
To the President. You remember, aware of that recommendation, President?
Yes.
Yep. Recently, a complaint was lodged with the AHRC by by two groups. And just bear with me 1 second. By the Alliance Against Islamophobia and by the Peria and Bedka Thought Circle of Australia, or PAPCHA, under the Racial Discrimination Act, against Multicultural New South Wales and the Minister, alleging caste discrimination in funding and other conduct of the New South Wales Department and Minister. Are you aware of that complaint?
I can't discuss. So our legislation, Section 49, actually has criminal provisions that prevent us from discussing matters relating to complaints.
All right.
But in general terms, I'm aware of the reason for that recommendation in the National Anti-Racism Framework and the general international and domestic law around caste discrimination I've looked at recently around issues of complaints.
Yeah, and caste-oppressed communities in this country are concerned that our discrimination law just doesn't mention them. Yeah. And the discrimination can be employment discrimination, social discrimination, just overt exclusion from community groups and spaces. And you know, I've had members of caste oppression groups say this is real in Australia and it's part of their lived experience in Australia, and our discrimination laws don't protect people from it. What's your understanding about legal protections for caste oppression and discrimination?
So this issue came to me last year, and I looked at the National Anti-Racism Framework, and you know, particularly in the Indian community, there's the imported caste discrimination that's happening in Indian community here. The Racial Discrimination Act, I'm hesitant to try and be specific here, but broadly talks about descent and social origin. And I asked for advice from our legal team looking at the international law around this, around whether we could accept complaints of caste discrimination, looking at the interpretation of those provisions in the Racial Discrimination Act. And there's some nuance to it, but our advice to a particular group was, yes, we can. It hasn't been tested in Australian courts, but our view is that we should adopt a beneficial interpretation of those words in the Racial Discrimination Act that permits us to receive certain complaints of caste discrimination. I think it varies depending on the area in which the discrimination occurs in the Race Discrimination Act, which is drafted differently from the other discrimination acts. But the recommendation is in the National Anti-Racism Framework because there is uncertainty around this and because this is a problem that should be very clearly outlawed under our discrimination laws.
And I'm not going to ask you for a full considered legal position about the extent of caste discrimination protection in other state and territory laws, but did you review whether or not it was picked up in any state or territory law?
I would need to, I can come back to you on notice around that. And obviously was consulting with particularly Commissioner Sivaraman, he's the one engaging with the most with multicultural communities in Australia and receiving this feedback.
Well, then perhaps I might, because that Commissioner's not here, Sivaraman, I may put a question on notice. Can you advise this committee about the extent to which either your complaints or your other work is finding evidence of caste discrimination and the extent to which you're able to effectively deal with complaints or those issues, given the statutory remit you're given? All right, thank you.
Thank you very much, Senator Shoebridge. That concludes the questions we have for the Commission. Thank you for your time this evening. We will suspend very briefly while we welcome the National Anti-Corruption Commission. Okay, I now call officers from the National Anti-Corruption Commission. Mr Reid, would you like to make an opening statement?
Yes, I've provided a document which I think will have been provided to you for tabling, so it's quite short.
Yep. The committee tables the document.
As you've been previously advised earlier in proceedings, last Friday, the 6th of February, the Commission was notified by the Inspector that she'd commenced a complaint investigation under Section 1841E of the National Anti-Corruption Commission Act regarding the Commissioner's involvement in defence referrals and assistance to the IGADF. Whilst we've provided substantial amounts of documentation and information in response to the Inspector's preliminary inquiries, it's now at a point where it's a complaint investigation, and we'll respond to the Inspector within the framework and the process of investigation which are mandated by the Act. But in order to avoid prejudicing the investigation, including the procedural fairness process under the NAC Act, I'll not be able to answer questions about matters within the scope of the investigation. Thank you.
Thank you, Mr Reid. We'll proceed to questions, and I'll go to Senator Blythe.
Thank you very much, Chair, and thank you for that. And we will certainly respect the integrity of that investigation. So there is a whole lot of questions that I won't ask you, because obviously that is changing as we speak. In terms of delays and resourcing issues for the NAC. You've received over 3,000 referrals in your first year, which is a huge workload. Can you confirm how many of these referrals remain unassessed or are still waiting preliminary triage?
Right. Okay. I think I have a piece of paper here that maybe it was a Quan that we've answered. Sorry. Let me just. Because we did recently put on the record
Okay.
the number. Yeah, here it is. So this was an answer to a question on notice at another committee, the Parliamentary Joint Committee on the NAC, on the 11th of December, and it was asked by Dr. Haynes. And so the answer that was provided in relation to has there been any change in the numbers since the end of the reporting periods that we've referred to in the 2023 annual report and the 2024-25 annual report. And the answer was yes. The number of open referrals outside the 90-day target has been reduced from 440 at the end of 2024-25 reporting period to 266 as at the 19th of January 2026. And the number of them that were received in 23-24 has reduced from 159 to 78. So there's been a substantial inroad, but there's still a small backlog there.
Do you feel as though your current staffing levels allow you to meet your statutory expectations?
Yes. The challenge in these areas as an organisation that's just turned 2.5 is bedding down processes with staff who are still learning their skills at a time when we also were in a position of a significant attrition rate going on in the first 2 years of our operations, and that's slowed in this third year. Okay. So you've got these elements of starting a new process with virtually nobody from the predecessor organisation that had been involved in the assessment process, as we call it more widely, transferring into the National Anti-Corruption Commission, staff turnover, bedding down processes. And so I think we're at a point where we've turned the corner at just over 2.5 years, but there's still a significant issue that we have to try and deal with over time, because this work never stops. No. Whilst the numbers may have declined from that first year, where I think that there was a significant number of people just waiting for this organisation to begin. At the moment, the numbers for that have come through the door in this financial year are, and we put this on our website, 1,583. So roughly in half of this current financial year and reporting period, we've had just under half of what came through in the first year. So it keeps coming in. We have to keep assessing. It's a never-ending process for the staff to undertake, and I suspect that some people probably don't see an end in sight to being able to, have done this amount of work, and therefore you have a breather because the work keeps coming in. And that's the nature of the assessment processes, and it was the same at the New South Wales Independent Commission Against Corruption when I was there for 5 years.
Can I just ask a follow-up question in relation to that, with Senator Blight's indulgence? And I asked this question having previously served as the chair of the Oversight Committee for the previous anti-corruption agency at a federal level that was limited in its jurisdiction to law enforcement agencies, so the Law Enforcement Integrity Commission. And I was just somewhat concerned by your comment that there'd been limited limited migration, if I can put it that way, of people who were performing that function under the previous agency to the NAC. My understanding was that arrangements had been entered into for those staff to come across to the NAC, so that the NAC from day one would have the benefit, A, of their general expertise, but also B, their experience with respect to dealing with particular matters that were still in train. So why hasn't that worked?
So there's probably 2 or 3 different ways of answering this, but if we look at ACLI in its final year, 22-23, it started the year with 80 staff. By the end of the year, it had 180 because of the active work to recruit in as the legislation was passing through the Parliament.
Yep.
And so you had a lot of people that arrived, and there were people leaving of some of the 80 that were there at the beginning of the financial year had left by the end. And so in some areas there's a great deal of wealth of experience that came across, and everybody had the opportunity to move across, no question about that. But in the assessment area it was fairly limited because it was always a very small function, and the history of ACLI was that they struggled at times to resource that particular area, and their numbers did ebb and flow quite a lot. So yes, there were 180 people that moved into the NAC on day one, but a lot of those people had only been there less than 6 months, and therefore I think what they thought they were coming to wasn't necessarily what they came to. The National Anti-Corruption Commission being bigger but also with broader jurisdiction, I think was something that people didn't necessarily have in their minds when they put their hand up, and that's why I think we had the attrition rate over those first 2 years that was reasonably high, but it was particularly high in the area we call evaluations, the assessment area. It was one of the highest, and so it went through a significant period of reduction of staff and having to rebuild, and we're now close to full numbers in that area. But we've got some people acting in roles, and we're going out to the market constantly to try and keep recruiting, and that's got to also be weighed up with the volume of material that you're trying to deal with on any day of any week.
Yep.
So it's not a criticism of ACLI, it's just the reality of what was available at the time of moving across. It appeared that we had a couple of senior staff that were well versed in the assessment area, and that changed about 6 months in for a couple of different reasons. So.
And just to be clear, I wasn't criticising ACLI or seeking to do so in any way. I think
No, I wasn't either.
I was more concerned about the manifestation of a lack of migration of people, successful migration, long-term of people, and why that might have been. But I'm happy with your answer, so thank you, Chair.
Thank you. Senator Blythe.
Thank you. And I guess going back to the triaging of, and it seems like an endless churn, as you've sort of described. How many of those outstanding assessments do you think would be relating to the current Labor government?
I mean, we normally wouldn't talk about what is within the referrals. We unless it's on the public record, we don't normally comment on what has been referred or what might have been referred to us, and that's partly for operational reasons about not wanting to prejudice our ability to consider matters, but on the other hand, we don't want to impact on reputation. So we've been fairly clear that we don't provide regularly or generally at all information about what's in there, but what we do provide, and we have provided in our updates, is the nature of the issues that are coming across to us, and particularly where we're doing investigations, what the generic sort of area, but we don't usually talk about the individual department or were it parliamentarians, which part of the the Parliament or former parliamentarians, we are quite clear in our minds that that's inappropriate.
Yeah, sure. Thank you, Senator Blythe. Senator Shoebridge.
Oh, thanks, Chair. Thanks, Mr. Reid, for your attendance and your staff. You said that you wouldn't answer any questions about the most recent investigation by the inspector into possible maladministration or officer misconduct by the NAC and the Commissioner because of procedural fairness reasons. You said procedural fairness provisions in the Act.
Yes.
Can you point to the procedural fairness provisions in the Act that would be breached by you disclosing to this committee?
So I might turn to my colleague Rebecca Omar for a bit more detail on that.
Yes, certainly. Rebecca Omar, General Manager Legal, Senator. So in terms of the concern that we have about answering questions that are currently subject to the inspector's investigation, we're very conscious that we don't want to prejudice that investigation in any way. And so there's a couple of parts to that. The first one is in terms of what the inspector's doing. We don't want to interfere with that or prejudge anything in terms of any answers we give. And then the second part to that is in terms of the procedural fairness requirements that are in the Act in relation to the investigation. I think it's 213 of the NAC Act that outlines a process that the inspector will go through. And part of that is when she has her draft report, she will provide that to the Commission for comment before moving to a final report.
How do answering questions to this Parliamentary Oversight Committee in any way limit the Commission's role in assessing a draft report from the NAC inspector? How would that limit the procedural fairness, whatever rights the Commissioner or Commission have in assessing a draft report from the inspector?
It's because that process is embedded in the Act whereby that's how the investigation proceeds, and the ability then for the inspector to consider all the evidence and then to put that before the Commission to consider that as the full evidence that has been gathered and then to respond as part of that process rather than the questions taking place in a public forum and the issues being ventilated there.
Well, I'm mystified as to how you say this will impact procedural fairness in a process being undertaken by the inspector who's already shown an incredible capacity to exercise her statutory powers with procedural fairness and care. How does answering questions about what's happening in this committee with its separate oversight role in any way negatively impact that procedural fairness? You just asserting that it does, I'm mystified about how you say it will negatively impact the rights.
Senator, I don't know whether I can take it too much further. I can let you know that we had consulted with the inspector in terms of the position that we would be taking in relation to the evidence given at estimates and asked the inspector if she had any concerns in relation to our position, and she did not raise any concerns with us.
It's not her job to tell you how to respond to a parliamentary inquiry. She has important statutory jobs, but it's not her job to tell you how to respond to questions from Parliament in the parliamentary oversight of the NAC, is it?
That's definitely true, Senator, but we were consulting with the inspector because she is the one conducting the investigation.
This is now the second time, isn't it, that the inspector has commenced an investigation like this into the NAC and the NAC Commissioner, Mr Reid? The second time we've had an investigation about potential agency maladministration or officer misconduct?
Well, the second time that an investigation's looked at an area of the Commission's operations and the role of the Commissioner in that. So yes, the first one, as you'd be well aware, was what started as an inquiry on the 13th of June 2024 into the previous week's decision by the Commission about the robo-debt referrals, and that then morphed into an investigation which ultimately produced its report on the 30th of October 2024 and you know the outcome of that.
Yeah, which was a finding that the Commissioner had failed to adequately deal with actual or perceived conflicts of interest, and that's come at great cost to the taxpayer, hasn't it, that finding?
Well, I think...
Well, not the finding, but the conduct that led to the finding.
Well, but you've canvassed that view with the Commissioner present at the Parliamentary Joint Committee of the NAC, and I think he and Deputy Commissioner Kilgour were clearly of the view that had we investigated at that point, we would have ended up bringing in significant external legal support.
How much have we paid so far, as the public, have taxpayers paid so far to Jeffrey Nettle, because he's had to be brought in to deal with, to clean up the mess that was left when Commissioner Brereton failed to deal with his conflict of interest on the referral?
The recommendation of the inspector's report was that the matter be reconsidered. We undertook that. And
how much does it cost?
And, well, that's a separate issue to the cost of then the investigation that he is assisting with. And so he...
No, Mr Reid, you were required to bring in somebody who had no connection with the Commissioner and hadn't been in any of those meetings where he'd been in, despite having had a conflict of interest that he hadn't dealt with. You were required to bring in this case, a former High Court judge at significant expense because of the findings of the inspector. And do you not agree with that?
Sorry,
well,
before you answer,
what we
Mr.
ended
Reid,
up...
I'll just interrupt for a second and just remind senators that it is appropriate that we allow witnesses to answer questions that have been asked. And there's been a couple of times where Mr. Reid's been interrupted now, and I just want to make sure that we're getting back to listening to the responses from witnesses at the table. Thank you. Mr. Reid.
Thank you. So, as at the 1st of December 2025, Mr. Nettle has been paid $998,250 inclusive of GST, and that's against a contracted amount of $1.138 million.
And Mr. Nettle's contract last time, if I remember correctly, was I think to February of this year?
The end of February.
Yes. Will the contract conclude at the end of February? Are there negotiations to extend it?
At this point, yes, it will conclude at the end of February, and that's what's on Oz tender. The contract amount is there. So,
the NAC Commissioner received correspondence from the Attorney General on the 10th of October.
That's correct.
Where the Attorney General stated to Commissioner Brereton, amongst other things, your recent declarations of interest and your earlier declarations of interest provided to the former Attorney General on the 11th of August 2023 do not provide details of the nature and extent of the activities you are undertaking at the request of the IGADF. Did you see that correspondence on or about the 10th of October? Were you given it by the Commissioner?
Yes, I saw it on the 10th of October when it arrived, and the Commissioner provided it to myself and to the statutory office holders on that day.
And were you part of drafting the 9-page response that came from Commissioner Brereton to the Attorney General?
The 10th of October was my final day before going on just over 3 weeks of annual leave out of Australia. So I wasn't. I was aware of the letter. I was aware that a draft would be put together and there would be consultation within there. Had I been in the office, I would have been part of that. I've now seen and I'm aware of the response as it was drafted.
So who was fulfilling your duties while you were on leave?
So there was an acting Chief Executive Officer, but I'm quite happy to take questions about the issue.
Who was the acting Chief Executive Officer while you were on leave?
It was my colleague Pete Ratcliffe over here.
All right. Well, was Mr Ratcliffe in the role as acting CEO? Mr Ratcliffe, were you consulted and part of providing the response, the 9-page response from Commissioner Brereton back to the Attorney General?
Thank you, Senator. Peter Ratcliffe, General Manager, Operational Capabilities. Yeah, I was acting in the role from Monday the 13th of October through to the 7th of November. I wasn't originally aware that the letter had come in because in my normal position I wouldn't be made aware of such.
And sorry, what is your normal position, Mr. Ratcliffe?
Operational capabilities. So I deal with our intelligence collection, our use of covert powers, and provide basically assistance and capability to our operational.
Your current tag says General Manager. Has that been a change?
No, so I'm General Manager of Operational Capabilities.
Okay. Right.
Yeah, so I was acting for that period. I hadn't been made aware that there'd been a letter from the attorney because in my normal role I wouldn't have seen that. I first became aware that there'd been a letter on Monday the 20th of October when a member of the legal team asked me if I would like to see the draft that was ongoing. I was then aware that the draft was occurring, but because I was in an acting position and hadn't had any of the sort of history of how this had come about, I didn't contribute to the drafting,
right.
but I did see it.
Yeah, but so Mr. Reid didn't give you a briefing? I mean, it was and I'll probably ask this to Mr. Reid, high profile, I would have thought, high front of your mind. The Attorney General's asking a whole series of pointed questions about what the Attorney General sees as perceived failures to answer conflicts of interest. Just 3 days before you go on leave, and you don't give your acting CEO even a brief about it? You don't say, this is pretty hot, you better deal with this while I'm away?
Senator, my final day was Friday the 10th. The letter arrived, I think, towards in the afternoon of that day.
Oh.
There was a lot of things that I was trying to finalise before I left. It'd been the first time I'd gone on leave for 2 years, and so there was a lot of things that needed to be finalised. And so,
A letter from the attorney?
The letter is to the Commissioner. The other statutory office holders were aware that it existed. The legal branch, who are actively involved in these areas, were involved in assisting in developing a response. I don't see any difficulty, Senator, about not having done any major handover to my colleague here, because these things, in my experience, are dealt with generally within that group of the Commissioner, myself, and legal. So,
Well, you say the Commissioner yourself, but while you're on leave, Mr. Ratcliffe was meant to be filling your role as CEO. And I would have thought, maybe I'm wrong, an important role in dealing with issues of integrity and transparency, and an important role in responding to a query that's come from the Attorney General.
Yeah.
But you didn't even tell him about it.
Senator, look, I've given you my answer. I'm quite comfortable with what occurred in terms of my approach to this on my final day before going on leave, knowing that in the discussions with the other statutory office holders, it was quite clear that the Commissioner was going to be primarily involved in the drafting of the letter. So I don't really see what the issue is here, Senator.
Well, one of the issues might be if you'd read the Attorney's letter, because the Attorney was deeply troubled, amongst other things, about conflicts of interest not being informed to the CEO, the Chief Executive Officer. The failure to ensure the Chief Executive Officer was in the loop on conflicts of interest. And then the very day you get the letter, you don't even tell the incoming acting CEO. Like, it was actually in the Attorney's own letter. How do you explain that? Or is it just no respect for what the Attorney's raising?
I've answered the question, Senator. I don't think I've got to explain anything more about it. I'm not really sure that you're going to progress this by trying to somehow suggest that I've done something inappropriate. I haven't.
Well, the Attorney wanted confirmation of steps by the Commissioner about how the CEO is kept informed about conflicts of interest. And while you're away, the acting CEO didn't even know about the attorney's letter and the attorney's concerns, and you don't see a problem with that?
No, I don't.
Okay, all right. The attorney was also concerned, perhaps I'll just read on the concern from the attorney to the Commissioner. In your declaration, you note that if a matter comes before the Commission affecting the interests of any individual or entity with which you have an affiliation, you will consider if an actual or perceived conflict arises and, if necessary, take steps to mitigate it. I would suggest it would be preferable for you to declare all relevant affiliations and interactions to the CEO. If an actual conflict of interest arises, it should always be mitigated through non-participation in decision-making. Have you now implemented that process, where if an actual conflict of interest arises, it will always be mitigated through non-participation? Is that part of your rules?
That is exactly what we've explained to you previously in other Senate appearances, which is that as a result of the Robodebt report by the inspector, in November 2024, the terms of reference for the National Anti-Corruption Commission Senior Assessment Panel were changed to ensure that there was no question about the need to declare conflicts of interest or perceived or potential conflicts of interest for the consideration of referrals that had come in. That's extended to, or has always been in place for people doing the referrals. It's also been in place for people that are investigating the referrals. So that actually exists already and has since late November 2024 as a result of the recommendations coming out of the inspector's report.
Well, you see, the Attorney-General is suggesting it would be, to quote the attorney, preferable for you to declare all relevant affiliations and interactions to the CEO. And in the Commissioner's response, the Commissioner cavils with whether or not the CEO's role extends to matters relating to assessment and investigation of corruption referrals. So that's not the role of the CEO. Is that your view?
Well,
you don't have that role?
It's quite clear, if you'd read the legislation, Senator, that my role has no direct decision-making surrounding operational decisions. And that means that I, as the Commissioner has pointed out in his letter, attend as an observer all of the meetings where decisions are made, because if I don't know what is being decided, then it's hard for me to ensure the resourcing is appropriate, that we are dealing with matters in a way which, you know, picks up on some of those earlier questions about where delays might be in the assessment process. It's very, very clear in the Act what the role of the CEO is and what the functions of the Commissioner are. And the Commissioner cannot delegate to me any of his operational powers, functions. They're delegated to Deputy Commissioners and General Managers and others in the organisation. He can direct me to do things, but he's never done that.
So is that I think the letter says the CEO is aware of the contents of declarations.
That's right.
And will be provided a copy of updated declarations going forward. Is that in writing anywhere? In the
we've always been provided with declarations of interest.
Is that contained in written policy, this obligation on the Commissioner to declare those matters to the CEO? Is that anywhere in the written policy of the
Well, the terms of reference for the NSAP, as we call it, are clear that any potential conflict, any actual perceived conflicts are put on the table, and if it happened to be about the Commissioner, it would be a Deputy Commissioner making a decision. If it was about a Deputy Commissioner, the Commissioner would make the decision. That's very clear in writing. This, what's referred to here is what's occurred from day one in the Commission, which is that the declarations of interest of the Commissioner, Deputy Commissioners and myself as statutory office holders are shared with that group before they're then provided to the Attorney-General. So that is very clear. There's no doubt that that is the case.
Is it in writing in the procedures and policies of the NAC that the Commissioner has to provide you with all declarations of conflicts of interest and with all declarations about relevant affiliations? Is that in writing in the policy of the NAC anyway?
No, it's not. But the practice is to do exactly what you've said.
All right. When a commissioner or a deputy commissioner is undertaking an investigation, they are often in receipt of highly confidential information, which is protected by statutory secrecy. Do you agree with that, Mr. Reid?
Well, the confidentiality provisions are quite clear in the Act about who's authorised to disclose things and who is what is referred to as entrusted persons. And so we're all very clear in our minds of confidentiality around the work we do.
Yeah, and if you've got a confidential investigation on foot, you can't just have a quiet chat in a social setting with somebody you know who you think might have something to do with it. You can't just have a quiet social chat with them and ask them about it.
I'm not sure where this is leading, Senator.
Well, you can't disclose confidential information other than in formal actions of the NAC, right? It has to be for the purpose of the NAC and in circumstances where it'll be protected by the confidentiality provisions of the NAC. Do you agree?
I suppose I'm struggling to get an understanding of where you're heading.
You don't have to be worried about where I'm heading. You just have to answer the questions, Mr. Reid.
So
I can restate the question, but maybe you could answer.
In terms of the way that the Act is structured, it's very clear that there are strong confidentiality provisions. There's strong provisions if somebody doesn't abide by those provisions in the Act. There's penalties that can ensue as a result of that. And so everybody in the organisation is aware of that legislative framework and what that actually means on a day-to-day basis.
And when you say everybody, I assume you're also including the Commissioner in that?
Yes.
So did the Commissioner at any point before November of last year, 6th of November last year, meet with a member of the AFP who was also in the Army Reserves and disclose confidential information to them?
I think I know the issue that you're talking about, and I'm not in a position to discuss a matter that's been referred to us that is under active consideration. So I think at this point I'll just say that we're in the middle of operational work, and as a result of that, we're not going to talk about any operational matters.
This is a matter that was referred to the NAC, but then the NAC, after it appears some input from Commissioner Brereton, referred it back to the agency. So on my understanding, it's not before the NAC, it was referred back to the agency. Yeah. Did the Commissioner, in a social setting involving the Army Reserves, disclose confidential information about a NAC referral to a member of the AFP and a fellow member of the Army Reserves about a live NAC investigation that was then referred back to the agency? Did that happen?
So all I'm going to say is that you're talking about a matter that was referred to us that is still under our consideration. I'm not going to go into any great detail about it, and I think what you're asking about is something that I'm just not going to be in a position to talk about because it will impact on our prejudice our operational work that we're doing, and I think it would be highly improper for me to go any further.
Well, my question is, did the Commissioner, not in a formal hearing, not subject to a notice, but in an engagement involving the Army Reserves, not a NAC engagement, an engagement involving the Army Reserves, disclose confidential information, including the names of somebody whose name should not be disclosed, to a member of the AFP who was also a member of the Army Reserves, and do it not in a NAC hearing, not subject to a notice? Did the Commissioner do that?
I've answered that question. It would be improper for me to provide any other details about a matter that is still under active consideration by the Commission.
Well, this is a matter, on my understanding, where following that, for whatever reasons I can't tell, the NAC referred it back to the agency to investigate.
Look,
was that unofficial meeting that disclosed that engagement with the AFP officer and Army Reserve officer, was that material in making the decision to refer it back to the agency?
Senator, you don't know the details of this. I know that you've obviously been given a particular version by someone, but that is not an accurate...
Tell me how I'm wrong.
No, it's just not accurate, and it would be improper for me to consider this, speak about this matter at this point in time.
Are you aware about concerns having been raised with that communication?
I've just made my statement there that clearly you've been given material that could relate to this matter that we're considering at the moment. I'm not going to comment any further.
How many current defence referrals are before the NAC?
So there's, sorry, let me just get to, so we've got the 9 matters that the Commissioner had recused himself from. And we've got 8 other matters that have been allocated subsequent to that recusal on the 31st of October to the deputies for them to deal with. Mm-hmm. And somewhere here, I had a figure. I'm just trying to find it here in terms of where this sits in the overarching numbers of matters that have...
to be clear, that's an impartial set you've given me. 9 where the NAC Commissioner, because of affiliations with units or people he directly served with, recused himself. Right. 8 since then involving defence, which I assume is all of the referrals involving defence since the 31st of October, but it doesn't include however many the Commissioner had been sitting on and taking part in prior to the 31st of October.
Well, he wasn't sitting on matters.
Taking part in.
So there's 8 that were matters that he would have participated in because he didn't have a conflict of interest at the time, that have been transferred to the Deputy Commissioners for them to manage.
So 8 where he had a role in them, but as a result of the decision of the 31st of October, it's been transferred over. His role has been transferred to Deputy Commissioners. Is that right?
Well, at any one point in time, the Commissioner or Deputy Commissioners can preside over the matters. There's no issue with that. So now, rather than it being the Commissioner, because he's recused himself, it's a Deputy Commissioner.
Yes. So
and that's a fairly straightforward process.
So there were 8 matters that he had as at the 31st of October, which involved defence, that have been transferred over to Deputy Commissioners.
Yes.
Is that right?
That's correct.
And have you had legal advice on whether or not his actions up to that point, which may can be validly relied upon, even though there are concerns about conflicts of interest.
Well, what you've got to understand, Senator, is the Deputy Commissioners participate in discussions around virtually or all investigations that we're undertaking, and not all of these matters are investigations. Some of these matters have been decisions made by the NAC Senior Assessment Panel to still within the assessment process for them to be considered using the preliminary investigation powers. And so that at that point, it's work that is done predominantly by our investigators and brought back to that entity called the National, the NSAP. And as a result of that, everybody will be aware of what was asked of that assessment and the outcome of that assessment, and the decision maker about the outcome of that assessment will no longer be the Commissioner.
Okay.
It's a Deputy Commissioner.
So were there 8 matters where the Commissioner was on track to be the decision maker for defence matters that he's now stepped away from, and an alternate Deputy Commissioner is now the decision maker? That's happened since the 31st of October. Is that right?
That's right.
Okay. And I asked you before, how many defence referrals are there with the NAC? And I'm not really interested as to whether or not the Commissioner had a role in them or didn't have a role in them, bounced back to the Deputy Commissioner and bounced back to this. Just how many?
I found the question on notice, which was you asked on the 1st of December, this question. We've responded in the lead up to this committee hearing. And the difference of the answer to what I've just said to you was that at that point in time, 1st of December, he'd only recused himself from 7 referrals relating to defence. It's now 8. And he put that on the record at the PJC NAC as part of his... No, just let me finish. Then between the 1st of July 2023 and the 1st of December 2025, there's been a total of 710 referrals that have progressed to and have been subject to a decision at what we call Tier 2. So that's the NSAP process, involving a decision or noting at Commissioner, Deputy Commissioner level. Of the 16, now 17 defence-related referrals the Commissioner has recused himself from represent 2.25% of all referrals from 1 July 2023 to 1 December 2025, which have progressed to the Commissioner or Deputy Commissioners for noting or decision under current processes. The number of open defence-related referrals that have not yet reached a Commissioner or Deputy Commissioner level is approximately 62, so that means that they're still in the assessment phase. And the comparative number of open non-defence related referrals is approximately 775, and of these only a proportion, historically about 18%, are and in the current process is likely to be less than that, will require a decision at the Commissioner, Deputy Commissioner level. So a very small percent of referrals that have come up through the organisation to the primary body that makes decisions about whether to pursue a matter or not, 2.25% relate to
Ms. Reid, I'm not asking for comparisons, I'm not asking for percentages, I'm asking how many defence referrals has the NAC received?
I've told you.
Well, you've said 700 and you said 62 are open. You said something about Tier 2 referrals means 775. You must have somewhere just the total number of defence referrals that have been received by the NAC up to today.
Well, there's 62 that are still under consideration.
But I'm not interested.
And therefore...
He wants the aggregate.
Just the total.
Yeah.
How many?
But I'll just take that on notice, Senator.
All right. Well, that's what I asked earlier.
Yep.
And I keep getting comparisons and percentages.
Well, it's
How many
because
are
we've
there?
answered this question on notice to you with that information, and it's quite clear in my mind, quite clear that we've
you're going to tell me about
the information.
So how many defence referrals have there been in total, in aggregate, as Senator Scarr helpfully added?
Yep.
How many of the total matters that have gone to the NSAP have involved defence to date as well?
Okay,
All
take
right.
that on notice.
Thank you. We got there. Thanks.
Thank you, Senator Shoebridge. That concludes the questions we have for the National Anti-Corruption Commission this evening. Thank you very much for your time. We were due to go to the Inspector now, but given it's 5 minutes before dinner time, we might go to dinner.
Very short, though.
They're very short?
Very short.
Okay.
We can beat the other committees.
All right. If we feel like we can ask their questions of the Inspector reasonably briefly.
We certainly, I think ours will be very brief.
Okay, we invite the Inspector to the table. We'll take a very, very brief suspension while we welcome officials. Resume and welcome the Office of the Inspector of the National Anti-Corruption Commission. Ms Finesse, would you like to make an opening statement?
The only matter I wanted to deal with was a matter that was raised with Mr Reid, and I think with Ms Ma answered. I received a letter this afternoon from the Commission indicating that they propose to take the approach of not answering questions in relation to my investigation, and I acknowledged and noted that. I certainly agree with the Senator that it's not my role whatsoever to tell the NAC what they should and shouldn't do in relation to this committee.
Thank you for that opening statement. We'll go straight to questions. Senator Blythe.
Thank you, and I promise
everyone's hungry
to keep it brief. Thank you very much for appearing. As part of your ongoing investigation into Mr Brereton's involvement in defence-related matters and procurement decisions, how do you assess the concerns raised in the Attorney-General's letter as reported by the ABC?
Well, the terms of my investigation, two matters. The first is the involvement of the Commissioner in referrals made about the Department of Defence, the Australian Defence Force, IGADF, as well as ministers and other government departments where the Commissioner had some knowledge from his prior or current involvement with defence. And the second matter is the ongoing engagement of the Commissioner with the IGADF, including any disclosures made about that involvement. So that probably encompasses the general matters raised in the letter. However, I note that I've only received that correspondence very recently as a result of an FOI application.
Thank you. And I guess just going on to that, how do you think, in your view, the failure of Mr Brereton to disclose impact on the NACC's work and the public perception of this?
All I can say is that from the complaints I have received about the evidence and facts disclosed in documents that have been made public, there has been expressed to me a reduction in confidence of the Commissioner in dealing with defence-related matters because of his not disclosing it to the CEO.
Fantastic. Thank you.
Thank you for your efficiency. Senator Shoebridge, let's hope you can do the same.
Thanks, Chair, and thanks, Inspector, for your attendance and your work. Can you give what your expected timeframe is for dealing with the maladministration and officer misconduct investigation you've commenced in relation to the NAC and the Commissioner?
I've received a deal of information. The most recent was this week. The process now is to review it. The chances of there being material that I still need is quite high, and then I'll have to request that, and there will be a time frame within which that is provided. And then, as indicated earlier, there is a procedure under the legislation, and in any event, I would follow procedural fairness and provide the Commission with a draft report, receive any comments, submissions or extra material they wanted me to consider, and then finalise my report and provide it to the NAC as I have to under the Act, and then form a view as to whether it's in the public interest that I publish all or part of that report.
Yes. So not tomorrow?
Not tomorrow.
No.
Not next week.
No, but probably we would be expecting a matter of months rather than weeks, I assume, to go through that process. Would that be a fair?
Yes, that's correct.
You obviously requested significant amounts of information from the NAC. When did you commence asking for those documents?
In about May, I asked for a very small amount of documents arising from a complaint I'd received. And then after the end of September, when the ABC asked questions of the Commissioner and NAC, I sought further documents in relation to the IGADF. And then as further information emerged, particularly in relation to the disclosure of the ongoing IGADF role, I sought further information.
All right. Now, would your requests have encompassed the correspondence to and from the Attorney General, raising concerns about conflicts of interest, and the Commissioner's response in October of last year?
Well, on a strict reading of my correspondence, no. However, my interest in the topic was well known.
But that correspondence you became aware of not through proactive disclosure from the NAC, but through an FOI, is that right?
That's right.
Do you now have a copy of both of those? Have you now received a copy of both of those pieces of correspondence from the AG and from the Commissioner?
A person provided them to me, I think last week or perhaps shortly before last week. So I have both of the letters from them.
But to be clear, they didn't come from the NAC, despite your multiple requests for information about conflicts of interest and the like.
That's right, but I repeat what I said. Strictly, it wasn't encompassed, but more generally, my interest was well known. Since then, I have contacted the NAC and expressed disappointment that they hadn't provided it to me, and then they subsequently provided it to me.
And did they have an explanation for why they didn't provide it to you?
Oh, I think that's probably a matter for them to explain why.
You're probably right, Inspector. Can I ask you again about adequacy of resources for dealing with this? It appears that this is quite a significant task.
It is.
Have you got adequate resources to deal with it?
I do.
And you've got the adequate budget to call in additional assistance as needed to deal with this?
I do.
All right. Thanks, Inspector.
Thank you.
Can I ask just one follow-up question on that?
If it's very brief in its asking.
Very, very brief, and I've noted your carefully crafted, if I can call it that way, statement in relation to the provision of the letter. Strictly speaking, it didn't strictly fall within the ambit of your request, but more generally your interest was well known in relation to the subject matter. Can I just ask you for the record, was it your reasonable expectation in all the circumstances, given your interest in the generally your interest in the matter was well known, was it your reasonable expectation that it would have been given to you, notwithstanding the fact that it was strictly not within the specific ambit of your request?
Senator, if I can repeat what I said to Senator Shoebridge, and I hope it satisfactorily answers your question, I was disappointed not to have received it from the NAC.
Okay, thank you.
Thank you for your efficiency, Senator Scarr. That's all the questions that we have for you this evening. Thank you very much for your time. We will now suspend for 45 minutes for the dinner break. We will return at 6:50 p.m. with the Office of the Australian Information Commissioner.